you to our keynote for today, who's going to be interviewed by Professor Don. I have already introduced Professor Don a couple times, but I'll do it again because no, he doesn't want to. So, I mean, you already know him very well, right? You probably had a conversation with him already. So I'm going to head and introduce Valentina. Valentina is our keynote from today, and Valentina is the head of the Subnational Be Ready. She's going to talk about the indicator, but what I can say is that I am very acquainted with the indicator because it's the project I've been working on at the World Bank, and it's just amazing. You guys are gonna know a lot about it from Valentina's side. So Valentina Saltani is the manager of the Subnational Be Ready unit at the World Bank. Prior to that, Saltani was a senior private sector development specialist at the SIG, which is the division of the World Bank for economic indicators, where she worked for the Business Ready project in a supervisory role. Over the past 10 years, Saltani has managed several projects at both the World Bank and the IFC, which is the private division of the World Bank, the International Finance Corporation, including actionable regulatory indicators in the in the European Union, migration and the law, and global indicators at regulatory governance, doing business in agriculture, open government projects, market assessments under AIMM, and Capital Governance Partnership Report, Sweden's Business Climate Report, the Consumer Protection and Financial Literacy Report series, and several research papers in the areas to access to finance, business regulation, and capital markets. So I must say Valentina is one very experienced speaker to speak about economic indicators, I bet. Welcome, Valentina, and thank you again to take part in this symposium.
Thank you, Sophia. Pleasure to be here.
I'll leave you guys.
Thank you, Sophia, and good morning, Valentina. Nice to see you. Nice to be here with you. I'm very excited about the project that the World Bank has undertaken here, in part because I was quite familiar with the prior project, which was the doing business indicators that were quite relevant to at least the countries where I dealt with, because they were quite aware of their status on the indicators. Could you tell us a little bit about maybe what the doing business indicators were, and what this, because I understand that that was largely discontinued around 2022 as you're transitioning to this Be Ready mechanism, and could you tell us about sort of what that is?
Right, absolutely. So doing business was a very impactful, very good product that really provided actionable indicators to countries to act on to improve the business climate. But after the demise of the doing business, what happened, that created like a big data vacuum in the world. And it was believed that World Bank is still very well positioned to collect important data on private sector development for all the countries in the world. So with that, after 2 years of deliberation, the new brand was born, Business Ready, which is a revamped, stronger version of the Doing Business report. There are a couple of novelties in the Business Ready that Doing Business lacked on. So for instance, the scope of the Business Ready project is much larger. Rather than covering more narrow elements of private sector development. Right now, Business Ready has topics such as market competition, which includes 3 subcategories: innovation, market competition, and public procurement. Then there is a new topic area on financial services. The trade looks right now at trade in goods, trade in services, digital trade. So the scope of the project is much larger. Business Ready produces 1,200 indicators per country. Also, if we remember Doing Business, the Doing Business was based on those somewhat narrow case studies. So for example, when we look at taxes, we would consider a small company that produces clay flower pots. and all the tax assessment was based on that case study, which was criticized that, well, but this is not representative of the entire country. Now, when we looked at insolvency proceedings, also a particular case study was considered that it was a company that owned a relatively small hotel. And again, judges would tell us this is not representative of the entire insolvency system because there is so much more than a small hotel to reorganize or to liquidate. So with that, the business ready projects shies away from those case studies, and the way the measurements are constructed, they're applicable, first of all, to all types of companies, to small, medium, and large firms, and they cover business regulatory areas as a whole. So now there's criticisms that the case studies are limited or the scope is limited, they no longer apply. Another big novelty of the Business Ready brand is that Business Ready uses enterprise surveys data. And enterprise surveys data is collected also by the World Bank, by our sister unit, Enterprise Analysis. And now with the expansion of the Business Ready product, enterprise survey data will be collected in every country that is included in the Business Ready report in a period of every 3 years. So here I can just give you a short highlight from Brazil. The latest enterprise survey data for Brazil was collected by the World Bank in 2009, so quite a while back. And back then, very common question that's asked to all companies, it's tell us about the most severe obstacles for you to do business in the economy. And back in 2009, those were taxation, so tax processes and tax compliance. Then it was lack of skilled labor force and lack of skilled labor to fill in positions that companies needed to fill in. Then also the prevalence of informality and the competition from the informal sector, as well as access to finance. So we'll see what the next round of enterprise surveys data collection will tell us. Currently, the World Bank is collecting enterprise surveys data in Brazil for this year because Brazil will be included in the Global Business Ready report in the fall of this year.
Thank you for that presentation. For the audience here, let me sort of give you an indication of what they used to do, and then you've heard how it's been broadened. They had 10 or 11 indicators in the doing business, right? And this was sort of ease of doing business. And the first one was, how easy was it to register a company to start? And it then led, because what the World Bank would do is do their studies and they would rank countries. And they had a worldwide ranking with 1 through, I think it was 176 or something. I forget.
189.
189, okay. And then they would do it regionally as well, so that you would have South America or Latin America, and you would see that, I don't know, Mexico was #1. And there were people in the Brazilian government that might not like that and think that they should be #1. And it led governments to commit, in some ways, resources and personnel to figure out how they could upgrade, right, to raise their rankings, because maybe people in the world, business people and others, pay attention to this. There were other indicators. One indicator was enforcing contracts. You know, does the country enforce contracts? And how might you look at that? Well, you enforce contracts, I suppose, by litigation, but also by arbitration. And actually, one way that countries then could improve their scores was to ratify the New York Convention on Recognition and Enforcement of International Arbitration. And you saw many, many countries sort of sign on to that convention as a result. And now there are 170 signatories. Very, very impressive. Now, you know, there's a big difference between signing on to something and really enforcing it, right? So sometimes passing legislation is very easy to do, but you know, having your systems really, you know, sort of embrace the new change, having all the professionals and others be educated in it can be quite challenging. Now, we've talked about national laws. You're also involved with the subnational group. Could you explain sort of what that is and how that differs?
No, thank you for this background, and thank you for the opportunity to talk about specifically subnational business ready. Because sometimes, when countries develop and their economies grow, when you look at the regional level of development, you see that it's often very uneven, especially in countries like Brazil, India, Nigeria, even the United States. So while some states advance quite rapidly economically, and those are commonly the ones surrounding main business cities or coastal areas, many other states fall behind. So with subnational studies, what we do, we measure the effectiveness of the business climate in the case of Brazil, at the state level, so at the regional level. And the purpose for that, first, to go by the mantra, what gets measured gets done, to highlight regulatory obstacles and bottlenecks that exist for the private sector, and then to provide data and tools, particularly primary data, for policymakers to act upon and to improve the business climate at the local level. With our work, we also strive to ignite the healthy competition among different regions and states, so that there is this will to converge with the best practices that already exist within the country. So here I have an example of the latest subnational study that we did in Brazil in the date is of 2020, and the report came out in 2021. And there are some interesting findings that I'll share with you later about Brazil. In that assessment, we covered 26 states plus the federal district across 5 different areas, because with subnational studies, what we do, we take business ready methodology right now, and we apply it to the regional level. We look at the topics that make sense to cover at the state level rather than at the national level, and those topics are usually the ones that lead most variability. In the case of Brazil, we looked at business and corporation processes, construction permits, property registration, taxation, and contract enforcement.
Well, I must say that I'm looking at this book and it's quite impressive. I'm old-fashioned. When I see a thick book, I know that it must be filled with good data. It's interesting to observe what the World Bank, it started as an infrastructure financing bank. And the World Bank itself has gone through many, many phases. And one of the things is a knowledge bank. And so these sorts of studies that are done, and I was in a presentation last week with climate financing sets of issues. There are many, many areas within the bank that are focused on important areas that address multiple sort of economies, but is no longer sort of your classic World Bank infrastructure. It's one of the things to maybe we're here in the United States right now. We have a U.S. government that is looking at its international organizations. And one of the I think views of the current U.S. government is that many of the international organizations have engaged in what we call mission creep, meaning they started with a mission and then they started doing lots of other things. And is that proper to do, right? And what would, and how might that be changed if it should be changed? But that is an ongoing engagement and process as well. Tell us about sort of the maybe in greater detail what you'd found and maybe what you will do next in terms of Brazil and subnational.
Thank you. I'm happy to share with you a couple of highlights from the report that was published in 21. So first, indeed, in Brazil, it's one of the countries where the state differences in terms of business climate are very vast. So one of the the report uncovered a lot of bottlenecks that are still faced by the private sector. So there is a long way to go to align Brazil with OECD economies, for example. In the area of business and corporation, it still takes on average about 11 steps, so 11 interactions that entrepreneurs need to engage in with third parties or government entities to get company incorporated. There was this very good reform back in 2000, around 2010, to introduce the system REDESIM that would connect electronically different entities to facilitate the company registration process. But for this to happen, good coordination has to take place among different entities. So state commercial registries have to use the same software as federal, state, and municipal tax authorities. But although in some states, such as Bahia, Pará, Paraná, and Santa Catarina, that was somewhat well done, in other states, that integration did not take place. Another finding was that transparency of information available to entrepreneurs is not equal across all states. In many states, it's very difficult, for instance, to obtain information on municipal taxes. And if you don't have this information in public domain, it's very difficult for companies to plan ahead and to know what their expenses are going to be. Then, speaking of topics that are more relevant to this audience today, the contract enforcement. So according to National Justice Council data, if we compare the efficiency of courts in Brazil back to 2008, the court efficiency improved by about 33%. However, our findings show that the backlog of cases at first instance courts is still very much onerous. And it takes a long time for judges to render judgment. For example, in the state of Sergipe, it takes 538 days to resolve a commercial dispute, which is actually good timing, because if you compare it to Espírito Santo, there it takes 1,516 days on average, so longer than in any India's state. And then it's also important to note that in the past, all courts, as you well know, introduced alternative mediation mechanism. But those mechanisms are not widely used. According to the 2019 data, the uptake of alternative dispute resolution was only at around 12%. And in some states, such as Rio Grande do Norte or Espírito Santo, the alternative dispute resolution is not used at all. So all cases still go to courts, which adds even further to the court backlog. And lastly, just to share with you that when we compare Brazil to other countries, we compared Brazil's performance to OECD average, to average for BRICS, and to the average for Latin America and the Caribbean. And the Brazil's indicators are much worse than those averages. For instance, the average time to obtain a building permit can be as long as almost a year. And the number, again, of steps entrepreneurs need to undertake to get a building permit is 26 in Maranhão, compared to the average in OECD of 6 steps. So there is, and also to register property, it takes a long time. And it also requires 15 different interactions across different agencies to get a simple property transfer. And from property, I can cite a specific example. So this is a perfect case where information should be shared among different regulatory entities, but it's not. So for property transactions to be effective, the property registry and the municipality, they need to be connected. They need to share information, particularly on cadastral data and the legal ownership. But a unified document does not exist where all this information is available in one place. So what happens? Buyers and sellers need to go to different entities, consult different places to obtain all the information to buy or sell a simple, house or a simple commercial building. So this is the situation for Brazil. Some good reforms have taken place, but much more needs to be done to improve the business climate at the subnational level.
So, Valentina, what is the next step in terms of updating your 2019 information and coming out with the new report?
Thank you. So what we see that subnational studies are most impactful when they are repeated after 3 to 5 years, because here we have a baseline. We signaled what's wrong. We clearly communicated to the government on national level and on state level where reforms are needed. All this information that we published is in public domain, so all of you can access it at any time. The business community can access it at any time. So right now we are aiming to do a repeat study for Brazil. Here I would like to give you a couple of important pieces of information. So 3 pieces of information for Brazil. First of all, Brazil will be included in the global Business Ready report that covers all economies worldwide. And that report will come out in October of this year or late September of this year. Then there will be fresh enterprise surveys data available for Brazil also in this year and before the publication of the global report. And we are hoping to do another round of subnational studies in Brazil in the upcoming year. And there we are partnering up with our regular donors. We are donor-funded projects, so we need to have funding from the country to be able to implement the work. Currently, we are talking to the entities such as SEBRAE, CNSE, FEBRABAN, and CNI. And our government partner is the Ministry of Development, MDIC, because for us to be successful, we want the government to really believe in our study, in what we do, and then to be active users of our data and active promoters of reform. So that's why it's very important for us to have this kind of partnership with the government entity in the country. So a long list of things to do, a very ambitious agenda for Brazil because it's a vast country to cover. And we hope that we'll be able to cover all 27 locations again. And it's always a pleasure to work in a country with, with sunshine, beautiful scenery, and lovely people. So thank you.
That's great. I've got many more questions, but we are going to be short on time. But I would like to see if the audience has any questions that they would like to ask, because your presentation is very interesting. And clearly, there's a lot that is relevant to this whole issue of doing business in Brazil. Yes.
Valentina, I need a mic, right?
Yes, you need to speak into the mic. Yeah.
Valentina, thank you for the presentation. Very, very interesting. So I have, actually a comment and a question. So the comment is, I sensed from when I started working in the 90s that this improved a lot in Brazil, right? And I know that it still takes time, but nowadays you can incorporate a company at least in São Paulo within days. Right, and most of the systems are integrated and etc. So I wanted to have your perspective on the amount of progress that we made. And the question is, how can we from the business and legal community in Brazil help you in your studies and in your work? Because I think this is really, really important to foster business transactions and investments in Brazil.
Thank you. So the first question, absolutely. And the report acknowledges a lot of good efforts that have taken place, but we also being realistic. So for example, the company incorporation in Sao Paulo, Minas Gerais, Paraná, and Roraima, the processes are running very well. So that was the finding of the report. And in the report for each topic, we provide the scores for states and cities within those states for each topic where the processes are easier or more difficult. So that comparison is available in the report, and all the data is present on the website. And then thank you very much for the question in terms of how you could engage, how you could help. In our work under the Business Ready framework, whether it's subnational or global, we work very closely with local experts. We actually pay them to fill out the questionnaires. What we do, we need expert input, an expert opinion. In the case of subnational, we do a lot of meetings with the lawyers to understand insolvency processes, to understand how contract enforcement works, to understand what reforms have taken place and what reforms have been fruitful or not. So all that is collected through in-person interviews, in-person follow-ups, but initially through the sets of questionnaires. So the legal community can help us first by becoming contributors to the project by producing the data. by doing focus groups with us, by attending the workshops. So we are very transparent when we operate in the countries. So whenever we are in the process of data collection or present the results, we usually invite our contributors, our experts, our counterparts to attend the events, and also to put the pressure on the government to reform more. Right, so we're happy to be in touch. You can contact us through the organizers, and once this project takes off, we'll be more than happy to be in touch. We'll need a lot of experts. To give you a statistic, to get this report done, we conducted more than 1,500 expert interviews and collected more than 1,500 questionnaires across the topics. So thank you. Excellent, recruited, done.
And he will be a great expert. So any other questions? Oh, okay. We've got many questions. You've excited the audience early in the morning.
Thank you, Valentina, for your explanation. It was very interesting to learn more about the reports. My question is about digital public infrastructure, whether it is considered or it will be considered, and if so, how it affects Brazil. In the recent past, we've seen Brazil improve a lot in that. We made it easier to make payments through PIX. E-notariado, I see as a big development, that people don't have to go to the notary. They can have a video conference and get a document notarized. So is this going to affect the report or not, and how?
No, thank you. This is a great question. And one of the findings that I should have mentioned in this report, because we were completing the report during the pandemic. So what really came through is that those states that had advanced digital processes, they did very well compared to those that did not. Specifically on the legal topic, I can share with you that in the area of contract enforcement, we do acknowledge that many courts are introducing electronic case management systems. However, what we also find that, first of all, not all courts use those systems, or not all courts use those systems effectively. So very often there is a digital platform put in place, but there is also parallel paperwork still happening. Whenever you need to retrieve a document or make changes to the document, very often it's not enough. Like, to submit filing online, yes, you can do, but any modifications, any changes, then it still has to be done in paper. So moving away from that paper trail and making the processes fully automated, or if you look at company and corporation processes, through REDASIM, hopefully it will be all automated throughout all the states. That would make the life for entrepreneurs and for the governments much easier. Plus, when you use digital services, there's better transparency, there's better accountability. So it's a win-win situation. And if you compare Brazil to OECD economies, you see that in OECD economies, even a process of obtaining a building permit is very often highly automated. But then again, coming back to what was discussed before, there has to be integration across different agencies, there has to be introductions of single windows, and there has to be political will to make those changes.
I am going to actually call this to a conclusion.
Professor, can I make a
Okay.
final question? Would you mind?
Well, Sophia, I will make an exception for you, but only for one reason, and that's because you will be in charge of the timing for the rest of the day, okay?
Okay, fair enough, fair enough. So Valentina, thanks for being here again. I find it amazing. That's why I'm working at the project too. But I wanted to know about Subnational specifically. You talked about competition and how it business ready Subnational enhances competition, healthy competition amongst the states. And I wanted you to give some examples maybe of what you've seen in other countries like Indonesia or other countries that you did this, so that as in Brazil, we can have a glance of what's coming next, right? Because competition, healthy competition is very important, especially among states in terms of investment influx. And I just wanted you to give a brief comment on that, please.
Thank you. Very good question. So we promote competition through different ways. Because first of all, it's not right, I think, when we do this type of work to assume that people don't want to reform. Maybe some don't, but they're in minority. I think in most cases, there is genuine will to improve the business climate and to make the country better and to make the states better. So with our work, when we engage with the governors, with mayors' offices, one-on-one, first of all, we tell them about best practices that already exist in other states. And we publish this data, we present it at the workshops, and it's very gratifying for me to see. I was recently in Bucharest and in Budapest presenting our work that we do in the European Union, and you have different mayors around the room. And you do a presentation and you say, well, in this state or in this region, they use these systems and they work really well. While with these areas, these systems are not fully integrated yet. And then after the presentation, you see the mayor of one region comes and talks to the mayor of the other region saying, hey, I heard the congratulations on your good reforms. How did you do that? And sometimes it's an issue of resources. The mayors would say, well, that region always gets all the funding and we don't. So how do you expect us to improve the efficiency if we cannot buy the new software? So, but that also is brought up to the national level, and it can also be addressed. But what our project helps is to give visibility to different states, to their level of development. And hopefully that propels reforms, that propels ask for resources. Just recently, we got good news from Romania that based on our study in the area of construction permitting, there were new reforms put forward for a proposal in a draft at the local level to digitalize, back to your question, the process and to make more efficient the process of obtaining building permits. So kind of this is how we ignite this momentum and inspire countries to reform. Thank you.
Well, Valentina, thank you for that presentation. It's an immense project that the bank is engaged in. They clearly have highly qualified people involved with this. Thank you for your remarks here. And will you join me in thanking Valentina for her preparation?
Thank you.
We will now go to the next panel. And this is the panel that will be dealing with, let me just find my schedule. This is the forum shopping, frivolous litigation, and the business environment. Thank you so much. Thank you. Hablo español, pero no español. But I will translate to you. Oh, yes, I will bring you.
Yes, it's six. Six. I believe it's perfect. O professor está aí para a gente começar, não? Ok. So let's begin. You can all take your seats, please. Vamos começar o nosso sexto painel, que trata de Forum Shopping, Frivolous Litigation in the Business Environment. E para compor a nossa sessão, já estão sentados. Temos aqui o nosso ministro do Superior Tribunal de Justiça, Benedito Gonçalves, graduado em Direito na Federal do Paraná, no Federal do Rio de Janeiro. Acabei puxando aqui para minha sardinha, né? Mestre em Direito pela Unesa e doutor honoris causa pela Universidade Federal do Rio de Janeiro, que foi recentemente concedido e que será objeto de uma cerimônia da outorga. E meus parabéns, ministro, pelo devido reconhecimento. Ingressou na magistratura em 1998 e é autor e coautor de diversas obras jurídicas, compôs o Tribunal Superior Eleitoral no biênio 2021-23, tendo sido corregedor-geral nas eleições gerais brasileiras de 2022. Atualmente, exerce a direção-geral da Escola Nacional de Formação e Aperfeiçoamento de Magistrados, a Infam. Temos aqui também o nosso Murilo de Aragão, co-organizador do evento, presidente do Instituto Brasileiro de Direito Legislativo, que é advogado, jornalista, cientista político e palestrante, uma pessoa conhecida aqui de todos, fundador e CEO da Arco Advice Pesquisas, a maior empresa de análise política do Brasil, também sócio fundador do MDA Law. Ele formou-se em Direito pelo Centro Universitário de Brasília, é mestre em Ciência Política e doutor em Sociologia pela Universidade de Brasília, além de pós-doutor também em Salamanca. É fundador e presidente do IBDL, professor adjunto de Colômbia, colunista do site Migalhas e das revistas Veja e Conjuntura Econômica da FGV. Temos aqui também o nosso querido professor Fred Didier, que é o diretor-geral da Faculdade Baiana de Direito, eminente processualista, professor titular da Universidade Federal da Bahia, graduado e mestre pela mesma instituição e doutor pela PUC de São Paulo, com pós-doutorado em Lisboa e livre docente pela USP. É advogado, sócio do escritório DJ, Sodré e Rosa Advocacia e Consultoria. Bem, outra pessoa muito conhecida pela sua produção intelectual, inúmeros artigos e livros publicados. Temos aqui também o Thiago Asfor Rocha Lima, que é sócio de César Asfor Rocha Advogados, advogado, sócio, pós-doutor, visiting scholar na Columbia Law School, doutor em Direito Processual pela USP, mestre e bacharel pela Universidade Federal do Ceará. Participou da Comissão de Juristas do Senado, responsável pela elaboração do anteprojeto e novo Código Comercial. Atuou como juiz eleitoral do TRE do Ceará, na categoria de jurista, entre 2017 e 2019. Foi presidente do Centro de Estudos das Sociedades de Advogados do Ceará e é professor de cursos de pós-graduação em disciplinas relacionadas ao direito processual e empresarial. E, por fim, o ex-aluno aqui de Georgetown, o Rodrigo Ricardo Vilar do Vela, que é sócio e fundador e administrador do Vela Pugliese Bose Guidoni Advogados e líder global de Private Equity e Venture Capital do Dentons e membro de seus conselhos global e consultivo. É bacharel em Direito pela Mackenzie, especialista em Direito Tributário pela PUC de São Paulo e mestre LLM pela Georgetown University, onde integra o Latin American Alumni Advisory Board. Ele foi bolsista da Fundação Estudar e participou do Programa de Desenvolvimento de Dirigentes da Fundação Dom Cabral. Com mais de 28 anos de experiência, atuou em escritórios internacionais e é referência em M&A, Private Equity, infraestrutura e operações multijurisdicionais. Boas-vindas novamente aos presentes. Esse tópico é um tópico que é muito quente, costuma gerar bons debates, é muito atual, e eu naturalmente vou passar a palavra já aos nossos palestrantes, mas antes disso eu gostaria só de fazer uma especial referência, porque hoje nós, em 13 de maio, nós temos a data da abolição da escravatura ou da escravidão no Brasil. E temos aqui conosco, compondo esse painel, o único ministro negro dos tribunais superiores brasileiros. E essa trajetória exemplar que honra o Brasil, o Poder Judiciário, e o ministro Benedito Gonçalves ocupa com distinção essa posição e conquistou com mérito, é importante, ressalto isso, e com muito equilíbrio, com essa simpatia, descrição que lhe é muito, muito peculiar, e que também, trazendo outro exemplo e evocando Luiz Gama, que é advogado autodidata, abolicionista, que, mesmo vendido como escravo aos 10 anos, libertou mais de 500 pessoas usando as ferramentas do direito. Então, que esse 13 de maio seja um marco de reconhecimento do passado, mas principalmente importância de termos hoje homens públicos como Vossa Excelência, né? Então, receba, ministro, nosso profundo de todos aqui respeito e admiração, e a palavra é sua para falar. Obrigado.
Dá licença. É bom ter amigos por isso também. É uma maravilha.
Bom dia. Nessa manhã de debate desse fórum de Washington, e agradecendo primeiro eu compor essa seleta bancada de doutrinadores, de vários profissionais do direito, e também agradecer o convite feito e pela excelência do evento ao IBDL, na pessoa do professor Murilo Aragão, o Centro de Negócios Transnacionais e Direito, CTBL, o centro acadêmico pertencente à Faculdade de Direito desta universidade. Ao mesmo tempo, agradeço e parabenizo, porque ontem, por causa do trabalho, eu ainda consegui pegar 2 painéis, e se eu pudesse, ficaria até o final, porque os debates são muito interessantes. Agradeço agora o nosso moderador em comemorar essa data saudar a data de 13 de maio para o Brasil. Todos nós sabemos que foi a abolição da escravidão, a escravatura. Tem até um texto nosso lá que nós fizemos hoje, em homenagem, na Escola Nacional de Formação de Magistrados do Brasil, está no site, né? E vamos ao nosso tema. Nós temos aqui uma conversa sobre os efeitos, o Fórum Shopping, que é o painel 5, litigância frívola e ambiente de negócios. De trás para frente, desde há muito estamos ouvindo falar o termo segurança jurídica. Ontem ouvi aqui, vim lá do Congresso em Madrid dos advogados, o tema que estava segurança jurídica. Então, o Fórum Shop e litigância frívola vem num ambiente em que se discute para o ambiente de negócio o quê? Segurança jurídica. Segurança jurídica, nós precisamos ver, repetindo o que nós já ouvimos aqui, segurança nos contratos, é isso que o ambiente de negócio precisa. Saber que a coisa julgada, a sua imutabilidade vai ser respeitada. Nós temos o nosso Código de Processo Civil que, de norma cogente, obrigando todos os juízes de qualquer instância a obedecer os precedentes para a segurança jurídica. Nós temos 2 precedentes no Brasil qualificados. Um no Supremo Tribunal Federal, que basta ter o tema relevante, que é a repercussão geral. Nós temos o outro precedente qualificado no STJ, que é o Tribunal pela Competência Constitucional, é o intérprete último da aplicação da lei federal, que se chama recursos repetitivos. Os recursos repetitivos diferem da repercussão geral, porque na repercussão geral não precisa-se ter multiplicidade de recursos. Já no repetitivo, já precisamos da multiplicidade de recursos no mesmo tema. Para quê? Unificar. Quando foi criado o STJ, o recurso especial veio na ideia de unificar a última palavra da interpretação e aplicação da lei federal. Dentro do STJ tem um embargos até hoje, que é o embargo de divergência, para unificar a jurisprudência quando 2 turmas vinculadas à mesma sessão, por exemplo, direito público íntegro, para unificar o entendimento. Diante do nosso Código de Processo Civil, que vem a norma cogente repetindo obediência à jurisprudência, temos esse precedente qualificado, que é repetitivo, que é maior do que a decisão do ERESP. Tudo isso nesse contexto que vamos conversar, eu, de modo geral, eu estou sabendo que os expositores vão tratar de modo específico, até ouvir, até nos contratos, o Fórum Shopping e a litigância frívola. Então, permita iniciar com uma advertência feita por Mauro Capelletti, jurista italiano conhecido, que contribuiu para o nosso pensamento processual moderno. Aspas, o acesso à justiça não se resume à abertura das portas do judiciário, mas à construção de um sistema que propicie resultados justos e eficientes. Fecho aspas. Ou seja, quando práticas abusivas distorcem esse acesso, a própria legitimidade do sistema é colocada em xeque. Abra um parêntese. Imagina, estamos trabalhando para unificar a jurisprudência, dar segurança jurídica na jurisprudência, precedente qualificado. Como é que, no nosso caso STJ, buscamos ver a multiplicidade de temas discutidos para unificar, se nós temos uma multiplicidade de temas na forma de fórum shopping ou litigância frívola? Assim, desde logo, é importante sublinhar que o judiciário moderno não pode ser apenas célere, precisa ser íntegro, previsível e integrativo. Aí cito aqui o Cândido Dinamarco. Aspas, a função jurisdicional exige equilíbrio entre o acesso à justiça e a contenção dos abusos decorrentes do mau uso da atividade processual, fecho aspas. O Fórum Shopping, na sua fase abusiva, rompe com a ideia de imparcialidade que nós sabemos e com o princípio juiz natural tão nos caro, em que nós temos juiz em que é sorteado, é distribuído, não sabemos quem é, para saber, o Estado tem o interesse e dever de resolver a demanda, mas ser equidistante das partes interessadas. Busca-se integralmente o foro tido como mais favorável no Fórum Shopping, ainda que desprovido de conexão legítima com a demanda. Essa conduta compromete a isonomia entre as partes e fragiliza a coerência do nosso sistema judicial. Acresça-se a isso a litigância frívola, aquela que se vale do processo não como instrumento de composição de conflitos, mas como forma de coação, marketing e mais, que vejo muito, a protelação. Nós hoje temos sistema, por exemplo, virtual de julgamento, em que é um instrumento que agiliza a prestação jurisdicional, porque o acesso à justiça é livre. Nós temos que ter gestão para dar ao jurisdicionado outro direito fundamental, que veio numa emenda 45 de 2004 a 2005. Cada demandado tem direito à solução do seu conflito em tempo razoável. Até hoje, eu não sei o que é o tempo razoável, mas todos nós sabemos aqui, qualquer advogado, qualquer juiz, o que é tempo irrazoável. Já riu ali o Bichara. Ele sabe quando tem uma liminar de um cliente que o dia seguinte vai ser executado, penhorado, mas não chega aquela liminar. Quando chega, já acabou tudo. Vai correr agora para desfazer. Então, essa nosso sistema de virtualidade ajuda, mas toda hora nós temos, infelizmente, algumas protelações, não tirando as legítimas, em que o advogado precisa despachar, ter audiência, para mostrar a distinção daquele caso para o juiz. Essa é muito válida, mas muitas vezes se usa a retirada do processo virtual para protelar. Elogio mais uma vez e dever do juiz e direito do advogado a demonstrar os pontos básicos da demanda para o juiz. E o único modo que ele tem, muitas vezes, não é na defesa oral da tribuna, é na audiência pessoal. Continuo. Em uma brilhante participação no JusPod, podcast jurídico do Bahia Notícias, o jurista aqui presente, Didier, que tanto eu admiro, até falei para ele que eu tenho no gabinete, ele manda todos os livros e eu guardo. Ainda falei para ele, indo tomar um café, está lá em destaque a última coleção dele de processo civil. Alertou para o uso da IA, que tem facilitado a litigância predatória, uma prática abusiva que ameaça sobrecarregar o judiciário e comprometer o nosso sistema de justiça. De certo, a IA tem transformado práticas profissionais em todo o mundo e o direito não ficou de fora. No entanto, apesar de muito se exaltar os ganhos em produtividade e precisão, é preciso conhecer estratégias para que o uso da IA não seja uma ameaça para o bom direito. A litigância predatória, também chamada litigância abusiva, é um fenômeno distinto da litigância de má-fé tradicional. Ainda segundo o nosso professor Didier, a má-fé é um problema antigo e já previsto no CPC. A litigância predatória, por outro lado, é uma litigância volumosa e ilícita, que caracteriza pelo uso estratégico de um grande número de processos com o objetivo de explorar falhas no sistema judicial ou obter ganhos indevidos. Essas distorções afetam diretamente o ambiente de negócios, geram insegurança jurídica, desincentivam investimentos e sobrecarregam a justiça com demandas artificiais. E nesse ponto que o papel institucional do STJ ganha relevo. O STJ, o Superior Tribunal de Justiça, intitulado Tribunal da Cidadania, precisa ser firme na repressão a essas práticas. Mas não basta o enfrentamento jurisprudencial. É imprescindível investir em formação, prevenção e consciência institucional. E nesse contexto destaco especial orgulho o papel da Escola Nacional de Magistrados, que ela veio no texto constitucional também dessa emenda 45, criar uma escola nacional para regular a formação, o aperfeiçoamento. No caso do Brasil, temos duas justiças comuns. Nós temos a Justiça Federal comum, que eu tive a honra de integrar junto com a minha colega ali, amiga Liliane, que hoje está do outro lado do balcão também, nos ensinando, levando seus ensinamentos, e temos a Justiça Estadual, que são os dois ramos da Justiça Comum, e que a Escola Nacional, então, regula, dentre outras funções, a forma, os cursos de ingresso e aperfeiçoamento. E fazendo mais um marketing, então, aqui da minha escola, minha não, da escola do STJ, mantemos ainda o mestrado profissional. Tudo isso, por quê? Para aperfeiçoar os juízes, para enfrentar não só as novas tecnologias, que eu tenho falado muito nos cursos de formação, mas quanto essas práticas predatórias do sistema justiça. E como exerço o cargo de diretor-geral por eleição do tribunal, tenho acompanhado de perto o desenvolvimento de programas voltados à qualificação de magistrados para o enfrentamento da litigância abusiva. Nossos cursos abordam temas como, esse é o curso inicial, que é feito de 480 horas, 40 horas é feita na própria escola e 440 horas feito nas escolas, seja federais e estaduais. Dá mais ou menos 4 meses de curso. Às 40 horas, o juiz já está nomeado e empossado. Vem para Brasília, fica uma semana. E dentro da programação nós falamos sobre o quê? Abuso do direito de ação, prevenção de fraudes estruturadas, jurisdição empresarial e ambiente de negócios. Se do meu tempo eu sou juiz, não, doutora Liliane, não, eu sou do século passado. Sou lá que eu não gosto de mensagem de WhatsApp, não sei nem funcionar direito, tenho que ficar perguntando, como é que implanta aqui o telefone? Falei agora, como é que implanta isso aqui? Eu fico com vergonha e falo assim, bota o telefone aqui, bota seu número aqui e sai de perto. Então, o juiz, lá do meu tempo da lei introdução ao Código Civil, lá que eu acompanhava o Código Civil de 16, falava o quê de 42? O juiz, ao aplicar a lei, deve atentar aos fins sociais que a destinam. Andou mais. Hoje temos uma lei bonita aí, que eu não sei falar o nome, Linde, né? E fala lá muito bem, que é o juiz julgar, agora aumentou. Ele tem que ter, numa interpretação minha, ele tem que estar preocupado com a repercussão social, ambiental, econômica e etc. da sua decisão. Ele decide, não é para hoje, ele tem que ter visão para frente. Então, por isso, esse tema empresarial e negócios vem para o curso de formação dos juízes. Mais do que capacitar tecnicamente, buscamos promover uma cultura judiciária compreendida com a ética, a racionalidade e a eficiência. Kazuo Watanabe já diz, aspas, o juiz não é um mero aplicador de normas, mas um garantidor da boa-fé e da lealdade processual, fecho aspas. E a boa-fé deve ser o norte de todo o sistema processual. Inclusive, uma das frentes em que a nossa Escola Nacional de Magistrado vem atuando é na formação em precedentes judiciais e uniformização de jurisprudência, justamente para impedir que a multiplicação artificial de demandas contradiga entendimentos consolidados. Prática comum em estratégia de litigância abusiva. Além disso, defendemos o estímulo aos meios alternativos de conflitos, solução de conflitos, como a mediação e a arbitragem, muito importante no mundo dos negócios. Enquanto nós, juízes e advogados, lutamos com o prazo razoável do processo, mas o sistema processual, a demanda, o resultado, difere do tempo do negócio. O ambiente de negócio é outro tempo. E nós, juízes, temos que ter esse conhecimento. E o Código, desde 73 e esse 2015, incentiva o quê? A conciliação, a mediação, que é um modo mais rápido de chegarmos a velho conceito de justiça de piano, dar a cada um o que é seu e acrescento, em tempo certo e razoável. Especialmente no campo empresarial, onde a flexibilidade e a celeridade se mostram fundamentais. O processo judicial não deve ser única via, nem sempre a mais adequada. Combater o fórum shopping e a litigância abusiva não é tarefa fácil, nem tarefa de um só poder. Por isso que é importante a continuidade, cada um dos palestrantes já vi que vai especificamente colocar em cada sistema essas práticas abusivas. Repito de novo o caso Watanabe, aspas. A litigiosidade abusiva é um fenômeno que desafia não apenas a técnica processual, mas a ética e a responsabilidade social de todos os operadores do direito, fecho aspas, o todos é meu. Daí a importância de ações coordenadas entre o judiciário, a advocacia, Ministério Público, as instituições de ensino e formação como um todo, seja públicas ou privadas. Mas, acima de tudo, exige coragem institucional para reconhecer o que cada um pode fazer por um judiciário mais justo e, sobretudo, efetivo. Por isso, defendo que o investimento em formação contínua é essencial para garantir decisões mais céleres para os nossos juízes, equilibradas e alinhadas com os objetivos de eficiência judicial e o desenvolvimento econômico. Já terminando, reitero que o acesso à justiça é um direito fundamental, mas não se pode ser confundido com a banalização da jurisdição. Combater o fórum shopping abusivo e a litigância frívola é proteger a justiça, é fortalecer o ambiente de negócios, é assegurar um judiciário confiável, competente e justo. Compromisso que todos nós, operadores do direito, devemos reafirmar a cada dia. Concluo reafirmando minha convicção de que o Brasil só avançará rumo a um ambiente de negócio seguro e competitivo se consolidar um sistema de justiça que puna o abuso e valorize cada vez mais o acesso legítimo e responsável. Sei que esse painel será rico de reflexões e que esse é um passo que não termina, é um passo sem volta. Muito obrigado.
Muito obrigado, ministro, pela excelente reflexão. E, sem maiores delongas, eu passo o microfone, passo a palavra ao professor Fred Didier, para fazer a sua apresentação.
Eu vou pedir licença, então, porque aqui nós temos 1 hora a menos que o Brasil. E eu tenho sessão. Mandaram pegar o microfone para gravar, para ficar gravado, para ficar sabendo que eu estou saindo por isso. Eu tenho sessão de julgamento no Brasil às 14 horas, e processo inadiável. Eu já liguei para o presidente da turma aqui, ministro Cuquina, então eu vou sair para poder preparar a sessão e arrumar um lugar para fazer a sessão. E que não perca o voo, que ainda vou para São Domingos, no evento do STJ e das escolas. Então, peço permissão para sair. Muito obrigado e continue, mas meu espírito vai estar aqui.
Muito obrigado, ministro, pela sua presença no evento.
Professor, boa palestra.
Um abraço, um abraço.
Justice. Thank you.
Ótimo.
Vamos. Opa, olha aí. Olha, eu preciso levar essa foto para ganhar diária, tá?
Agora deixa eu também justificar a minha diária. Se bem que lá não tem mais diária não, viu? Calma. Oi, foi meu professor, imagina. Esse cara foi meu professor. Acho que é a primeira turma.
Tchau, pessoal. Um abraço.
Lá na. O Barbosa.
O Barbosa.
Pois, né?
Posso começar? Posso começar?
Professor Fred Didier, a palavra é sua.
Muito bom dia. Muito obrigado a Murilo, a Sofia, Daniela pelo convite para poder participar desse evento. Eu resolvi focar as minhas palavras, a minha palestra, numa parte mais de definição, de arrumação do tema, para a gente poder conversar sobre o tema. Veja, no Brasil, eu não tenho dúvida de dizer que o tema da litigância abusiva é hoje o principal tema de reflexão dos processualistas brasileiros e do judiciário brasileiro. Sem dúvida, eu não tenho a menor dúvida de dizer isso. E é um tema cheio de imprecisões, Começar pelo fato de que sempre houve problema de litigância abusiva, no sentido de litigância ilícita no judiciário. Sempre se usou desse ou daquele mecanismo para se valer do judiciário de maneira indevida. Isso não é uma novidade. A litigância de má-fé está aí para isso. A litigância de má-fé existe há muito tempo. Desde sempre se punem condutas tidas como condutas indevidas no processo. Mas não é sobre litigância de má-fé que a gente vai falar aqui. Até porque se o evento ou a palestra fosse sobre litigância de má-fé, seguramente ela nem existiria. A gente não ia parar hoje para falar sobre litigância de má-fé, um assunto antigo, um assunto cujo regramento também é antigo e que, venhamos e convenhamos, nunca ajudou muito. Nunca foi muito utilizado, é um tema velho e que os tribunais desprezavam. Também a gente não pode confundir o assunto de que eu vou tratar com a litigância de massa, a litigância repetitiva ou de massa, que é uma outra coisa. A litigância de massa e a litigância repetitiva é um fenômeno social, no Brasil especificamente muito significativo, que decorre de múltiplos fatores, desde fatores regulatórios a fatores econômicos, e não é, por si, um fenômeno ilícito. Não há ilicitude alguma na litigância repetitiva ou na litigância de massa. Então, é preciso separar a litigância de massa como um fenômeno lícito, embora caótico, mas lícito, da litigância de má-fé, que é uma figura antiga, que também não é objeto da nossa reflexão. O que caracteriza um e outro? Na litigância de má-fé, nós punimos comportamentos episódicos, isolados, de determinados sujeitos do processo, e sempre com uma dupla característica. São comportamentos típicos, portanto, há uma lista das condutas consideradas como litigância de má-fé, então há um elenco típico de condutas e punidos sempre da mesma forma. A litigância de má-fé pune condutas típicas com multa e indenização se essas condutas causarem prejuízo. Então, é um modelo de punição e de repressão muito rígido, pouco adaptável, pouco flexível à realidade, porque ele lista um conjunto de comportamentos e já define previamente que esses comportamentos serão punidos com multa e com sanção o dever de indenizar, isso se eles causarem prejuízo. Portanto, é algo sempre episódico, pontual. A litigância de massa, por outro lado, é um fenômeno volumoso, um fenômeno que envolve múltiplos processos, múltiplas causas. A litigância abusiva, essa sobre a qual eu vou falar aqui, ela pega um elemento da litigância de massa, que é o conjunto, que é o volume a enorme quantidade de condutas indevidas. E pega um elemento da litigância de má-fé, que é a ilicitude. A litigância de massa não é ilícita, mas é volumosa. A litigância de má-fé é ilícita, mas não é volumosa. A litigância abusiva pega uma característica de cada uma delas. A litigância abusiva é um fenômeno de ilicitude, portanto, de comportamento que viola o direito, e é um fenômeno de volume massificado. Eu faço uma comparação, uma metáfora aqui, uma metáfora com um gafanhoto. Pegar o gafanhoto como um predador de uma plantação. Se você vir um gafanhoto roendo uma folha, você vai lá e mata aquele gafanhoto. É como se fosse um litigante de má-fé. Agora, se vier uma nuvem de gafanhotos para a sua plantação, não adianta se valer da litigância de má-fé. A nuvem de gafanhotos, você vai ter que resolver de uma outra forma. De uma outra forma, ela vai destruir a plantação, ela não vai destruir uma plantinha, ela vai destruir a plantação. Então, o tratamento de uma nuvem de gafanhotos nunca pode ser o mesmo tratamento de um gafanhoto só. Então, era preciso pensar num modelo, num regime jurídico de combate a um fenômeno que é volumoso e que me permitam o uso de uma palavra, talvez um neologismo, é um fenômeno polimórfico ou polimorfo, no seguinte sentido de polimorfo. É um fenômeno que pode assumir variadas morfologias. A litigância abusiva, ela se apresenta num número impressionante de personagens, de variações. Impressionante, enorme e, eu diria, infinito. É impossível, eu digo isso com muita tranquilidade, é impossível catalogar todas as variações morfológicas de uma litigância abusiva. É impossível. Consequentemente, será impossível imaginar todas as possíveis reações a esse conjunto de comportamentos, conjunto indefinido de comportamentos. Então, aqui surge a seguinte característica muito marcante da litigância abusiva, essa sobre a qual eu estou falando. Ela é de difícil caracterização, porque ela pode se apresentar de variadas maneiras, ela é muito mutante, ela sofre muitas mutações. A criatividade para a litigância abusiva volumosa é enorme. E, por conta disso, a repressão a ela também tem de ser uma repressão com múltiplas armas, com múltiplos remédios. Quer dizer, a farmácia contra esse conjunto de doenças é uma farmácia enorme, variados remédios possíveis. Aqui a gente chega num outro ponto fundamental da compreensão da litigância abusiva. Ela é uma litigância atípica, ou seja, é um conjunto de comportamentos que a gente só pode identificar num rol exemplificativo, e a reação a ela é também uma reação atípica, ou seja, as sanções à litigância abusiva podem ser as mais diversas. Isso é muito importante isso para a conclusão da minha exposição. Um outro ponto muito importante para destacar na litigância abusiva é que ela pode ser tanto visualizada no polo ativo, quanto no polo passivo, como também nas intervenções de terceiro. Ou seja, é possível visualizar a litigância abusiva em comportamentos, por exemplo, orquestrados de intervenção de determinado terceiro em diversos processos. Isso pode ser um comportamento abusivo, nesse sentido de litigância abusiva. Pode haver comportamentos abusivos no polo ativo e pode haver comportamentos abusivos no polo passivo, de modo que a gente não pode restringir a litigância abusiva apenas a demandar ou a contestar. Isso é um erro. A litigância abusiva pode se revelar em qualquer tipo de comportamento processual por qualquer dos sujeitos que se valham do processo. Esse ponto também é um ponto muito importante. E eu acrescento um outro elemento na compreensão da litigância abusiva, que é o elemento estratégico. A litigância abusiva ela não é aleatória. Ela não é aleatória. ela decorre de uma estratégia de litigância. Há uma concertação, há uma orquestração, há uma racionalidade por detrás daquilo. É muito importante isso, porque se não houver essa racionalidade, se não houver essa orquestração, essa concertação, o fenômeno é outro. O fenômeno pode ser resolvido de maneira tradicional. O fenômeno de que a gente se ocupa aqui, ele supõe essa orquestração, que pode ser visualizada, e o pessoal do direito concorrencial já percebeu isso aqui dos Estados Unidos, naquilo que se chama aqui de shame litigation, que foi muito vista por direito concorrencial, que era uma estratégia de predar um concorrente abusivamente, se valendo da propositura de demandas para poder ter ganhos concorrenciais. Mas no Brasil houve um caso de litigância abusiva clássico, sobre o qual o Supremo se manifestou no ano passado, que foi o da Igreja Universal do Reino de Deus contra J.P. Cuenca e contra Elvira Lobato, um escritor e uma jornalista. A Igreja Universal consertou o ajuizamento de mais de 150 processos individuais em juizados especiais do Brasil, em comarcas do interior, para dificultar a defesa, inviabilizar a defesa de um jornalista e de um escritor. O Supremo reconheceu esse comportamento abusivo no ano passado no julgamento de duas ADIs, um julgamento histórico do Supremo, porque ele percebeu essa variedade, essa variação nova de litigância abusiva e deu uma solução atípica para isso. Perceba que o Supremo não mandou condenar por litigância de má-fé, não aplicou a multa. Não, ele disse o seguinte, para resolver esse problema, é preciso reunir esses processos todos no domicílio do réu. E aí criou uma conexão de casos que não está prevista na lei, mas que foi a forma de combater esse tipo de litigância abusiva. Pois bem, um outro ponto muito importante é saber qual é o arsenal normativo que nós temos contra a litigância abusiva, contra esse fenômeno polimórfico de difícil caracterização. A gente tem no CPC, no Código de Processo Civil, dois artigos muito importantes. Um é o artigo 5º, é meio básico porque ele consagra o princípio da boa-fé. O princípio da boa-fé, ele impede qualquer tipo de abuso do direito. Então, a proibição de abuso do direito é uma consequência do princípio da boa-fé, que pode ser extraída, portanto, do artigo 5º. Mas há um outro artigo do CPC que é pouco falado, eu não tenho visto esse dispositivo sendo falado nas palestras, mas ele é muito importante, que é o artigo 142 do Código de Processo, porque o artigo 142 ele diz o seguinte, que o juiz, diante de um processo fraudulento ou simulado, e fraude aqui pode ser compreendido em sentido amplo, processo fraudulento ou processo simulado, o juiz tem o dever, observem bem, o dever, ele pode fazer isso de ofício, de tomar qualquer decisão que impeça os objetivos da fraude ou da simulação. Então, observem isso. O 142, ele consagra essa atipicidade da sanção a que eu me referi aqui. Você lembra que eu disse que era muito importante a gente compreender a litigância abusiva como um fenômeno que se apresenta com variadas feições, com variadas caras, e por conta disso ela tem que ser reprimida de maneira também diversa, também variada. O artigo 142 do Código de Processo, ele deixa claro que o juiz pode tomar, repito, qualquer decisão que sirva para combater o que se quer com a fraude e o que se quer com a simulação. Por isso que o Supremo Tribunal Federal, no caso da Igreja Universal, ele criou uma decisão. Qual foi a solução? Em vez de punir por litigância de má-fé, não. A melhor solução para impedir isso é facilitar a defesa do réu. Portanto, leve os processos todos para o domicílio do réu. Então, você cria uma hipótese nova de conexão. Pois bem, vem o CNJ, em outubro do ano passado, edita a Recomendação 159. Essa Recomendação de 159, a meu ver, uma grande evolução do CNJ em relação ao tema. A Recomendação 159 do CNJ, ela passa a usar o termo litigância abusiva, melhor do que litigância predatória, que comunicava mal. Até então se usava muito litigância predatória, mas comunicava mal, gerava um certo desconforto. O CNJ vai e diz assim, vamos chamar tudo de litigância abusiva. Define litigância abusiva de maneira ampla, tal como eu estou propondo aqui. Deixa claro que ela pode ser no polo ativo e no polo passivo. e faz, a meu ver, a grande contribuição que foi prever nessa recomendação 2 anexos. Observe que coisa interessante, 2 anexos. O anexo A dessa recomendação faz uma lista exemplificativa de condutas tidas como litigância abusiva. É como se fosse um repertório. Vamos criar um repertório do que a gente está vendo aí que é abusivo e vamos começar a preencher esse repertório para avisar as pessoas do que a gente já achou. Perceba, isso é igual a investigação de biólogo e espécie da biodiversidade. Você vai achando e vai catalogando para as pessoas perceberem. O CNJ fez isso no anexo A. E no anexo B, o CNJ traz a lista de possíveis sanções, também exemplificativa, inclusive trazendo a proposta que o Supremo deu, nesse caso da Igreja Universal. Mas é uma lista exemplificativa. E é muito importante esse ponto, muito importante, estou aqui vendo, muito importante esse ponto, porque a gente está vivendo aqui no Brasil o fenômeno da litigância de problemas brasileiros fora do Brasil. E todo mundo sabe com um escritório que foi criado com esse propósito. E se vale de uma série de providências e estratégias para um tipo de litigância evidentemente abusiva, evidentemente volumosa e estratégica. Uma possível reação do judiciário brasileiro a isso pode ser construída a partir dessa dogmática que eu estou propondo aqui. Inclusive com um acréscimo, quem sabe, e que o CNJ possa me ouvir, no anexo A, com outras condutas que estão acontecendo no Brasil, seja em Minas Gerais, seja em Alagoas, e no anexo B, com possíveis reações a isso. Então, é muito importante a gente perceber isso. Eu e Leandro Fernandes, a gente que é um juiz do trabalho da 6ª Região, estamos mergulhados nesse assunto já há alguns anos e publicamos agora, acabamos de publicar um livro sobre litigância abusiva. Eu ia até trazer aqui para mostrar para vocês, só que não deu tempo de o livro ficar pronto, mas já está anunciado. A gente vai receber, eu vou receber a edição física dele só agora, na semana que vem, mas fica aí para quem quiser. Foi uma tentativa de a gente esboçar uma teoria inicial para a gente começar a conversar mais adequadamente sobre esse assunto. Era isso que eu queria falar, meu tempo acabou. Muitíssimo obrigado.
Obrigado, professor Fred, pela aula. Eu estou certo de que essa gravação será muito consultada posteriormente, se disponibilizada no YouTube. Bem, sem maiores delongas, eu convido o Rodrigo Vela para fazer a sua apresentação.
Obrigado, Fábio. So I'll do this in English, and I'll try to do it in English. And well, first of all, I would like to thank the organizers, Sophia, Professor Don. I would like to thank the faculty in the person also of Professor Don, and the leadership of the school in the person of Jessica, Karen, and others that are here. I would like to say that I'm very proud to be here, right? And I'm proud in various levels. I'm proud as a person to be sitting next to such distinguished speakers, to participate in an event where we had ministers of the Supreme Court, justices, public authorities, and such influential people. So as a person, I'm really proud and humbled by that. I'm also proud as an alumni because I did my master's here. It's my alma mater. So I'm really, really proud that Georgetown is able to put this together. And Sophia, you should be proud of organizing this. This is Georgetown at its best, right? When I came here first to Georgetown, I always said that Georgetown is not as well recognized as other international schools in Brazil, and I think that's you know, we deserve much more than that because we are an amazing school. We're in the center of the world. We have such an amazing faculty that we definitely deserve a better place in Brazil. So I'm very happy that you're, you know, showcasing this to Brazil. And I'm also proud as a Brazilian, right? Because I think we saw and we had the opportunity of seeing how Brazil is evolving. I think the level of the speakers, the seriousness, and I think the way they sound integrated and aligned in terms of, you know, designing a future for Brazil. And I think this is something that we all as Brazilians should be proud as well. So just to finalize and to close this, I think this is a really important event. I think we need to try to do this more, grow this, and use this as a trampoline to something much bigger. I will also say that I'm speaking today as an alumni, not as a lawyer, right? And I'm totally out of my league. I'm not a professor. I'm not. I'm definitely not a litigator. I've never been to court in my entire life, and I've been doing this since the 90s. So I'm a contract lawyer, right? So I'll speak from the only perspective that I can, and I hope with this I can tee up the discussions for the experts, right? So basically what I do is I represent investors, right? So private investors. And what do private investors do, right? They buy something at X, hoping to sell for X plus something, a profit, right? And when they do that, so if they're doing that in a foreign country, that is, you know, difficult enough, right? You don't know the country, you don't know the rules, you need guides, you need legal certainty, a lot of the things that we discussed here today. And that represents risk. So I think when we are acting in our different areas, what we're trying to do is to at least reduce the risk for those investors, right? So in my practice, what I do is I help them exactly. I serve as kind of a guide to Brazil. So how to do it with a lowest risk possible, in structuring their investment, in implementing the investment, growing, operating and protecting the investments. And one of the first things that we discuss, right, or that they ask is, okay, so now I'm entering into this contract, and what law will govern the contract, right? And what will be the dispute settlement mechanism that we will choose, right? And surprisingly enough, that's not an easy question to answer, right? And this is one of the things that, the first things that we learn in law school is to say that it depends, right? So in Brazil, we say that a lot. And so I'll just frame this, and I think the professors will be able to, you know, to close, and maybe we can have a discussion on that. And the reason it's not easy is, and I need to read this because I think it's important. It's very basic for the lawyers in the room. That's very basic, but for the Americans, I think it'll be a good framework. So the law that Justice Benedito mentioned, the old introduction to the Civil Code, says in Article 9 that to determine and govern obligations, the law of the country in which they are constituted shall apply, right? So in theory, if we're talking about an obligation that is to be performed in Brazil, I could read this to say that Brazilian law should apply to that transaction, right? So that's the beginning of it. There are several articles. I'm not gonna waste your time in that. But just to give another context, so if we're talking about a property, Article 8 says to determine and regulate the legal nature of property and the relationships concerning it, the law of the country where the property is located shall apply. Again, so if we're talking about a Brazilian property, in theory, we should use Brazilian law, right? And now, so that kind of covers governing law, right? So in theory, if you're talking about a Brazilian contract that will be litigated in Brazilian courts, choosing a different law, it's something that we wouldn't recommend. So now looking at a forum, right, which is the topic of this discussion, so foreign shopping, the Civil Procedure Code says in Article 21, it falls within the jurisdiction of the Brazilian judiciary to process and judge legal claims in which the defendant, regardless of nationality, is domiciled in Brazil. The obligation is to be performed in Brazil. So that's in the law, right? So again, probably it will be difficult to choose a forum that is not Brazil for most of the investments that we're dealing with, right? Same thing. Well, there are several. I'm not going to waste your time here. So basically, if we're talking about the court system, the judiciary, there are limits, and I think that's the main, the main message that I want to convey. There are limits to the parties' ability to choose. There are certain situations that they can, but there are limits to it. However, there is the arbitration possibility, hopefully, and this is a good thing, right? So Brazil does recognize international arbitration, and in the arbitration, in theory, the parties have much more, not in theory, I can say that in Brazil, in an arbitration or in a contract that has arbitration as the dispute settlement mechanism, the parties are able to choose the law and the arbitration seat. So, and I'm finalizing here to make sure that we all have an opportunity to speak, that when we are advising clients and trying to respond to that question, obviously we consider the question very carefully. There are circumstances that we do choose Brazilian law and Brazilian courts, but for foreign investment, especially when the client wants to make sure that there'll be a technical discussion and they want to choose a forum that is different than Brazil or a law that is different than Brazilian, we end up suggesting international arbitration. And that could be also, outside Brazil or in Brazil. We have very, very good arbitration in Brazil as well. So that's, as I said, just teeing up the discussion, and I hope I was able to contribute a bit to the discussion. Thank you.
Muito obrigado, Rodrigo, por trazer essa visão prática de contratualista. Contribuiu muito para o nosso debate e, sem maiores delongas, eu passo para o Thiago Astro Rocha. Já, por favor, Thiago, a gente acabou que já começou um pouquinho mais tarde a nossa sessão e a gente precisa correr um pouquinho com o tempo. Peço perdão por isso.
Hello, good morning to everyone. I ask permission to speak in Portuguese, but first of all, I'd like to congratulate the organizers, Professor Dan Amicis, my friend and colleague that is here, and queria também parabenizar aqui e agradecer ao moderador do painel, o amigo Fábio, né? E dentro do tema do nosso painel, eu fiquei responsável aqui por tratar, e esse é o ponto da discussão, tentarei ser breve, Fábio, que é a questão da cultura da litigiosidade abusiva e o comprometimento do ambiente de negócios, né? Antes também parabenizo aqui o professor Murilo Aragão pela organização do evento, congratular meu amigo Fred Didier, né? Que também participa aqui do painel, temos amizade aí de mais de 20 anos, ontem comentávamos isso, né? E nesse ponto que me foi a minha incumbência, eu queria inicialmente dizer, trazer, rememorar aqui a primeira palestra do dia, que foi feita pela representante do Banco Mundial, né? Falando sobre o relatório do Doing Business, e esse é um tema que eu tenho um grande apreço, tive a oportunidade em 2015, quando compunha a comissão de reforma do Código Comercial, a gente fez uma visita ao Banco Mundial e foi nos apresentados a delegação brasileira, juntamente com alguns deputados, senadores que vieram aqui a Washington, e foi nos apresentados essa temática do relatório do Doing Business, né? E é um relatório que deixa algumas reflexões importantes, faz nos refletir sobre como melhorar o ambiente de negócio no Brasil. O Brasil, infelizmente, no último ranking, né, posicionado aí na posição 124 do ranking, atrás de países como Trinidad e Tobago, Guatemala, 17ª posição dos países, entre os países do Caribe e da América do Sul, né? E isso daí faz a gente realmente pensar e refletir o porquê desse posicionamento, né? E uma parte disso tem a ver realmente com essa, a meu ver, pelo menos, essa cultura da litigiosidade abusiva que hoje enfrentamos, e como a Fred falou aqui, é talvez um dos temas hoje mais palpitantes, não só no judiciário, mas também na doutrina brasileira, né? E essa questão da litigiosidade excessiva, abusiva, inclusive, ela é uma decorrência, né, da própria estrutura do Poder Judiciário, do sistema judicial ao que o Brasil tem hoje, né? No último relatório do CNJ de 2024, Fred, você deve ter acompanhado, verificou-se que o Brasil atualmente tem, professor Deamides, 81 milhões de processos ativos, dos quais 75% em fase de execução. Difícil encontrar, talvez, um país no mundo que tenha essa quantidade de ações judiciais em curso, né? É um país ainda com 18 mil magistrados e, pasmem, todos sabemos disso, é o país que mais possui advogados no mundo, né? Com a população que nós temos de 220, 230 milhões de pessoas, temos o arsenal, e é realmente um arsenal de 1 milhão, quase 1 milhão e 400 mil advogados, né? Para se ter uma ideia, país como a Alemanha, que tem aproximadamente 90 milhões de habitantes, né, ele não passa de 160 mil advogados. A França, com também uma população parecida, de 77 milhões de habitantes, tem aí um universo de 70 mil advogados. E por que eu digo isso? Eu digo isso para explicar que esse ambiente, né, de litigiosidade que enfrentamos em parte, a gente tem que fazer a meia-culpa, em parte decorrente dessa a quantidade de pessoas ligadas ao sistema de justiça, né? O Brasil tem um custo anual de 123 bilhões de reais com o Poder Judiciário, atualmente, né? Valor esse que não engloba ainda aqueles servidores não ligados diretamente ao Poder Judiciário, mas que fazem parte do sistema de justiça, né? Me refiro aqui aos defensores públicos, né? Promotores, integrantes de carreiras que não fazem parte do Poder Executivo. Então, isso realmente é algo que chama atenção, né? Que repercute nessa quantidade enorme, né, de processos em trâmite no nosso judiciário. E isso, como bem colocado aqui pelo professor Fred, ele reflete nessa quantidade de questões, de litígios abusivos, predatórios, e também nas próprias demandas repetitivas, né? Os litígios predatórios, a gente sabe que esses possuem ilicitudes por trás deles e que devem ser combatidas com ferramentas, como o Fred colocou muito bem aqui, eu não vou repetir, com ferramentas não usuais, mas que hoje o CNJ tem se preocupado em utilizá-las, mas também não perdendo de vista que as demandas repetitivas, existem os instrumentos processuais, cada vez mais, especialmente com o Código de 2015, foram aperfeiçoadas e estão sendo incrementadas para poder resolver essas questões da judicialização de massa, né? Então, nós sabemos, por outro lado, que essa quantidade exagerada de processos, ela tem um reflexo também absolutamente absurdo no chamado custo Brasil, né? Isso é uma nomenclatura corrente quando a gente fala sobre investimentos no Brasil, especialmente no setor de infraestrutura, nas concessões e permissões públicas, porque termina que há um reflexo disso para o consumidor, para a população, quando o particular, o privado, precisa computar dentro da sua tarifa o custo decorrente dessas tratativas judiciais, né? Então, no Brasil, mais do que qualquer país do mundo, eu acredito, qualquer questão pode vir a ser judicializada. A gente sabe que existe o princípio do acesso à justiça, mas sabemos também que isso não pode ser, como disse o ministro Benedito, na fala dele, isso não pode ser levado ao exagero, né? Nesse ponto, já me aproximo para a conclusão, já que o painel iniciou com um certo atraso, e bem lembrado aqui pelo nosso moderador, né? Como se podemos fazer para tentar reverter esse ambiente de negócios, né? E eu sempre pontuo aqui pelo menos 3 ou 4 aspectos que entendo que sejam relevantes como medida para tentar melhorar esse ambiente de negócios e permitir o desenvolvimento da infraestrutura, no setor de infraestrutura em geral no Brasil. Primeiro, a atuação das agências reguladoras, né, que isso pode sim contribuir muito com essa questão, desestimular, né, o ajuizamento de novas demandas através de controle adequado do pagamento de custas judiciais, da questão da justiça gratuita, né? Além de priorizar, ou no sentido de valorizar o sistema arbitral, a mediação, né? As formas alternativas de resolução de disputas, combater a litigância irresponsável, que aqui falamos, e também investir, finalmente, em tecnologia e previsibilidade nas situações. Então, eu encerro aqui, peço mais uma vez licença para encerrar, até parafraseando aqui o líder dos direitos civis norte-americano, Martin Luther King, que diz, ele aqui diante do memorial do Lincoln, na escadaria, lá no discurso dele, ele dizia que tinha um sonho. Então, nós também temos um sonho de que o Brasil um dia possa efetivamente, e possamos fazer parte disso, de contribuir para ter um ambiente de negócio mais favorável. Muito obrigado a todos.
Muito obrigado, Tiago. Eu passo agora a palavra ao Murilo de Aragão para que faça a sua apresentação e com a mesma pedido de observância do tempo. Obrigado.
Professor Don, I will send to you my remarks in English after, but I will speak in Portuguese because most of the people here around are Brazilians, and I prefer to be more precise in my remarks. But don't worry, you will receive soon what I will will express here. Bom, esse painel tem 3 temas e um deles não foi muito comentado, eu então vou concentrar mais a minha observação sobre o terceiro tema. Mas todos eles se relacionam com a questão da judicialização excessiva do Brasil. O Brasil é um país que adora litigar, é muito fácil acessar a justiça e todo o arcabouço constitucional legislativo do Brasil permite que se expresse de forma judiciária, né, as demandas, as disputas, e é o paraíso dos advogados. Por isso que nós temos quase 1,5 milhão de bacharéis em direito, e se não fosse o exame da ordem, nós teríamos aí mais e mais advogados. Enfim, então, isso mostra uma situação de um país preparado para a disputa, preparado para a briga e que lucra com isso. E, além do mais, nós temos estrategicamente o fato de que existe uma briga, uma disputa permanente entre a sociedade e o Estado, porque no Brasil a sociedade é menor que o Estado. O Brasil é uma invenção estatal. O Brasil foi criado pela coroa portuguesa e foi sempre administrado com um predomínio do Estado sobre a sociedade. Fazendo uma comparação rasteira com os Estados Unidos se torna uma nação a partir da rebelião das colônias contra o poder colonizador. No Brasil, não, foi tudo uma transação. E todos os momentos dramáticos da história do Brasil foram negociados, foram transacionados. A Revolução de 30, a Proclamação da República, que foi uma quartelada, o golpe militar de 64, a transição democrática, e sempre o Estado prevalecendo sobre a sociedade. E essa prevalência do Estado gerou um arcabouço legislativo, legal, absolutamente caótico, e que se revela, sobretudo, no sistema tributário brasileiro, que é um dos piores sistemas tributários do mundo. Aliás, aqui se falava da reforma tributária, ela existe, ela já vem ocorrendo há muito tempo, mas ela sempre visou aumentar a arrecadação. O contribuinte no Brasil, ele é um cidadão de terceira classe, não de segunda classe, de terceira classe. Não há sequer direitos do contribuinte no Brasil. Isso nunca se colocou na pauta aqui, deputado Zé Neto. Nunca se colocou o direito do contribuinte. Agora, há quase 30 anos atrás, um colega seu, Joaci Góes, foi o relator do Código dos Direitos do Consumidor. Porque aqui dizia meu filho Tiago que no Brasil é mais importante ser consumidor do que ser cidadão. E é muito mais importante ser consumidor do que contribuinte, mas o contribuinte é que paga a conta. Bom, dos 3 temas aqui, a judicialização excessiva, ela se revela junto da litigância abusiva, a litigância predatória, e que virou um grande negócio, e também favorece aos advogados. Mas não há uma cultura de combater a litigância abusiva e a litigância predatória no Brasil. É um tema relativamente novo no Brasil. A recomendação do CNJ ela é muito bem-vinda, mas ela ainda é uma recomendação. Há que se colocar, professor Fred, disposições muito claras de combate à litigância predatória, ao copia e cola de ações. No caso ali de Maceió, se não houvesse uma intervenção a tempo do CNJ, nós teríamos tido milhares de ações sobre a questão de Maceió e que a intervenção do CNJ, à época presidido pelo ministro Dias Toffoli, permitiu que se houvesse ali uma concertação e se organizasse o acordo, que se chegou rapidamente, ao invés de se ter o drama que foi o Acordo de Mariana, que trouxe uma grande incerteza ao mundo dos investimentos no Brasil, que até hoje afeta a imagem no Brasil como destino de investimentos, porque o sem fim do Acordo de Mariana, que ficou em aberto muitos anos, era um péssimo exemplo de como o Brasil trata problemas graves como as grandes tragédias que nós tivemos no país. Agora eu quero falar mais sobre o Fórum Shopping, porque o Fórum Shopping ele traz para mim, na minha formação, a questão da minha visão de analista político e a minha visão de advogado. A questão do Fórum Shopping hoje, como disse o doutor Fred, é tão extraordinária que ela se virou um jogo geopolítico. Existe uma geopolítica por trás do Fórum Shopping. Não é apenas a questão de você escolher uma corte que seja favorável a você para você levar uma vantagem, mas há também um jogo geopolítico para, por exemplo, prejudicar as exportações de um país ou evitar que o trânsito de dinheiro de determinada companhia seja prejudicado. Imagine, por exemplo, se uma empresa brasileira com operações no mundo será condenada na Europa e essa condenação poderá resultar na apreensão de valores que transitam pela Europa, né? E o absurdo de tudo é que esse julgamento ocorre com base na lei brasileira, com a alegação de que o judiciário brasileiro não tem a liberdade ou a eficiência ou autonomia suficiente para julgar o caso. É mais ou menos como se amanhã aquele clássico Real Madrid-Barcelona tivesse uma querela e ela fosse julgada pelo Superior Tribunal de Justiça Desportiva do Brasil, né? Ou quando houve aquela tragédia recente de inundação nas cidades espanholas, quando estávamos lá no nosso evento de Salamanca, se decidisse processar a empresa espanhola de energia elétrica no Brasil. Não, porque a Justiça do Brasil é mais legal, a Justiça do Brasil é mais rápida. Então, isso é um absurdo. E essa situação virou um grande negócio. Existe um financiamento para isso e se aproveita da boa-fé das pessoas, se iludem as pessoas dão procuração para que as litigâncias ocorram fora, como há, por exemplo, dos quilombolas em Londres. Ou seja, por que o quilombola tem que ser defendido em Londres? Como se a justiça do Brasil fosse uma justiça absolutamente destruída. E se toma como exemplo a justiça de Ruanda. E eu me lembro que, em Lisboa, debatendo o tema, um professor inglês defendia o Fórum Shopping e eu flagrei um texto dele dizendo que a lei inglesa só poderia ser aplicada na Inglaterra e não na Alemanha. Aí eu perguntei para ele, o senhor acha que o melhor lugar para se aplicar a lei brasileira é no Brasil? Ele, depende. Falei, bom, essa não é a sua opinião a respeito da lei inglesa, num caso que envolve a Alemanha. Ele ficou sem graça, ele disse, eu escrevi isso? Escreveu, está aqui, eu mostrei. Então, o fato é o seguinte, nós temos que ter a consciência de que isso desmoraliza o judiciário brasileiro. Isso é uma espécie de colonialismo judiciário praticado com o Brasil. E o Brasil, ele ignora olimpicamente. Os diplomatas não tratam desse assunto. Os diplomatas acham, não, isso aí é um problema judicial. Ele tem o direito de acionar a companhia no exterior. Tem, mas tem que ter fundamento, tem que ter base. E o que falta, nesse caso, é uma diplomacia judiciária, né? Não há uma diplomacia judiciária. O Brasil não dialoga diplomaticamente com os demais poderes judiciários do mundo, principalmente aqueles onde transitam os interesses do país. E até mesmo dizer, olha, se não há reciprocidade, não há respeito ao judiciário brasileiro, por que deveremos respeitar o judiciário holandês ou belga ou inglês no Brasil? Será que isso não é caso de se examinar até retaliações ou negociações diplomáticas duras? Porque isso traz uma brutal insegurança jurídica. Então, olha só, o Brasil é um país que o mundo devia agradecer todos os dias o benefício que nós trazemos ao mundo, que é o de não criar problemas para o mundo, porque nós criamos problemas para nós mesmos. Nós gastamos 90% do nosso tempo criando problemas para nós mesmos. Então, o mundo não se preocupa. Lá não somos uma Venezuela chata, né? Israel brigando, Irã, né? Coreia do Norte, todo mundo criando problema, Rússia invadindo os outros. Não, a gente não cria problema, a gente só cria problema para nós mesmos. Mas a gente tem que se proteger e começar a criar problema para os outros também. Porque senão nós vamos ficar sempre numa situação difícil. E fica ridículo para o Brasil, para o sistema judiciário, gigantesco, né, que custa quantos por cento do PIB? 1,5% do PIB? Não, é um dos mais caros do mundo, mas eu não tomo até esse referencial como o Brasil desperdiça dinheiro. Não, não desperdiça. Eu acho que a justiça tem que ser bem paga, tem que ter aparelhamento adequado, funcionar bem, mas ela tem que ter uma visão geopolítica e consequencialista das suas decisões, porque senão amanhã nós vamos ter uma empresa brasileira punida e com os seus bens bloqueados no exterior por conta de uma decisão relacionada a um episódio que ocorreu no Brasil e que foi julgado no Brasil. Ou voltar a ter ações rescisórias em massa, porque o acordo que eu fiz lá sob a égide do CNJ, eu não estou satisfeito, eu quero agora rever o acordo. Ora, nós temos que ter segurança jurídica, e esse é um grande problema que nós não endereçamos adequadamente no Brasil. E a minha visão não é totalmente pessimista, já concluindo, porque eu vejo que a tecnologia, a inteligência artificial vai ajudar muito a lidar com essas questões de litigância, e também, politicamente, acredito que o Brasil vai acordar e despertar para essas questões geopolíticas que envolvem o direito e os processos judiciais contra empresas brasileiras no exterior. Acho que o CNJ vai acordar para esse problema. Eventos como esse vêm trazendo a dinâmica, a problemática, para mostrar que isso é um problema de soberania e que nós temos que lutar contra o colonialismo judicial para fazer valer as nossas regras, as nossas leis perante o mundo e mostrar respeito ao nosso judiciário, que é muito bom. Enfim, então, eu faço uma sugestão final aqui, tendo até o privilégio de ter a presença do deputado Zé Neto aqui, que é a de que o Congresso estabeleça uma comissão permanente de revisão da legislação, visando olhar onde nós temos fragilidades, contradições, porque o Brasil navega num mar proceloso, para usar uma palavra antiga, de legislação. Todo dia tem milhares de atos, portarias, o tempo todo, e nós precisamos simplificar isso. E o Congresso é a casa que deveria pensar e nessa racionalização da lei que existe hoje já. Se nós fizermos isso, já é um grande serviço para a segurança jurídica no Brasil. E a outra é que a própria Comissão de Relações Exteriores do Congresso pense nessa questão do colonialismo judicial, desses ataques que as empresas brasileiras estão sofrendo, e que, além de serem um problema econômico, são também um problema de soberania e um problema de desmoralização ou de descredibilização do judiciário brasileiro. Muito obrigado.
Muito obrigado, Murilo. Acabamos de ter aqui excelente, we just had an amazing session, so exciting, dense, and we could notice how the opinions here were complementary, and so thank you, Professor Don, to host this event. Thank you, Sofia, Murilo, and Danny, all involved. Okay.
We are falling a little behind of the program, so we will do coffee break for 10 minutes and then 15 minutes. Professor Don allowed me extra 5 minutes. So extra 5 minutes on the coffee break, and then we'll summarize with the next panel. Thank you, Fábio.
Ok, de cada um. Beleza. Avisa o Roberto.
Foi legal, o lugar. Pelo vídeo que você mandou foi fora. Antes de todo mundo chegar, para o vídeo foi fora, mas o lugar. Era assim. Eu ia falar bem, o cara fugiu ontem. Ele só ninguém.
Lavagem.
Não, total. Não. Parecia assim, um assessor da família Adams. Caralho! Aí você pedia assim, eu quero. Eu quero isso. Eu não queria. Não, melhor não. E aí eu comecei a brincar. Que loucura. Agora nós ficamos no restaurante. Tem que fazer uma contabilidade. Só no dono do caderno.
Caramba!
Isso era um filme. Um restaurante italiano com chinês. Que isso? Com chinês assim. O amigo da Fernanda tinha um capanga. E ele andava na mesa, ele não estava com isso. Ele era gigante. Ele ia servir, ele fazia assim. Aí servi, e o cara atrás dele, só olhando. E fica estagiário. Mas era mais velho que eu, porque aí a comida era boa, pelo menos. Pô, pelo menos isso, né? Sim, muito servir com indicação. Vai lá que é muito bom. Mas é isso. Também igual no Brasil. Segunda-feira não funciona. Segunda-feira e aí, mais engraçado, claramente ali é um ponto do emprego de algo isso. Aí de vez em quando aí então é lavagem. E aí, ontem encheu o restaurante da máfia. Mas aquele filme mundial da faca de biscoito, o cara. O cara que roubou o banco e. Mas eu falei isso. A gente tá trabalhando. Nossa, deve ser aqui, cara. Essa é boa. A gente tira a salvação do dia. Caramba, aqui. Temos a coragem. Pode trazer. Então, pega tudo aí. Ela fez tudo pra gente ir embora. Vai chegar aos pizzas. Ele botou 5 pizzas em volta da Fernanda. A pizza do Fernando. Ele botou a Fernanda aqui, ó. Só queria te avisar que eu não tinha. Inclusive, parece que é comigo. Eu vou acertar essa bola. Nunca vai ter servido. Porque ele nunca vai ter servido. Tá com cara de delegada. Xerife. Já achou com cara de xerife. Determinado começo vai ser eita! Aquele furgão do lado é fechado, tem 2 caras amarrados, aquele plástico, de sangue, ou é ferida escura. Exatamente.
Os linhos de navegação já reduzindo, já está ótimo. Obrigado. Você está lá com a... Ai, como é que é o nome dela? Esqueci agora.
Não, a gente já tinha chegado aí, o Marcelo. Eu te liguei, ele foi embora.
Acho que essa branca está executiva lá. Janeiro.
Ai, que maravilhoso.
Muito querido, trabalha pra caramba. A gente é do mesmo grupo, assim, né? A VDP, com a professora Laura, né? E aí eu lembro dela trabalhando, fazendo relatório do meu tempo, ela estava trabalhando. É uma corrida, né? Uma querida. Já precisa uma cabeça?
Ô, Fernando, tem coisa maior que ele faz que choque. Esses lugares
Yeah. Oh no, but it's
Como eu vou ter que, né, reduzir os currículos, né?
Não, o meu tu pode rascar.
É, tá bom. Sim.
Ah, não, você tá. Cara, o meu tu pode mexer agora desculpa. Agora do pessoal, não sei. Daniela, ela falou pra ela que pode. Ah, então não. Não, então se ela fez, beleza. Beleza, não. Então... Sim. Não, pô. Não, tá, o meu, se quiser. Fala, Roberto, não tem. Só que eu, cara, sei lá, se você soubesse que tem só tem ESA e tudo, precisa falar essas coisas. Então. Uhum. Vai ser mandado. Então. Não, mas acho que, cara. Não, fica tranquilo que não tem. É, eu falei com ela, acabei de falar. Não.
Se for pra manter um, vai ser.
Exatamente.
And I see we talk about for choosing, right? The transactional lawyers, like, oh my gosh, I wish I was there. You know, this because
Cara, é 1h15 assim começar. Então não sei se a gente consegue acabar meio-dia 45 se começar. Deixa eu falar com ela, se precisar. Eu vou falar com a Sofia. Entendi. Vou falar com a Daniela, ver se.
our activities. As digital platforms transform the way we live, work, and compete, regulators around the world are grappling with how to respond. Are current antitrust laws adequate to rein in self-preference, data monopolies, and the gatekeeping behavior, or is it time to rewrite the rule book? Should global coordination guide this effort, or will each country chart its own path? This panel brings together diverse voices to unpack these urgent questions, with a spotlight on Brazil's regulatory initiatives, such as the Supreme Court review on the Marco Civil da Internet, the proposed fake news legislation, the emerging Brazilian DMA, and the Ministry of Finance's 2024 proposal to modernize Brazil's competition law for the digital platforms age. To speak about this topic, a great team of experts were invited. It's my pleasure to introduce our first speaker, Lilian Sintra. Lilian Sintra holds a PhD and bachelor's degree in law from the University of São Paulo, with international experience as a visiting researcher at Harvard Law School, Institute for Global Law and Policy. She has served as an advisor of Justice Ricardo Lewandowski at Brazilian Supreme Court and at the Ministry of Justice and Public Security. She is currently Secretary for Digital Rights at the Ministry. Now I would like to invite Ana Sofia Signorelli. Sofia is a partner of Buzzi Signorelli Advocacia and consultant at the World Bank's Be Ready initiative. At the IFC, Sofia graduated cum laude in International Relations and Economics at IBMEC and in Law at the Federal University of Rio de Janeiro. She holds a Master of Science degree in Finance from the University of Rio de Janeiro, as well as a postgraduate specialization in Competition and Economic Law at FGV and an LLM in International Business and Economic Law with a concentration in International Arbitration from the Georgetown University.
Well, thank you very much, Jan. No, it's okay. Yeah. Well, good morning, everyone. Thank you very much for the introduction, Jan. And as you know, I'm Roberto, and it's a pleasure to be moderating today's discussion. Well, today we are here to talk about digital platforms. They are pushing the traditional limits of regulation. They are bringing antitrust issues, data governance, and platform accountability are kind of overlapping in this discussion, and governments are trying to tackle this issue in different ways across the world. But luckily, we have 4 outstanding speakers which will guide us through legal, policy, and litigation challenges that this issue brings. So each speaker will have around 10 to 15 minutes to share their insights, and the panel will gonna be held in English. So it's my pleasure to begin with Lilian, who will share a little bit of her perspectives from the Brazilian authority, the Ministry of Justice and Public Safety, and some insights about the federal government's new draft bills aimed at regulating digital markets and service. Lilian, the floor is yours.
Good morning, everyone, distinguished authorities, dear professor. Such an honor to be here. Thank you, Jan and Roberto, for the introduction and the question. First, I want to just thank for the invitation to be here representing the Brazilian Ministry of Justice and Public Security in this discussion that is very, very important and urgent. Also, I want to say a special thanks to Murilo Aragão, Sofia Signorelli, and Professor Don Giamici for organizing this and giving me this opportunity, and also Georgetown Law. I'm very excited to share with you some of the insights we are having right now in the federal government, the Brazilian federal government, because now I think we are navigating in a very complex environment that in a way that we need to foster innovation, make sure we have good governance, and also to protect fundamental rights in the digital environment. So with this in mind, just before answering the question, just want to to make a very, very brief introduction of the framework that we are adopting. Because Today, I think we really need to abandon the idea of internet exceptionalism. It seems that just to explain the idea of internet exceptionalism, it's just like the notion, and it's a prevailing notion, that the internet represents such a radical novelty that it requires an entirely new framework, entirely new principles. And it's just like, you know, in the beginning of the discussion of internet regulation, we even had an independence declaration of cyberspace. And it seems that that idea in a new way is just like coming all like, it's just prevailing in a way that it's not exactly the same, but it's always there. And I really need, I really understand that we have to abandon this internet exceptionalism because it has led to, first, lack of regulation, of course, legal immunity for platforms, and even worse, I think it just like leads to a disconnection between online and offline legal protection. So that creates a legal inconsistency, you know, applying different standards to the same behaviors based solely on whether they occur online or offline. So just to give you an example, considering Brazilian law, we have the protection of consumers, and there is a very strict rule for publicity. But right now we have to rediscuss the whole system of publicity because it seems like online is completely different than offline. And in my opinion, maybe we need some adjustments, but it's just like unfair to put a heavy weight in recreating almost the whole legal system because everything we put on table is seen and or it's just like interpreted as something that will, I don't know, impact in a negative way innovation. So we have to understand that the best way to move forward with innovation is to be sure we are in compliance with the law and that we have safety in first place. And then, so this is like something that I'm always saying. So this is, in my opinion, like this idea of internet exceptionalism was not unintentional. So we need to be like very intentional in the way we undo this idea. And I think we are having a small success, but I'm really happy that we are moving in a different way and that today in Brazil, we have people thinking with us in the federal government that we don't need to recreate entire legal systems so we can solve the problems of the internet. So in my opinion, again, many of the social problems that we see in the internet today, just like to give examples, misinformation, antitrust concerns, privacy violation, child sexual abuse material can be and actually should be addressed through existing legal tools. And I will just give some examples of the tools that we are using right now. So I just said consumer protection. We also have competition law. I know we need some adjustments, but we need to see on a case-by-case basis. Data protection statutes also are very important, and mainly civil liability regimes. So I'm not saying, again, we don't need some adjustments because, of course, we are dealing with some social problems that are new. But what I'm saying is just like legal principles remain very relevant. Our Constitution remains the main text that guides us, and they are all applicable to digital context. And if we need to make some adjustments, that's okay, but we don't need to have like the burden of recreating everything because always innovation is just like put on the table as something that will be violated or I don't know, and negatively impacted. I know Sophia will comment on the Supreme Court ongoing debate on the constitutionality of Article 19 of the Civil Rights Framework for the Internet, which we call in Portuguese Marco Civil da Internet, which shields platforms from liability for user-generated content unless they fail to comply with a judicial removal order. In my opinion, the Brazilian law does not mean that internet service providers may only make content unavailable if there is a court order. This is very different. And the liability regime created in this law also does not take like all the other laws from the table. So we still have civil code, consumer protection code, child and adolescent statute, and many other laws. So when we look or when we interpret this specific rule, we have to look for to the whole system and not only one article to make a decision here and to understand how we should comply with the Brazilian law. And just to give you an example of the discussion, a lot of people says that the Article 19 is based mainly on the protection of freedom of speech, and I agreed, but I can't see a free speech without democracy. So we have to take it all together. There is no place in the world where those two things work apart. So thank you. So just, I think I'm just telling this here because I really believe that Brazil has followed a unique path in digital regulation, not only because we have the civil rights framework for the internet, which was a very important construction with the participation of civil society, but also because if you just look like to recent court decisions, including the Supreme Court, you can understand that we are kind of in the middle path. We are not adopting the US minimalism, or maybe we can call it also internet exceptionalism. And we are also creating a way to navigate the Europe interventionism, which is more intrusive, but in a way that needs a lot of institutional capacity. And we, as a global South country, deal with a lot of issues to put like this kind of systems in place. So I'm not saying that I prefer one or another. It's just like for the Brazilian path, I really think that we are doing our unique way, and maybe we can be an example to the global South and even countries that are struggling to deal with internet problems right now. I just will make a very quick note on the discussion on the Article 19, because Sophia will deep dive into that. It's just like one part of Minister Justice Dias Toffoli's vote talks about an appeal to the legislator. So we can approve a law that will bring more safety to the internet in Brazil. And this is very relevant because we are not only discussing if we should apply this or that interpretation, but we have now, in a way, probably the Supreme Court saying that we need also a law in Brazil. So we at the federal government are now discussing draft bills, not only related to this topic, but also to the main topic of the panel, which is antitrust concerns. So just to make sure and to be clear, we have two bills right now, two draft bills actually, because we are still working on that and it hasn't been submitted to Congress. And our main idea is just like for the digital, we also need to have a strategy. So we are not doing like sparse and diverse laws that in the future we will have a problem to communicate with. So right now we are thinking in it as an ecosystem of law, or I don't know, laws that are together since the beginning. And the first one we are calling it the legal framework for the protection of users of digital services, is a draft proposed by the Ministry of Justice and Public Security. So I'm working a lot on that text right now. And the main idea is just like that we need mechanisms for preventing and repairing damages related to digital services. So the idea here is to look heavily on consumer protection and how we need to adapt that to the Brazilian reality regarding the digital. And why we are doing this? First, because we had like a very important learning process with Bill 2630, which was called Fake News Bill. It was a huge debate. It took more than 4 years in Congress, and it was also being considered one of the most controversial legislative proposals in Congress for the digital, and actually it's very recent, so probably it still impacts the digital policy landscape in Brazil. But here, since I wasn't personally in the process, but we as the government were in the process. So we took that as a learning process and how we could look to the problem and think of new solutions. And right now, what we are doing is the fake news bills was focusing on disinformation, so misinformation on social media and messaging apps, and creating rules for content moderation. So what we do right now, we change the logic, we change how we perceive the problem. So we still have this problem. We also had, like the US had January 6th, we had January 8th. So we still have a problem related to democracy, but we also have a problem that is actually in people's life, such as fraud, such as child abuse, and that we also related to the way those platforms or those digital services work. So if you pose some risk, it's your obligation to mitigate the kind of risks that you offer to your users. So that's the main idea. I would talk more, but I really want to stay on time. So if you have some questions, I will be very happy to address it. And then we also have the second bill, which is the economic regulation for digital markets. This is a bill proposed by the Ministry of Finance. They did a beautiful, very, very competent work. Which won the concurrence. Yes. They won an award. It's a very traditional award in the antitrust community, the Concurrence Award, for this beautiful study. And they had like a large public consultation, and the result of this beautiful job is the bill that we are now discussing, the draft bill that we are now discussing. And the main idea is that we will empower the Brazilian antitrust authority with ex-ante tools. One thing that's really important is that DMA, so the Digital Market Act in Europe, was very inspirational, but we had to adapt it to the Brazilian specificities. And then the proposal has two groups of actions. So first is the power to designate platforms of systemic relevance for digital markets, and then to them specifically design rules to foster competition in those markets. The second group is related to measures that can already be done with existing antitrust tools and with our existing law. So we won't change it, but we will make it more specific to digital markets. So I think here what we are doing is just not only understanding that the myth of internet exceptionalism has to be abandoned, and that we have good laws and how to apply it and not to always go to a legislative process to solve problems, but also to create new laws that really look at the problem. We want to create remedies for specific problems. And this is very, very important. This is kind of a mantra. Every time we discuss a new idea, we go back and we look at the diagnosis we had, how we understand the problem and how we can change it into a solution related to the problem we see in Brazil. And of course, international experience is always welcome, but this was part of the whole process. And why we did that? I think the main concern was just like, we need to build laws that will create an internet that is also created for digital sovereignty. So we really need to make sure that we, as a country, are not only fostering innovation, stimulating scientific and technological development, but also promoting social justice and making like a huge battle against structural inequality. This is the way we see a lot of the internet services in Brazil and spaces in Brazil. So just to conclude, because I know I'm on time, what I just said here and what moved us a lot was that Brazilian digital policy strategy need, again, to reject that exceptionalism. I'm so sorry I'm being repetitive, but it's just like I really need you to be with me in that idea. And we are adopting in Brazil a pragmatic approach. So our idea is we need to extend consumer protection principles to the digital. So that's the reason we have one bill. We also need ex-ante competition tools, but also adapting our existing antitrust law. We need also digital sovereignty so we can stimulate innovation and promote social justice. And we also have like the judicial, like the Supreme Court reevaluating intermediary liability right now, which will also impact a lot the way we see internet in Brazil. So this is just examples of the journey, and just to give you a bit of the process that we are right now discussing in the federal government, and how I really believe Brazil can be an important player in this matter, and how we actually can bring more economic development, more innovation, can bring more safety. We can move forward in issues like this, and also create a collaborative space where we can discuss, we can, I don't know, think about the way Brazil is navigating those problems, and I don't know, even propose ideas that we could go to Congress and talk like in the right space to create a new law. So that was my main idea. That was the main idea I wanted to share with you. I thank you all for your attention and for the opportunity to raise awareness on these issues.
That's great, Lilian. Lilian, thank you very much for sharing this like brilliant overview of Brazil's legislative agenda on this issue. It's great to see that Brazil is not like falling behind this discussion. But now let's change a little bit to the US side. Professor Shelansky, I would like to hear your thoughts on how the US antitrust policy is responding or not to this issue.
Well, thanks very much. It's a real pleasure and honor to be here. And by the way, if I leave before the panel is over, it's not in protest. I just have to speak on another panel at 1:15 by Zoom. So I just have to get back to my desk here at the university. So apologies in advance. So I want to give a little bit of a US perspective. And I think that one of the real contrasts that I'll be able to draw to what Lilian offered, which was just very interesting, and thank you for that, is that our legislative agenda is much smaller. In fact, I wish I could give you a list of bills that were actively being considered, that were addressing all kinds of problems, but it doesn't exist. And yes, I could find efforts by our Congress to draft legislation over recent years, and some bills that may even be pending now. but those are never going to go anywhere, or at least not in the foreseeable future. So perhaps the really interesting feature of US law in comparison with Brazilian law is that we actually have a much more limited palette of laws to bring to bear on digital platforms. And we are largely reliant on existing laws. And so I want to talk a little bit about what we are doing under existing laws under the competition and consumer protection regimes. Now, one note, of course, there are some digital specific laws that our Congress has passed. We've got statutes that deal with online commerce. We've got statutes that deal with protection of children online. We have Section 230, which makes it very clear that, at least under the communications laws, that there is not liability for user-generated content on digital platforms. That's something that's actually being reconsidered right now. But we do not have much in the way of digital platform-specific consumer protection or competition law. So we really differ from Brazil, we differ from Europe, we differ from Australia, we differ from the United Kingdom, from some Asian jurisdictions in the absence of a regulatory regime specifically governing digital platforms. So then how do we address digital platforms? We address them through our existing antitrust laws, through our existing consumer protection laws. And I think one of the very interesting things that we can see over time, and this is an interesting note. I think Lillian made a great point that we need to move past internet exceptionalism. And we've had to do that in the United States because the only tools we have are tools that were not developed for the internet. And so for a long time, you did hear people argue we should not be applying existing legal and regulatory frameworks to this online world because it is so different. But I think our antitrust agencies and our consumer protection agencies have shown that they no longer believe digital platforms to be exceptional. So we have antitrust suits being brought by the Federal Trade Commission against Amazon, against Meta. We have antitrust suits being brought by the Antitrust Division of the Department of Justice. Yes, I think as most of you know, we have two antitrust agencies. Don't ask me to explain right now. But we have the US Department of Justice bringing suits against Google and bringing suits against Apple. So there has been no shyness over the past 6-7 years about bringing our conventional, very old 1890 antitrust statutes into the modern era and bringing monopolization cases against the large digital platforms. This, however, has been a challenge, and I will explain why. There are some things that are a little bit different about digital platforms and how they work economically. As we all know, there can be user-side, demand-side benefits to having one large platform. And so when you have network effects that make people more interested in joining a platform that their friends or that other people are already on, the kinds of remedies that you're talking about to overcome that are a little bit different than sort of the kinds of injunction remedies or possibly even the breakup remedies that have been considered or used in the past. So what are the remedies? Well, we're going to see very soon in the Google search case, because Judge Mehta will issue a decision in August, but there will be access and interoperability remedies, requirements that digital platforms make their APIs open to a wider range of competitors, that they make their information, certain forms of their information. We don't know what at this point. It could be the search index that drives Google's search. It could be data that Google uses to train its algorithms. These things will have to be made available to competitors. Here's the tricky thing. Under US antitrust law, there is a very, very strong presumption against any requirement or remedy that a company deal with its rivals, even a monopolist. And we have a case from 20 years ago, the Trinco case from the US Supreme Court, where the court said we only as a last resort, and maybe not even then, want to require a company to deal with its rivals. Well, now think about the court in the Google search case trying to enable search rivals to compete against Google. What will have to happen is that Google will have to be forced to deal with rivals. And this is going to be something that runs a little bit counter to the precedent and the history of US antitrust law. So without a specialized legislative platform, a specialized set of laws to say, well, okay, with digital platforms, having to deal with your rival is a more acceptable remedy, the court has to find a way to make this very old law with a very long body of precedent fit the very new economic dynamics and remedial demands of digital platforms. So so we have the courage, I think, here to see our agencies bring hard cases under the antitrust laws. How well the courts will be able to apply the existing precedent and those old laws to these new challenges is going to be interesting to see. And I do believe we will see some of these cases go all the way to our Supreme Court and have them interpret the applicability. And perhaps if they say that you cannot impose these remedies, we might see our legislature begin to act. On the consumer protection side, I think we see something a little bit different. And when we talk about things like consumer fraud, misuse of consumer data, privacy, false promises or disclosures about data security, the U.S. Federal Trade Commission, we only have one consumer protection agency, unlike antitrust. That's the Federal Trade Commission under its the consumer protection half of its statute. They've actually been very good and very forward-looking and I think innovative in looking ahead to how companies act towards consumers in terms of the disclosures they make, the accuracy of the information that they provide to those companies, how they use your data. We don't have a federal privacy law in the United States. We do not. But consumer protection law can make companies accountable for misleading consumers about what they're doing with their data. Okay, so even in the absence of a privacy law, we've been able to use the consumer protection laws to force a measure of clarity and openness and disclosure about what privacy policies are. And what that does is it can drive companies to have better privacy policies if they know that the FTC will hold them to account. So we have seen the FTC Act is from 1914. So it is 111 years old. Yet it has managed to move beyond the view of the internet as exceptional and to apply to some of the conduct that we're seeing online. I want to conclude by just making an observation about the challenges that digital platforms pose. 25 years ago, I was the chief economist of the Federal Communications Commission here in the United States, and our biggest question was whether or not we should require the physical infrastructure that connected people to this emerging thing called broadband, if we should make that open, whether there should be interoperability and there should be openness. And the chair of the Federal Communications Commission, Bill Kennard, a very smart man, said, no, we're not going to regulate this emerging internet or this broadband infrastructure. We don't have a monopoly. We don't have a duopoly. We have a noopoly. Let's let the technology develop. Years later, the locus or the location of market power shifted up from the infrastructure to applications. And we had these big digital platforms emerge, Google, Meta, all of these. And suddenly we're not concerned about the infrastructure to get to the applications. We're concerned about applications that have market power because of network effects. I think we're now seeing, we're on the verge of a new evolution of where the regulatory concern is. When you think about artificial intelligence, and the set of tools that can power search, that can power social media, these now become inputs to these platforms. And we are now going to start to have increasing concern about market power at the level of the technologies that underlie and drive these digital platforms. And we're going to have solutions to keep that environment competitive, innovative, and open. And those will be further tests of whether our existing framework without new legislation will be able to exist in the United States. But we're working with very old tools for these new problems and have been, I think, a little slower than the rest of the world to start thinking hard, as Brazil clearly is, about the new kinds of tools that might be needed. Thank you.
Thank you very much, Professor Shelensky, for sharing those thoughtful and high-level issues that revolves around this discussion. But staying the U.S. side, I think, Kyle, we have some cases that some brave warriors trying to to challenge this issue in courts. Could you guide us through a little bit through that?
Thanks very much, Roberto, and to all of you for being here this morning. As an antitrust litigator, the past few years have been a fascinating shift in public perception. It used to be at dinner parties and things, I would tell people I was an antitrust lawyer and their eyes would close and they would fall asleep. But now it is a household word, and I knew eventually that my practice would be cool, and we're finally here. The emergence of digital gatekeepers, or what some people would call big tech companies, has led courts around the world to revamp the old theories that Professor Shelensky was just talking about that have new applicability in our modern world. In the 19th and 20th centuries, it was somewhat more common for a would-be competitor to sue a dominant rival for not giving them fair access to a resource that was necessary for competition, what we called the essential facilities doctrine. And those were literally things like a road that was necessary to transport something or build something. Those cases comparatively declined as vertical integration became more common, as supply chains became more global. There were simply less essential facilities. But today, this theory of harm has been reframed as part of a broader prohibition on anti-competitively refusing to deal, as Professor Shelensky just mentioned in the Trinco case. Big tech companies have selectively refused access to important digital inputs or platforms. For example, one of the levers of harm that the US Department of Justice's antitrust case against Google about the online advertising industry is that Google was self-interestedly using contemporaneous information it had about people who were bidding on online ads. Because Google owned the ad servers, it had better information than the average person who was bidding on that technology, and Google self-preferenced itself by virtue of the platform it built and owned. This is also the basis of the EU's February fine of Google of over $100 million for refusing to allow an Italian app developer called Enel access to its Android Auto platform. So moving up the progression from infrastructure to application, now we're at platforms. And large tech companies who built platforms that are now essential for competition are being told by tribunals around the world that they have to give fair access to the inputs and the platforms themselves so competition and innovation can continue in those areas. And on access to data, and perhaps in fairness to Google in case they're listening, consumer sentiment has certainly shifted. In the early 2000s, we were very trusting of companies like Facebook and Google, perhaps to a fault. But now consumer sentiment has undoubtedly shifted, and data privacy has become a huge international issue. Google just agreed to pay the state of Texas almost $1.4 billion for mishandling biometric data and privacy failures just in that state. We've also seen a raft of antitrust cases relating to self-preferencing in two-sided markets. These are markets like the Apple App Store, which is a market both for consumers who want to download apps and for app developers who want to use that platform to sell. And these two-sided digital markets are going to be an important feature of regulation and competition around the world, including in the United States. This new school of thinking has also brought with it a groundswell in terms of the scope and severity of remedies being sought by both public and private enforcers. For example, the Department of Justice case here in the United States against Google in both search and the advertising space are seeking divestiture of some really important and critical properties that Google owns. In the search case, it's Chrome, the browser, and in the alternative, Android. And in the advertising case, it's AdX. It's Google's online advertising exchange. These are very, at least in the recent past, atypical in terms of the scope of remedies that public enforcers are seeking. And it will be interesting to see how courts fashion those remedies to bring about competition while preserving the network effects we were just talking about. You also see injunctions that tech companies are having trouble complying with. In California, a few weeks ago, a federal judge referred Apple to the U.S. attorney in that area for criminal contempt proceedings because they failed to comply with an injunction. These, again, are very atypical fights about remedies in antitrust cases. Internationally, tribunals are also taking more aggressive steps. The EU issued the first fines for violations of the Digital Markets Act against Apple and Meta. And we've seen in Brazil fines imposed by CADE against banks and the foreign exchange cartel. I think and hope we will continue to see CADE continue to follow this international trend of expanding enforcement in digital markets, including its investigation of potentially anti-competitive acquisitions made by Google, Apple, Amazon, and Facebook going back to the 2010s. I want to conclude with what might be my favorite possible implication of all of this, which is, will we see more private litigation in U.S. courts by foreign plaintiffs who've been harmed by anti-competitive conduct in digital markets? We've already started to see something like that. A class of French app developers filed a case against Apple and federal court in California. Just last week, a civil suit about Apple's noncompliance with the injunction I just referenced was seeking to represent a worldwide class of app developers. In Korean courts several years ago, the Korean local courts ruled that the forum selection clause, for all the transactional lawyers here in the room, that all developers are required to sign, actually prevented those cases from being brought against Apple anywhere other than in Northern California. So, in fact, companies who are customers of these digital gatekeepers may find that they have to bring cases here in the United States. And this trend is consistent with the economic reality that digital markets don't adhere to borders on a map. And those of you who do business in digital markets should not assume that there is no path to redress either under US law in Brazil or here in the United States just because your clients are located abroad. Thanks very much for your time and attention.
Thank you very much, Kyle, for sharing your look on how global litigation is evolving around this issue. And perhaps we're going to see more private plaintiffs taking the lead to keep this discussion evolving. Now, last but not least, let's have our host, Sophia, which will talk about how Brazilian courts are viewing this issue. And we have some spoilers from Lilian about your topic as well. Please go ahead, Sophia.
Thank you. Thank you all. First of all, I want to thank Lilian to have attended the symposium. It's a pleasure to have you here. I had the pleasure to work with you while in the Supreme Court, and I know very much about your competence. So I'm very happy you're at the government now. Professor Shelansky, a brilliant star in Georgetown Law in antitrust. I had the pleasure also to have him as faculty. And Kyle, fantastic lawyer, fantastic dispute resolution lawyer that can address the issue from a pragmatic perspective as he did. So I'm just here to make a few statements because I am between you and the lunchtime, right? But I will try to keep it very, very quick. I did I had the pleasure to have worked at both CADE and the judiciary. And listening to your remarks before, and just a brief note, I spent all my time preparing for everyone's and I didn't have time to prepare for mine. But in Brazil, we have a say that quem sabe faz ao vivo. So I'm improvising here, okay? But the good news is that this is my doctorate thesis. So I've been working on this for 5 years now. If I don't know about this, oh my gosh. So I was just mentioning that it's great to have Lillian here because this symposium was able to put together the judiciary, the executive, and the legislative. And the issue about regulating digital platforms is just about this. We have to have the three powers together and addressing it from different perspectives. And this is actually my team at my portion on this debate, because my PhD thesis was particularly about the role of the judiciary in the discussion in Brazil. Different from the US, and I will show you very quickly here. See, I did make 5 slides, as I said to the speakers. So here in the United States, we would have a judicial enforcement system, according to the OECD, okay? This is the chart that the OECD uses to compare both systems. So here you can see the competition authority having its power mainly on the investigatory side. I know you can litigate at the FTC, however, it's not really the first instance used. In the US, you would go with antitrust cases to the judiciary, but Brazil, as in the European Union, uses a different framework. We use a lot of the administrative enforcement system, which puts on CADE its adjudicatory function on the spotlight. Although CADE also exercises a investigatory function, it has its adjudicatory function, which is mainly in charge of digital cases, which, as Lillian has brought to our attention, this very nice expression about not leaving it aside, right? Not having a exceptionalism to digitalization. CADE has inclusively used this as its main sort of action from the last, I think, 5 years, like being a country where digital platforms could prevail, and this has been used by CADE officials in the past years. However, from a different framework compared to the states, my point is that we cannot just think about ex-ante regulation on the legislative side or in the executive branch, think about CADE as an administrative agency that will deal with it, but we have to take into account that there is a judiciary. And as we saw on the past day, and the program has shown us, the judiciary in Brazil is pretty powerful and is prepared to deal with these discussions. We had a remarkable speech by Justice André Mendonça yesterday that really touched me on the heart. And he would speak about how a judge has to be impartial and how our country is divided into left and right, but still the judiciary has to take its position as an impartial and transparent power branch. And my point is that we can bring antitrust to the judiciary, and this I call antitrust regulatory litigation. We spoke about regulatory litigation yesterday, but my point is that the judiciary, even in a framework where we have the administrative agency taking adjudicatory functions, we can still have the judiciary intervening in a good way. And Marco Civil da Internet, specifically its Article 19, which is now being discussed at the Supreme Court, I think it's now with André Mendonça. He took some time to review the decision, and he's not put his vote still. But Marco Civil da Internet is a good way to see how the judiciary has to taking a very deep approach to the regulation of digital platforms, showing it understands the peculiarities of this market. It understands the market dynamics, which Professor Shalensky was just addressing here. So when you talk about the different judiciary the different functions that the Brazilian judiciary could exercise on antitrust issues tackled at digital platforms, I classify them in three different instances. The first one, it's review function. So as you all know, the Brazilian judiciary has competence to review administrative decisions. And under this review function, of course, the judiciary exercises a lot of power on setting the stage to CADE so that CADE can stick to the law and to what's written on the law. So this important project that Lilian was addressing here, like about the ex ante regulation and how we have to change the Brazilian antitrust law so that it can be more updated to tackle digital platform issues. Of course, it would be great to have it, but my point is this is not enough. We need to foster in Brazil a more participation of the Brazilian judiciary in this discussion. This is not only to be dealt at CADE, we have to include the judiciary in the discussion. And so the second function would be the derivative function. We all know the Brazilian law has a provision about antitrust indemnity suits. And of course, this has not been used as much in Brazil, as Caio knows. We always discuss a lot about this, but this can be a way to make plaintiffs go more often to the judiciary, and this is a way to regulate. If you have class actions, if you have, indemnity decisions that tackle the issue, of course, the players will think twice before taking an antitrust position, an antitrust you know what I meant. So, so this last function I address is the autonomous function. So this is precisely what the judiciary is doing under Article 19 of Marco Civil da Internet, which is we are discussing here the constitutionality of a law enacted in 2014 and going to Marco Civil da Internet, Lilian, as you said, it's on me now. This is a law that was issued in 2014. Of course, it's not an old law, but it's old because digital platforms just evolve so quickly. 1 year is already a lot. And researching about this, I discovered that it's really true because I have to update my thesis every month. It's crazy. So this is precisely where the judiciary is at now. We have a judgment pending, of course, in the Supreme Court about Marco Civil da Internet. And I have heard all the hearings in December because of my thesis. And I really saw a lot of technicality in the discussions, especially from the justices' side. And also, of course, we have a lot of amici curiae bringing important contributions. But although this is not an antitrust lawsuit per se, we have antitrust considerations here because we have discussions about abuse. We have discussions about asymmetric regulation. We have discussions about how this can affect the competition in the market. So why not? If we are seeing the judiciary taking a position in digital platforms based on other laws, why not in the antitrust law? So my point and my contribution to the panel was to show you this. I just wanted to show you very quickly a chart that was publicized at the study Lilian was just mentioning. This is the Brazilian Ministry of Economics doing like an overview of the Brazilian framework in digital platforms. Like they did this study on the market about digital platforms working in Brazil, in the Brazilian market, and they tried, of course it's in Portuguese, I'm sorry, Shalensky, I can bring you a translated version of it, but you got it, right? Okay. Yeah. So basically, what they did at this study, where they suggest higher standards at ex-ante regulation, they did classify the types of platforms that are working in Brazil. And this is very important because this shows a deep comprehension about the market, which is important for both the regulatory side and the judicial decision. I mean, a judge, of course, has to know what it is dealing with, has to know the difference between the online and the offline market, the difference in the dynamics of competition, and why not bring competition to the discussion if we are bringing a bunch of different laws, the civil code, it's right? So this is basically my point. We need to get the Brazilian judiciary involved in the discussion, and this is not a binary discussion. It's not either the judiciary or the legislative branch, or either the judiciary or the executive branch. We need to have everyone on the debate because it's such an important debate and it affects our lives personally. And this was my what I had to address. I'm sorry if I didn't prepare as much as you guys, but we were very busy with the symposium. But thank you again. It's a pleasure to have you all here, and I leave it to the moderator. Thank you, Potter.
Thank you very much, Sophia. Thank you very much for framing the antitrust regulatory litigation issue and to be emphatic about the role that Brazilian courts has in this discussion. So now, after hearing those brilliant insights, I need to ask permission for the bosses for doing a Q&A, a short Q&A, or perhaps, yes, 5 minutes? 5 minutes, okay. Now the room is yours. If someone has a question, please raise your hand. Don't be shy.
Não, eu queria primeiro parabenizar a mesa. Sou deputado federal no Brasil, sou da Bahia e tenho uma atuação assim muito contundente nessa caminhada da reforma tributária. E a gente acabou de aprovar, eu sou vice-presidente de duas frentes importantes, a frente do empreendedorismo e a frente do comércio e serviço. Nessas duas frentes, como vice-presidente das duas, eu colaborei muito nas intermediações com o governo e com o objetivo não de fazer a melhor lei do mundo, que é impossível, no ambiente político que o mundo está vivendo e que o Brasil também está mergulhado de polarizações, mas fazer uma norma possível de darmos passos importantes, como estão sendo dados, principalmente no que tange à simplificação e melhoria do ambiente de negócios. Mas que tem interferência em tudo, na geração de emprego, de renda, no desenvolvimento, na diminuição da pobreza, em tudo a reforma tributária tem envolvimento. Na mesa anterior, a gente falou muito sobre a questão do ambiente de negócios e dos contratos internacionais e do tamanho do que a gente tem de desafio para que a nossa norma, que precisa ser melhor aplicada, para que o ambiente melhore em tudo. Eu te perguntaria, Lilian, hoje, que você falasse um pouco sobre esse movimento que é preciso ser feito no ponto de vista internacional. Porque eu vi o professor Ronald, né? Horace. Ele falou um pouco sobre o que está acontecendo nos Estados Unidos e eu queria que você falasse um pouco sobre o que você tem de intermediação do governo federal com o que está acontecendo no mundo, já que a geopolítica agora, nesse momento, tomou uma dimensão estratosférica dentro do Brasil e dentro de cada nação. Quem não tiver capacidade de se relacionar na geopolítica que o mundo está vivendo agora, não vai conseguir dar outros passos seguros no desenvolvimento. Então, eu queria que você falasse um pouco sobre essa intermediação que está sendo feita, e se está sendo feita, como está sendo feita, do Brasil com essa realidade mundial. E mandar um abraço lá para Lewandowski.
Just ask you to talk in Portuguese so I can address here. So, deputado, muito obrigada pela pergunta. Um prazer poder respondê-lo aqui. Somos quase conterrâneos, estamos ali pertinho, sou pernambucana, então muito bom poder ter essa oportunidade aqui de endereçar o ponto trazido. Acho que uma coisa que tem sido sempre levada à mesa nessa discussão do digital é como que a gente olha para todos esses pontos de um ponto de vista de uma estratégia mesmo mais global de discussão do digital pelo governo federal. Então, a gente tem inúmeras iniciativas, incluindo inteligência artificial, discussão sobre regulação dos serviços digitais, regulação econômica de plataformas digitais, como essas duas que eu trouxe aqui, toda uma frente também de incentivo a data centers no Brasil, que tem sido liderada pelo Ministério da Fazenda. E o que a gente entende, pelo menos o que a gente tem colocado de pé, é que essas frentes todas precisam se comunicar e a gente precisa ter um olhar para o digital estratégico. Então, isso envolve tanto a proteção, que é necessária para que todo mundo participe desse ambiente digital com segurança e que isso impacta. Eu sempre falo segurança, vou falar de uma forma muito rápida, mas assim, segurança não significa só proteção, mas segurança também significa confiança. Então, confiança na tecnologia, nos modelos de negócio. Tudo isso é importante para a gente poder, de fato, incentivar o desenvolvimento econômico e social, fazer com que as empresas tenham cada vez mais esse protagonismo, não só em outras áreas, mas também nessa que é muito central para o futuro. Então, aqui falei de algumas coisas, mas acho que o investimento, então, veja, estávamos discutindo toda uma legislação para inteligência artificial, o governo federal propôs o Plano Brasileiro de Inteligência Artificial em paralelo, com investimento tanto do poder público como do poder privado, né? Então, tanto público e privado ali se juntando para fazer essa entrega. Então, acho que essa é uma parte muito importante e que, do nosso lado, do ponto de vista do governo federal, o diálogo com o Congresso é fundamental para a gente poder, junto a essas iniciativas, poder propor política pública que venha nesse sentido de promoção mesmo do que o Brasil como todo entende que é uma prioridade. Então, desde já me coloco também à disposição do senhor para a gente continuar uma conversa e o que eu puder contribuir também do ponto de vista do digital, a gente poder olhar para esse aspecto, sabendo, né, que os negócios, inclusive, né, e principalmente, né, os negócios brasileiros, então nossa frente de unicórnios, fintechs, tudo isso é muito fundamental para esses próximos passos que vêm por aí, para a gente estar nesse futuro que é muito conectado e que vai depender bastante também desse ambiente digital seguro. Gente, eu tentei ser breve. Obrigada, deputada.
Muito obrigado, viu, Lilian? Obrigado, deputada, pela pergunta. Mantendo aqui no português, eu queria agradecer também a contribuição dos nossos speakers, pela Lilian, Caio, professor Chelansky, que teve que sair, Sofia, muito obrigado a todos. Obrigado a todos também que se juntaram aqui, tanto presencialmente quanto virtualmente. Muito obrigado e please enjoy the rest of the symposium. Ah,
Okay. I will. I will. Yeah. Okay. But that's tomorrow, right? Okay. So hello everyone, good afternoon. Glad to have you back. I'd like Jessica or someone to the organization to come over because I need the placards. If Potter could talk to her. I need the placards for this panel. So glad to have you here again. It's a pleasure to introduce the next panel in the afternoon, which will tackle on insolvency. Such a nice and important topic, especially in Brazil with the recent changes to our insolvency law. It's been some years, but we'll probably talk about the implementation of this 2021 changes, and we have a very exciting panel. Eu preciso das placas. Desse painel que a gente não tem as placas. Vai procurar uma. Without further ado, I wanted to introduce you to this panel. We will have Fernanda Wolff. Fernanda is a Chief Legal Officer at Grupo Abril, and she has received a bachelor degree from the Federal University of Rio Grande do Sul and an LLM from the American University. Thanks, Fernanda, for being with us for the second year. You've been here last year. Second, we'll have Gustavo Salgueiro. Gustavo is a partner at Galdino Advogados, one of our kind sponsors. Gustavo has a Master of Laws in Procedural Law from the State University of Rio de Janeiro, UERJ, and a Bachelor of Law from that same university. He's now a partner at Galdino Advogados with more than 20 years of practice in national and international insolvency proceedings. He is also a member of the legal subcommittee on credit recovery at FEBRABAN, the Brazilian Federation of Banks. Next, we'll have Pedro Leão. I'm saying Leão because I've heard this a couple of times, but it's actually Leão. He's a senior counsel at the International Finance Corporation from the World Bank. He has an LLM from the New York University School of Law and a postgraduate degree in Law and Economics from Fundação Getúlio Vargas. He also has his bachelor degree in Law from the Universidade Presbiteriana Mackenzie and in International Relations from the University of São Paulo, USP. Welcome, Pedro. And last but not least, we'll have Professor Don as part of our panel. I am not going to introduce him again, but I must say that Professor Don has more than 10 years of experience as a counsel in insolvency, besides every other expertise Professor Don has. But it's a pleasure to have this incredible panel of expertise. And to moderate this panel, we'll have a amazing lawyer, very much well-known in Brazil, Ângelo Prata de Carvalho. He's a professor at the University of Brasília, professor of civil and commercial law, and also a partner at Ana Frazão Advogados. He holds a PhD, a master's, and a bachelor degree at the University of Brasília, right, Ângelo? Because that's your fish, right? And thank you all, and I wish you a wonderful discussion. Thank you. By the way, I'm providing you with placards at a moment.
Hi, now you can hear me. Oh, good afternoon, everyone. Thank you very much, Ana Sofia. I'm really glad to be here. And thank you for the invitation to be here. And well, since we are a little ahead, a little advanced in time, and we have a very tight schedule, perhaps I'm going to be more annoying with time and less annoying with questions. But well, we have already defined who speaks first. It's Pedro. And Pedro, we would really like to hear you on the recent trends about transnational insolvency and perhaps the objective of harmonization we have in Brazil passed through a very recent reform which introduced a new section on our bankruptcy law, pretty much based on the ancestral model law. So it would be really nice to hear you. I think you're going to speak standing, right? Please. the floor.
I'm going to do this because I know it's a rainy day outside after lunch, so I hope to keep you guys awake. I'll try to be quick and painless, okay? So my objective here today, and first of all, I'm really honored to speak about this topic. For me, it's a very important topic, not only academically, but also professionally, as I'm working at the IFC. For those of you that don't know, the IFC is the private sector arm of the World Bank. So we work with developing countries and investing equity and debt in the private sector, okay? Secondly, I'd like to thank you guys very much for the invitation to participate in this distinguished panel. Thank you, Sophia and Professor Don, for the invitation to be here. And good, let me start. So the global trends in cross-border insolvency have evolved significantly during the past years. And this is due to the interconnectedness of the economies nowadays. And more than that, with the increased globalization that we all hope that's going to continue for a little while. So companies, as we know, they are operating nowadays across multiple jurisdictions. And this makes the process of insolvency and restructuring quite complex and challenging. Therefore, to address this kind of complexities, international frameworks and laws have been developed to approach a cohesive, to have a cohesive approach to cross-border insolvency. And one of such pivotal frameworks is the UNCITRAL model law on cross-border insolvency. The UNCITRAL model law was adopted in 1997. And why am I speaking about it? Because this is super important for the Brazilian aspect of it, because it was recently incorporated in our legal framework in 2020. I believe January 21st was when it began. So let me try to cover a little bit about the objectives of it, some key provisions, only to have a broad sense of what we are expecting on a global perspective. And then we can dive into some discussions. I won't talk about the adoption in the Brazilian law. I have Gustavo here, who is the expert for the local perspective. So first, what are the objectives of the UNCITRAL model law? First, cooperation, foster cooperation between courts and insolvency practitioners around the world. Of course, fair treatment, because it ensures fair and efficient administration of cross-border insolvencies. Most importantly, legal certainty, providing a predictable legal environment for investors operating in cross-border perspective. And finally, to protect and maximize the value of the debtor's assets. Okay, I'm not going to dive into the key provisions, but what you have to keep in mind is that it grants access to foreign representatives and creditors to local courts. Second, it has a framework that recognizes cross-border insolvencies or insolvency proceedings in another country into the local perspective. Again, it also provides for interim relief. This is super important for investors because it protects the interests of them in preserving their debtors' assets. And finally, cooperation and coordination. In summary, the model law facilitates more orderly and predictable resolution, reducing legal uncertainties. And why are we talking about it in a symposium called Doing Business in Brazil? Because the main point here is that by adopting the model law, it brings another perspective for foreign investors to invest in Brazil, and with that, providing for new jobs and economic growth. For an investor's perspective, first of all, you have the risk mitigation, because it assures that the investment would be protected, even if a company faces the inevitable insolvency in a foreign jurisdiction. Second, predictability, which is a crucial and essential point for an informed investment decision. And finally, it enhances the chances of recovering assets, minimizing losses, potentially. So let me jump into the challenges. So I'm gonna cut myself short here. All these benefits comes, of course, with challenges. And this is where I believe we can have a good debate. First of all, jurisdictional conflicts. Of course, different countries, they have varying insolvency laws, leading to conflicts in jurisdiction and legal interpretations, particularly when labor claims intersect with international proceedings. I will let Fernanda speak more about labor claims. I'm not the specialist here, but you have a lot of experience with labor claims, especially in insolvency proceedings. Another thing, it's not that easy to have a coordination between courts and insolvency practitioners across borders. It can be difficult to achieve. Another thing that we can discuss a little bit later. Third, cultural and legal differences. As I'm speaking here, we have different legal systems. Of course, it goes without saying, but we also have some business cultures that differ across borders. And finally, resource constraints. So developing countries may face some resource constraints in applying and enforcing a sophisticated insolvency framework as the UNCITRAL model law. So to conclude, the importance of cross-border mechanisms cannot be overstated. The UNCITRAL model law brings a robust framework that enhances cooperation, fairness, and legal certainty. And these we are going to debate. And for investors, these mechanisms offer protection and predictability, while for countries, they attract investments and foster economic development. So the main message that I want to keep here with you guys as legal professionals is that it's our duty to understand and advocate for these mechanisms to ensure a stable and prosperous global economy, which at the end of the day is what we are working for. Thank you.
Thank you very much. Now we have names. Thank you, Sophia. Thank you very much, Pedro. I think you have raised some very important issues, which we will, of course, debate over here. And it's my honor now to, pass the floor to Professor Don Diemesis, who will talk to us about, the experience here at the United States with these structures which we are struggling to implement in Brazil since this recent legal change based upon the UNCITRAL model law. And you have, of course, this experience, not only your own professional experience, but legal experience with the Chapter 15 claims, which are, based upon international cooperation, much like our new provision. So it will be an honor for us to hear from you. Thank you.
Nice to see everybody again. Pedro and I actually agreed about an hour ago that we would both keep our remarks abbreviated so that we can get back to schedule a little bit. So I won't go my full allocated 60 minutes. I'll do something less. Actually, what you heard Pedro talk about was UNCITRAL. Everyone's heard of UNCITRAL, United Nations Commission on Trade Law. They deal with unification and harmonization of laws across countries. They have a series of instruments. They have conventions that may be part of what they agree to. What we're talking about in the insolvency area are model laws, not conventions, model laws that a group of experts have said this would be a good law. Countries should consider adopting it. And then countries go and they may or may not adopt it. And if many adopt it, it results in greater uniformity. I remember I was practicing insolvency in the late 80s and early 90s, or that's at least when I started. And the UNCITRAL, for the first time ever, had convened one of its working groups to deal with insolvency. And everyone thought that it would be a failure. And it would be a failure because insolvencies were so inherently territorial assets, maybe territorial creditors, and it was going to be just a failure. And I will tell you, maybe somewhat proudly, that working group has continued to this day. And not only have they concluded the model law on cross-border insolvency in 1997, there's the UNCITRAL model law on enterprise group insolvency, very important actually, in 2019. There's another UNCITRAL model law on enforcement of insolvency-related judgments. There are legislative guides. It is a very rich source of the instruments for insolvency and what countries should consider. In the United States, we adopted the model law in 2005. We call it Chapter 15 of the U.S. Bankruptcy Code. And for those of us who deal with it in the United States, we have Chapter 7 that deals with liquidations. We have Chapter 11 that deals with reorganizations. We have Chapter 15, which deals with cross-border insolvency issues. As Pedro notes, in Chapter 15, and the legislation says that it is to promote cooperation between U.S. and foreign courts, provide legal certainty, debtor asset protection. What it does is it actually says that if there is a foreign proceeding that is started in bankruptcy, and there is a representative that is recognized in that foreign proceeding, that representative will have the ability to come to the United States and start a Chapter 15 bankruptcy by filing a petition. And it's intended to help use the United States courts to advance the bankruptcy in the home country. In the last 7 years, there have been over 200 Chapter 15 cases that have been filed in the United States by many countries, or proceedings started in many countries. And in some ways, why they are used is people then come to the United States, they start this petition, and if it's recognized as a foreign main proceeding, these will be technical terms and we don't need to get into them, then in fact, the court can do certain things. And for example, the U.S. court will impose an automatic stay, because maybe there's an automatic stay imposed in the foreign country, but it's not necessarily an automatic stay in the United States, or at least there would be questions about that. So Chapter 15 allows that stay to be put in place. It allows for U.S. discovery. It allows for collection of assets. So it can be a very powerful tool in administering cross-border insolvencies. Cross-border, the concept, you have a business, it has assets and creditors in different jurisdictions. And so in order to either liquidate or reorganize, there needs to be an effort to bring them all into what is essentially, I'm going to say, a single proceeding, but it needs to be done in the way of a main proceeding and then maybe a Chapter 15 in the United States. Pedro talked about various of the challenges. One of the most important, but it is actually rarely used, is that relief can be denied in the United States if what is asked for violates the public policy of the United States. Now, that's a fairly typical sort of way that governments can agree to things, right? You can do anything unless it violates our public policy. And to date, there have been very few times when courts here have concluded that it violates public policy. There are always opportunities for forum shopping, and very sophisticated businesses and creditors begin to think about, should we file maybe in Brazil and bring something in the United States? Or maybe we should file in England, in London, and bring a proceeding in the United States. And, where do we get the most benefit? So lots and lots of strategies may sometimes be availed on. Chapter 15 cases involving Brazilian debtors. Actually, since 2018, there have been 18 Chapter 15 cases where there have been Brazilian bankruptcies proceedings that have been started, and then they have brought Chapter 15, they've opened a Chapter 15 proceeding here in the United States to really assist in what they're trying to do in Brazil. The most recent one was Virgolino de Oliveira Açúcar y Alcohol, bankruptcy petition 2 weeks ago. We have, there are many, many cases. Americanas S.A., a $4 billion accounting scandal. OI, a telecom restructuring. Odebrecht, Engenharia y Construção, Intercement Brazil. I mean, there are many, many, many cases. And what has emerged, at least from what I can tell, is there are a group of lawyers and restructuring professionals who are very aware of the Chapter 15 in the United States. And if a Brazilian company has, sometimes it may be they have U.S. creditors, right, they've borrowed money for, and they need to have it restructured. And so what they may try to do is get a plan put through in Brazil that they can then enforce here in the United States. And they'll use the United States courts as part of a process of restructuring. The OAS, for example, in 2015 protected U.S. assets during its restructuring. The Intercement case, Brazil cement case, enforced a Brazilian plan. In Virgolino de Oliveira, it addressed sugarcane processor liabilities. So there is some ways 18 cases, 8 years. There's a fair amount of engagement. There was the old airline, Varig, had a case that was started in the United States, and it dealt with the very, sort of complex sets of issues. Should you respect the Brazilian bankruptcy? There had been a bankruptcy started in the United States. Who would go first, right? Comedy sets of issues. So it can be very rich with conflicts of law and international comedy and respect that are built into it. There are some interesting issues that are now coming into place, and that is, can you do things using a Brazilian or foreign insolvency that you can't do if you just started a case in the United States? A classic example that we have in the United States that was the subject of a case that went to the Supreme Court and was decided a year ago here is, can you, in a plan of reorganization, actually put in place compulsory third-party releases, where you release people that aren't debtors? They were people that maybe own the debtor, that are very wealthy, maybe have liability. Can that be put in place as part of a enforceable restructuring plan? And the Supreme Court decided 5-4, right? Close question, that no, you cannot enforce those third-party releases. That's not part of the powers of a bankruptcy court judge. So, of course, what happens? Well, there's a case out of Brazil. And the Brazilian case involves third-party releases. And then they come to the United States under a Chapter 15 case, and they file it. And the court says, oh, we're just enforcing the Brazilian, case. We're not issuing the third-party release, and it goes through. Stay tuned. These issues are going to come up. I was talking to someone last week that is talking about cases that people are thinking of bringing in Singapore, because Singapore will grant that sort of relief and then coming back to the United States. So there are lots and lots of those issues. Now, what Brazil did in, I think it was 2021, is it? They adopted, I'm going to say Chapter 15, not Chapter 15. They adopted the model law. And it is intended to operate similar to the way, these are model laws. There will be deviations, but intended to operate in that fashion. One of the things that it does, and this has been very interesting, is it actually is a law that allows the judiciary from one country to communicate and deal with the judiciary in another country. Revolutionary in a lot of ways. Now, of course, it's a lot easier to communicate when people are communicating in English, for example, if you're in the United States, right? So language does present, issues as to how that would then be arranged. And so I think we have seen it develop quite well and easily in cross-border cases with Canada, maybe Australia, maybe the United Kingdom, and with greater difficulty in other countries, maybe precisely because of that issue. What I think I'll do, I'm going to conclude now on that. I hope I've given you a little bit of a flavor of the way that this cross-border law can be used. And as actually, I think it's now 60 countries in the world have adopted the cross-border law. So it started, as someone's idea, Unsetral's idea, and now 60 countries, and there will be more coming. So thank you for listening.
Thank you very much, Professor. I already starting to grow envious of our students because it was an amazing lecture on Chapter 15 proceedings and cross-border insolvency. Thank you very much for that. And well, I'll have to present a question to Gustavo in order to introduce his presentation because, well, we have adopted the model law. We have adopted something similar to Chapter 15 provisions. But is it necessarily good? Was it the legal change we needed for us? Well, there's quite of a consensus that we needed something more concrete, more dense in order to regulate cross-border issues regarding insolvency proceedings. But is the model that we have adopted in 2020 or 2021 perhaps the right one regarding especially the legal choices we have made in Brazil in order to protect some special kinds of creditors, such as workers, such as labor creditors. And we have also made some choices in order to protect debtors in some ways, some special kinds of debtors who can, well, have some some special protections as well. So would the adoption of these kind of provisions perhaps hamper these special features we have in our laws? And perhaps in order to subvert these legal choices we have made previously? Well, please, you have the floor. Thank you very much for being with us.
Well, good afternoon, everyone. Thank you, Angelo, for the question and the introduction. Thank you, Sophia and Professor Don, for the kind invitation to sponsor such a symposium, a high-profile symposium, and also to address you guys this afternoon. So answering to your question, Angelo, I think it was a good choice, actually, because the ancestral is a model law, as Professor Don and Pedro explained, and also because it's quite similar to the Chapter 15 provision. So the provisions, so it facilitates the Brazilian operators to deal with cross-border insolvencies. And we have room in our legislation to accommodate preferred claims such as labor credits. And I don't want to jump into Fernanda's part of the panel, but the coolest thing that we have in Brazilian system with respect to labor credits is that legal fees are equal in terms of preferred treatment as labor credits. That's a case law construction. Our case law in Brazil made legal fees equal to labor credits for means of protection. So that's the coolest thing we have in Brazil, of course. I'm not biased when I say that, but it's something in Brazil that with lawyers greatly appreciate. So, but now speaking seriously, until the 2020 reform, and the law was enacted in 2020, but it became effective in 2021. So, but before the 2020 reform, we just had no domestic rules with respect to cross-border insolvency proceedings. But after the reform, Brazil became the 49th country, Professor, to adopt the ancestral model law on cross-border insolvency. So I do believe that the 2020 reform represents a significant step toward international harmonization and recognition of the needs of coordination between different jurisdictions in cases of cross-border insolvency. The international insolvency regime in Brazil is provided for in Article 167 of Law 11-101. According to this article, the provisions contained in international treaties to which Brazil is a party apply, and subsidiarily, Brazilian law applies as well, especially in relation to cooperation with foreign jurisdictions. So our Brazilian insolvency law sought to provide appropriate treatment to the pillars of the ancestral model law, as Pedro previously explained, regarding mainly access to Brazilian jurisdiction, recognition of foreign proceedings, appropriate protective measures, both for creditors and debtors within Brazilian jurisdiction, and finally, acts of coordination and cooperation between different jurisdictions. And I will briefly comment on such provisions. Of course, I'm aware we are in a tight schedule here, so I will just make brief comments. Similarly to the Chapter 11 in the ancestral model law, the Brazilian law expressly aims to promote the following objectives: cooperation between judges and other competent authorities of Brazil and other countries in cases of cross-border insolvency, the fair and efficient administration of cross-border insolvency proceedings in order to protect the interests of all creditors and other interested parties, including the debtor. And that's a curious choice of words, because creditors are referred in the first place, and then other interested parties, including the debtor. Finally, the increase of legal certainty for economic activity and investment, the protection and maximization of the value of the debtor's assets, the promotion of the recovery of companies in economic and financial crisis with the protection of investments and the preservation of jobs, and finally, the promotion of the liquidation of the assets of companies in economic financial crisis with the preservation and optimization of the productive use of the company's goods, assets, and productive resources, including those intangible ones. So, and the Brazilian legislation also adopts concepts similar to the ones also adopted by the ancestral model law and the Chapter 15 provisions, such as foreign proceeding, a main foreign proceeding, which is any foreign proceeding open in a country where the debtor has the center of its main interest, is the well-known concept of COMI, the center of main interest. A non-main foreign proceeding, which is a foreign proceeding that takes place in a jurisdiction where the debtor has an establishment or assets, but is not its center of main interest. The concept of foreign representative, the concept of foreign authority, and the concept of establishment, both, all of them well-known, certainly well-known for any practitioner here in the US, given the fact that they are established as well in the Chapter 15. So accordingly, our provisions, the Brazilian provisions, will apply to cases in which a foreign authority or a foreign representative requests assistance in Brazil for a foreign proceeding, assistance related to a proceeding governed by this law is requested in a foreign country. If a foreign proceeding and a proceeding governed by this law related to the same debtor are simultaneously pending, or if creditors or other interest parties from another country have an interest in requesting the commencement of a proceeding governed by this law or participating in it. So, regarding cooperation with foreign authorities and representatives, our Brazilian law provides that Brazilian courts shall cooperate directly or through the judicial administrator to the maximum extent possible with the foreign authority or with foreign representatives in the pursuit of these objectives. And accordingly, the foreign representative is entitled to file several claims directly before a Brazilian court. And once this foreign proceeding is recognized by a Brazilian court, the foreign representative is authorized to file for a debtor's bankruptcy within Brazil. He is able to also participate in the judicial reorganization, out-of-court reorganization, or a bankruptcy proceeding of the same debtor if this process is pending in Brazil. And finally, to intervene in any proceeding in which the debtor is a party, subject to the requirements of Brazilian law. Well, in order to accomplish this duty of cooperation, the Brazilian court may also determine, among other things, the following measures: the appointment of a natural or legal person to act under the supervision of the judge, the communication of information by any means considered appropriate by the judge. And this, Professor Dunn, addresses your comment with respect to the communication between judiciary authorities. That's something that actually happens in Brazil between Brazilian courts. One of the things that was made during the 2020 reform was to create rules specifically regarding the communication between different Brazilian judges, aiming, of course, to coordinate and to preserve the competence of the court responsible for the supervision of the insolvency proceeding. Because if we have two judges deciding about the assets of a company, of a debtor, of course, that will create uncertainty in an unstable environment in order to allow the reorganization of the company. So that was one of the pillars of the reform as well. So in order to fulfill this duty of cooperation, the Brazilian court may also determine the approval or implementation by the judge of agreements or protocols of cooperation for the coordination of judicial proceedings, and finally, the coordination of concurrent proceedings related to the same debtor. As a conclusion, and before I finish my part of the panel, I think it's correct to say that in practical terms, recognition of foreign decisions and cooperation depend on case-by-case analysis by the Brazilian courts, which weigh the compatibility of foreign provisions with the Brazilian law and Brazilian public policy. With the 2020 reform, Law 11-101 seeks to balance legal certainty, creditor protection, and respect for the principles of international cooperation. And then I will just address some cases that I had the opportunity to work with regarding cross-border insolvencies before, all of them before the 2020 reform. The first one was actually a quite interesting case. It was the Grupo Rede reorganization in Brazil. It became a Chapter 15 proceeding here in the US, where Grupo Rede Energia sought the confirmation, the enforcement of the plan approved in Brazil. It was important because one of the debts that was restructured by the plan was a note, and the reinforcement of the plan here in the US was a step necessary to the issuing of the global note to the investor, which was the client represented by my firm at the time. So it was quite a challenging case because other investors entered into an agreement with Grupo Rede to acquire the control of this energy player there in Brazil. And our client at the time, Energisa, basically attempted to do a hostile takeover within the judicial reorganization, and then the parties agreed, the debtor in Energisa, and become an acquisition, not a hostile takeover, but a takeover. And then once the case was, once the plan was approved, it was necessary to file for Chapter 15 for the recognition of such plan here in the US. And there was a dispute between Grupo Rede, the debtors, on one side, with, of course, the investor interested in the confirmation of the plan, Energisa in that case, also on the same side, and on the other side, the note holders. And at the time, Judge Shelley, which was Honorable Shelley, what's her name? Sorry. She was responsible for the United States Bankruptcy Court in New York. So Judge Shelley, at the very first audience of this, very first hearing of this case, she said, look, I don't know about Brazilian law, and I don't know about the facts of this case. You, counsel, can either choose me to investigate what the Brazilian law says and to investigate what the relevant facts of this case are. And if you choose to do so, it will take something like 2 years to rule this case here in the United States. But if you, counsel, are able to gather, to file a statement of law saying what are the relevant Brazilian legal provisions that I should consider to decide the case, and if you are able to provide me with a statement of facts about the relevant facts under this dispute, then I can issue a decision in about 3 months. So, of course, the lawyers involved in this case, we prepared a statement of law with our uncontroversial view of the Brazilian law and a statement of facts about the relevant facts under the dispute. And we provide this joint statement to the court. I'm saying we, of course, the American counsel did so with our help. But once we did that, she did issue a decision confirming the plan in a very short time. And it was quite surprising for a Brazilian lawyer to see that this kind of procedural flexibility. That was revolutionary, Professor. That was indeed revolutionary. So, but apart from this experience, we had cases, for instance, OGX case, the oil and gas company from Mr. Ike Batista that went under a Chapter 15 restructuring in Brazil, a judicial recovery, and it was necessary to include within the proceeding some Austrian companies that served as just companies to take loans, to take money from abroad. So they were basically vehicles constituted to take money from foreign investors. So and they were included in the Brazilian proceeding, and it was the first time in Brazil that we had the discussion if before the 2020 reform we could include those foreign companies within a Brazilian procedure. The Brazilian courts understood that this was something acceptable under our system, and the plan also addressed the loans and the debts of these Austrian companies. There was no assets in Austria; they were merely vehicles to take money from overseas. But in the OSX case, where it was the company with the vessels, with the FPSOs, the floating FPSO, floating production, offloading vessels. The vessels itself were companies constituted under Dutch law, and on Netherlands the Netherlands system just did not recognize foreign proceedings, so the Dutch companies were not included in the Brazilian proceeding, and actually there were concurring proceedings in the Netherlands to specifically deal with the debts that were taken by these vessels that were actually Dutch companies. So that's how we used to deal with cross-border insolvencies before the reform, and for a Brazilian perspective, the reform is quite recent. We don't have a relevant case law. We don't have strong precedents regarding the application of the law. But indeed, Angelo, I believe it's a very good system that we have adopted because it's the model law. So it makes easier for debtors, creditors, investors, both foreigners. It gives certainty and it gives some predictability of how to deal with these cross-border insolvencies. So I believe that's it from my part. Oh, yes.
Thank you very much, Gustavo, for this actual crash course on our 2020 reform and these new issues regarding our legislation. And it's very interesting for you to bring us your experience with cross-border proceedings before that reform. And perhaps, of course, it comes from the model law. Perhaps now we can develop a more dense, more coherent case law regarding these issues. And talking about, thank you very much once again. And talking about a crash course. Well, we are at the Doing Business in Brazil Legal Symposium, and perhaps the story Fernanda has to share with us and the experience Fernanda is going to kindly share with us is perhaps a crash course regarding doing business in Brazil. So it's going to be a great honor to hear from you, and especially your experience, of course, with Grupo Abril, which is a group of companies very well known to every Brazilian. You are with the Veja magazine on your hands, so with the new Pope, an American Pope, by the way. Well, please, you have the floor, Fernanda.
Hello, everyone. Good afternoon. I'm very honored to be here again. Thanks for the organization. Thanks for the previous presentation from my colleagues. It was really nice. While I cannot talk much about international insolvency, that's not my experience, but I can talk about labor disputes in the context of a judicial recovery in Brazil. As Chief of Justice Barroso mentioned yesterday, in Brazil we have many justices. We have the federal justice, the civil justice, the electoral justice, the military justice, and also the labor justice. The workers are protected by a specific system and by specific judges in Brazil. We have labor judges in all 26 states plus federal districts. There are over 3,000 labor judges in Brazil. When we talk about harmonization of international system with Brazilian law, for me, it's quite nice to hear that, but I believe that we first need to harmonize domestically, internally, our understanding and our interpretation about the law. There are a great quantity of disputes regarding labor issues, and also regarding labor issues in the context of a judicial recovery. When I was preparing myself for this panel, I read an article from Isabel Picot. She's also a restructuring lawyer, that brought some interesting numbers about judicial recovery in Brazil. It said that on 2014, we had 800 requests. 7 years after, there were 900 requests. On 2023, we have 1,000 requests. And surprisingly, on 2024, we have 22, more than 22 requests. But only 23% of them are successful. So only 23% of the, even less than 23% of these requests of this judicial recovery process were able to get to the end of the process and not to be under judicial recovery anymore. And why is that? So the article mentions a lot of problems we have in Brazil. Like as Gustavo mentioned, we have the fragmentation of the creditors. So different creditors with different rights, and they all try to escape from the plan. So you're always like taking care of the ships in a judicial recovery in Brazil because everybody will try to enforce their credit in a different way. So this is a nightmare, believe me. You also have tax authorities that they have some privilege when enforcing the credits against judicial recovery plans because they are not abide by the rules. And you also have the labor disputes. Labor disputes in Brazil are a chapter aside. As everybody mentioned here, you have not only the workers with constitutional protection, but you also have an extension of the concept of labor credits. So you have the fees of the lawyers. You also have some agents like commercial representatives when they render individual services, and when they have economic dependence, they are also considered as class 1 creditors. So there's a really huge expansion of that concept, which makes really hard for the restructuring people to deal with all these exceptions and all this fragmentation of the system. Aside from that, when you talk about workers' rights in Brazil, you are talking about rights that are protected from the Constitution. For the Constitution, I'm sorry. And we have principles like the social function of the company, human dignity, valorization of work, and we also have the private competence of labor judges to deal with labor credits. But when you are inside the judicial recovery process, what happens is that when you start the process, you have the stay period, and you have the competence of the judge from the judicial recovery. He is the one competent to enforce the credits against the company. He is the one that's going to put all the creditors in line. So at the same time, you have this special justice, the labor justice. When you are under a restructuring project, the judge of the restructuring is the one with the competence to take any enforcement action. So in practical matter, what happens is chaos, basically. That's what you have. Because during all the judicial recovery process, you were talking to the restructuring judge. When you file the judicial recovery plan, you have the stay period until you approve the plan. And then the judge from the restructuring, he is going to be protecting the company and making sure that no one is going to take the assets improperly. But once you go to the next level of the judicial recovery process, once your plan is approved in the assembly and you need to start making the payments, then the discussions start in Brazil. Who is going to be the judge that's going to take care of that credit? Who is going to be the judge that's going to put the credit in line? So our understanding, and I think the doctrine and the decisions, they are all aligned, is that the labor judges they have the competence to deal with the labor credits during the cognitive procedure. But by the time the enforcement starts, all these creditors need to go to the judicial recovery judge, and he is the one that's gonna, again, respect the plan, make the plan to be respect. The problem is that you don't talk to one judge anymore. You talk to 3,000 judges. And you don't talk to a judge that's with you since the beginning of the process. You have to talk to a judge that has only one lawsuit with not a super huge value, and he needs to understand the plan since the beginning. So the plan that you have been working on for months, sometimes years, you have to present to the labor judge and to explain to him and convince him that there's going to be discounts. That's something unacceptable to them, that you give discounts over labor creditors. So Paul asked me what were the strategies that we took in the Grupo Abril case to make it work. So again, we had different strategies in different moments of the judicial recovery process. So before the plan was approved, our strategy was to negotiate with all 5 unions. We had 4,000 worker creditors, so that was a lot. It's not mandatory for the Brazilian law that you negotiate with the unions during the restructuring process, but we did it because we believed that it would give more legitimacy to the process, and it really helps. Even today, it helps us when the labor judge is not comfortable with the plan. We show them that we made collective agreements with all the 5 unions, and that really helps them to understand the process and to be convinced that that was the only solution we have. Then after you approve the plan and you start the payments, we thought, well, now everything is going to be all right. We started payments. So no, that was not the case. What happened is that because there was not this, we were not in the stay period anymore. So we had to start paying everyone. The labor judges, they automatically started to enforce all the credits at the same time with no respect to the plan. So it was, again, a work of convincement of all the judges that the plan was applicable, that the collective agreements had been negotiated with the unions, and there's also another problem. When you file a lawsuit, judicial recovery process in Brazil, you have the liquidated labor credits, and you have the not liquidated labor credits yet. So in the first stage, we were able to deal with 4,000 workers that already knew how much money they had to receive from us, so they knew exactly what they were negotiating with us. In the second moment of the judicial recovery process, we didn't have liquidated creditors. We had labor lawsuits that were still going on. So every time that a labor lawsuit would get to the end, we would face the same problem, explaining the plan all again. And when the labor judge did not respect our plan, we would be able to go back to the judicial supervision of the restructuring judge and ask for I'm not sure if the name it's conflito de competência, competence conflict. So that was the mechanism we used. We went to the Superior Court of Justice asking for protection, and we got such protection. So every time that a labor judge would disrespect our plan, the Superior Court would issue a decision to make the labor judge understand that was a decision of the restructuring judge. And then we thought, now our problems are solved because we have the Superior Court protecting us. And then there was the third moment of our judicial recovery process, when we were not under judicial supervision anymore, And then what happened was a new understanding. In this one, there was no strategy because we were not waiting for it. What happened is that the labor judges, they started to understand that because we were not under judicial recovery anymore, the plan was not applicable anymore. So you would have this situation where all 4,000 creditors, plus the 2,400 labor lawsuits, they started to asking for the same creditors as if there was no judicial recovery plan at all. And we were not under judicial protection anymore. So we did not have the conflict of competence to protect us. So we had to be very creative. We went for many hearings with our judge. He had no jurisdiction over our judicial recovery process anymore because the judicial process was finished, was terminated. And then we filed with him an enforcement of the sentence. So we could reopen the process with the judicial recovery judge. And again, we were able to go to the Superior Court to ask for protection. During this entire process, we noticed that the labor judges were doing what they were doing, not because they didn't like us, but because they did not understand the process, the entire process was a mystery. So we started to develop a cooperation work because every time we would go to the labor courts to explain our case, the judges would believe us, but not believe us. Was always kind of a weird reaction because it's something new that a company in Brazil finishes his judicial recovery. So we asked the judicial, the judge from the judicial recovery process to help us in that communication. So instead of us saying that that credit was submitted to the judicial recovery plan, was the judge that was with his perito, with the specialized guys. They were the experts from the Judicial Recovery Court. They were the ones saying, look, this is subject to the plan and you should respect. When we were able to make that connection, when we were able to make that cooperation between the labor justice and the recovery, judicial recovery justice, this is when things really started to work for us. So nowadays, I'm glad to say that the labor creditors are being paid according to the plan, and the company is here. We are still publishing. I believe most of the Brazilians know. It's a famous political magazine in Brazil. We also have other activities, e-commerce, logistics, and so we were able to survive the attack that at that time we would call a death by 1,000 needles, because we were being attacked by many judges, many labor judges at the same time. So was the cooperation procedure that there was no law, there was no ancestral law being applicable, but we were able to create this cooperation between the judges, the justices, and it really worked. So I'm here today because we really believe that the system will improve a lot if we start to talk the same language inside Brazil. Sometimes we think we all speak the same language, but that's not true. So I think that's it. Thank you.
Thank you very much, Fernanda, for bringing us your case on Grupo Abril, which is, of course, a case to be studied and researched, and in order for us to have a better understanding of the great ideas you've had with the legal framework we already have in Brazil, and you have very clearly showed us how we have a lot of way to improve, a lot of space to improve. So now we have reached the end of this panel, and I think we have to wrap it up because we have a tight schedule. So I'd like to thank everyone once again, to thank Pedro, Fernanda, Gustavo, and Professor Don Diames is also our host over here. It has been an honor to moderate this panel, and thank you very much. And I'm really anxious to see the next panels on this amazing symposium. Thank you very much.
And so I think we'd like to ask the speakers and moderators for what will be panel 9 on energy transition in Brazil to come up to the front.
Thank you so much.
Thank you. You want one more? One more. It's not a real panel unless he gives in the photo.
Thank you.
Thank you. And that's why I announced it. You come up now. Okay. And you can bring them up. Thank you.
Presenter.
Thank you.
Tu muda, Mari.
Sem problema. Vocês se sentam e eu vou botar a plaquinha onde
So here I am again. I hope you don't mind to hear my voice again. We have a very exciting panel coming. It's about energy transition in Brazil. And this is surely one of the most important topics in Brazil right now, considering the world scenario on transitioning energy. And we do have great panelists to tackle that issue. First, we have the pleasure to welcome Natalia Rezende. Natalia is the Secretary of Environment, Infrastructure, and Logistics at the government of São Paulo. She's not only that, but well, I was learning with Natalia that she handles like more than 9 agendas in the state of São Paulo. So she's a true hero. And more than that, she works with Tassi, which is a very productive person. So yeah, she must be twice productive. But Natalia has a PhD from PITARC, UNB, with a focus on network infrastructure regulation. Is studying for a Master of Laws at the University of London. I don't know at what time she does this. Lectures on public-private partnership. She's a full member of the Airport Infrastructure Regulatory Committee at FGV Rio and is a board member of the Companhia Paulista de Parcerias. She has a master's degree in environmental technology and water resources from UNB and a postgraduate degree in law, specialization in economic regulation from the University of London. I think I'm speaking twice, but it's already a lot. So thanks, Natalia, for being here. Next, we will have Professor José Ronaldo Souza Jr. Is a professor at IBMEC Rio de Janeiro. He's an economist with a distinguished academic and professional career, with a PhD in economics from the Federal University of Minas Gerais and training in quantitative methods for forecasting technological innovations from MIT. He has built a solid career over almost 2 decades in in the Institute of Applied Economic Research, IPEA. His experience also covers the energy sector, having worked at Petrobras for almost 2 years, where he deepened his knowledge on oil and gas. In the academia, he combines his postdoctoral research in regulatory law at FGV Rio with more than a decade of teaching in economics at IBMEC Rio. So we do have economists on this panel, and I'm very glad to hear. Next, we will also have Gregory Harrington, which you were just hearing them from the last from our lunch at Arnold and Porter. Gregory is a lawyer in the U.S., but with a vast practice in Brazil. Gregory may talk about a bit of his background over the panel, because I don't really have it here. This is outdated. And we do have our last panelist. This is also outdated, okay? So maybe Eduani could give a glance about their backgrounds, and we will hear from them. Very, very happy to receive you in our symposium. Thank you for your to be here. Thank you. Have a great panel, by the way.
Good afternoon, everyone. I'm Eduani Pedro. I'm from Angola. Allow me, please, to share an important information for the Brazilians in the audience, but in Portuguese. Eu sou flamenguista desde pequeno e até hoje sigo me gabando pelo Mundial de 81. E me sinto muito conectado com o Brasil, que é um país maravilhoso. E confesso que é um grande privilégio estar aqui neste evento com profissionais brasileiros. É excelente e ter a oportunidade de discutir temas jurídicos bastante interessantes e profissionais de gerações distintas. E eu gostaria de dizer que as portas de Angola estão abertas para cada um de vocês. E espero que num futuro próximo possamos ter esses tipos de debates em Angola também. Back to English. It's an honor to moderate this panel in energy transition in Brazil. And I would like to extend our warm welcome to our distinguished panelists and thank each of you for joining us today. Before I give the floor to our panelists, I would like to highlight some important points. Each panelist will have 15 minutes to present their views and topics. The panel will be conducted in English and Portuguese, so you can choose. And after all presentation, we will have the audience to ask questions. So, I'd like to start with Secretary Natalia Rezende. I would like to hear your thoughts about the energy mix, the current profile and emerging opportunities in the state of São Paulo.
Okay, thank you. Thank you for having me. It is a great pleasure. Nós combinamos de falar em português e inglês também, então vou começar aqui em português, aí se for o caso a gente muda para o inglês. Bom, primeiro é um prazer, uma honra estar aqui. Gostaria muito de agradecer o convite, a oportunidade, a todos aqui que me acompanham no painel. Professor, parabéns pelo trabalho, um prazer imenso para nós do Estado de São Paulo ter a oportunidade de falar aqui num ambiente tão qualificado, com profissionais de extrema competência que me acompanham, sobre um assunto que é muito caro para nós, que é transição energética, descarbonização. E uma primeira coisa que eu queria colocar, que eu queria contextualizar, é o fato de que a transição energética, a descarbonização, até porque o Brasil é um país de uma energia muito limpa já, claro, nós sempre podemos melhorar, tem que estar dentro de uma política maior de infraestrutura e meio ambiente que deve ser articulada. Então, como que no estado de São Paulo a gente planejou? de uma forma com uma robustez de plano e ações de curto, médio e longo prazo, dentro de uma estratégia climática muito concreta, isso é importante, que nós dividimos em 2 eixos, um eixo de mitigação, um eixo de adaptação e resiliência. O de mitigação com foco até 2050, adaptação e resiliência com uma incrementalidade de 3 anos, 3 em 3 anos até 10 anos. E aí a gente vem desenvolvendo eixos, indústria, resíduos, transporte, uso do solo, educação ambiental, conscientização, finanças verdes e energia. Então, a energia é um dos principais eixos que nós temos na nossa estratégia climática e que deve ser vista de uma forma integrada com as demais. E aí, por que eu falo isso? Quando nós começamos a desenvolver o nosso plano de energia, e nós concluímos no ano passado, também com um horizonte até 2050, para ficar concatenado com a estratégia climática, primeiro plano subnacional do Brasil, nós fizemos alguns pilares: meio ambiente social, infraestrutura, regulação, tecnologia, e quais são os gargalos, quais são as fontes e como que a gente consegue desenvolver isso também numa estratégia de curto, médio e longo prazo. Quando a gente olha o estado de São Paulo, a gente tem várias possibilidades de transição energética, de energia limpa. E aí a gente tem desenvolvido todas as rotas, todas as tecnologias. Exemplo, nós temos pesquisado e olhado muito para a questão do hidrogênio. Sol verde? Não, hidrogênio de baixo carbono. Por quê? Porque a gente tem uma riqueza de biomassa muito grande da cana, das nossas plantações, principalmente ali no oeste de São Paulo. E aí a gente hoje consegue, a partir do etanol, a partir da cana, fazer a geração do hidrogênio de baixo carbono, que nós estamos junto com as universidades, com a USP, vendo como abastecer ônibus, caminhões, por meio do hidrogênio que a gente gera via etanol. A gente já tem protótipos e nós estamos desenvolvendo para dar escala, que é o grande ponto do hidrogênio. E aí, dentro dessa rota, vendo todas as possibilidades que a gente pode fazer para ter também a fonte do hidrogênio. Outro que a gente vem olhando, a parte hidroelétrica, que nós temos muito, de uma forma muito forte no Brasil como um todo. E aí eu mencionei aqui da nossa energia limpa, a gente tem no estado de São Paulo 60% da nossa matriz via energia renovável. Isso é um número muito alto, até quando a gente pega os objetivos dos países de forma geral, os países da Europa, por exemplo, vocês podem observar vários deles com um target aí de até 2030 para chegar em 30, a gente já tem 60. E isso por meio muito também da energia que a gente gera via recursos hídricos. Qual é o ponto em relação a isso? A disponibilidade dos recursos hídricos. E aí no estado a gente tem estudado as 3.074 otobacias que a gente tem dentro das 22 unidades de gerenciamento de recursos hídricos, para a gente saber aonde caminham cada curso d'água e como que eu consigo ter resiliência. E aí isso entra também dentro da lógica de saneamento, que não é objeto aqui, mas que a gente tem visto e estudado muito no estado. Um outro elemento rota que a gente tem desenvolvido e fomentado muito no estado, biogás e biometano, também por conta da biomassa rica que a gente tem. E aí é interessante a gente falar um pouco disso, porque nós fizemos um estudo extremamente aprofundado junto com a indústria do estado de São Paulo, e só para trazer alguns números aqui para vocês. Quando a gente começou a nossa gestão, a gente viu uma produção de biometano no estado de 30 mil metros cúbicos dia. A gente triplicou, a gente hoje tem 100 mil metros cúbicos dia, e o nosso potencial no estado de São Paulo é de 6,5 milhões de metros cúbicos dia. O que isso representa? 50% da indústria do estado de São Paulo. É dizer que eu consigo abastecer 50% da indústria do estado de São Paulo, potencialmente, com biometano, com um biocombustível. Isso é extremamente representativo. E, claro, a gente sabe que tem uma discussão muito grande em relação à segurança energética, que também deve ser olhada, e que isso a gente está vendo a questão do gás, vendo toda a parte de segurança energética junto com o meio ambiente. E por que o biometano também é interessante? Porque é uma molécula que eu consigo colocar 100% no grid, porque ela mistura com gás. E aí, o que a gente tem visto? Os gargalos que eu tenho na regulação, lembra dos eixos que eu falei lá do nosso plano de energia, na regulação e na infraestrutura, para eu conseguir que a geração de biometano entre no grid. E da onde que vem essa biomassa, esse biometano? Uma grande parte, 70% do setor sucroenergético e uma boa parte, 30%, 40%, de resíduos sólidos dos nossos aterros. E aí, dentro dessa perna do saneamento básico, a gente vê uma potencialidade gigantesca. Nós geramos no estado 44 mil toneladas dia de resíduos sólidos, do lixo. Só que em 536 municípios, dos 645 municípios que eu tenho no estado de São Paulo, a gente gera menos de 50 toneladas dia. O que isso significa? Que eu preciso, para de fato ter uma economia circular, de integração. E aí a gente lançou no estado um programa, se chama Integra Resíduos, para a gente conseguir agregar os municípios e dar escala. Esse é o ponto. Por quê? Porque ao longo de 2 anos, nós viemos desenvolvendo normativos ambientais para dar segurança jurídica e previsibilidade em relação a licenciamentos, a como que eu consigo, sim, fazer geração de energia por meio do lixo, do resíduo sólido, enfim, toda uma série de regras, um arcabouço jurídico muito forte para dar previsibilidade e segurança jurídica. Mas o ponto é além do meio ambiente, o ponto é viabilidade econômico-financeira, e isso eu consigo por meio de escala. Hoje a gente tem trabalhado com 12 consórcios, e aí a lógica de consórcio municipal é boa, desde que você tenha uma boa governança, e para isso o Estado tem que estar presente, gerando 7 mil toneladas dia. Nós vamos fazer 3 blocos agora, o Estado entrando para melhorar a governança, para fazer modelagem de concessões ou parcerias público-privadas, concessões patrocinadas, isso a gente está vendo ainda, modelando para... E aí a gente vai focar da triagem em diante, da triagem até a destinação, em como que eu valorizo o resíduo, independentemente da tecnologia. Então, a gente não vai cravar, tem que ser X, Y, não. Eu quero valorizar o meu resíduo. E por que eu olho da triagem em diante? Primeiro, porque a coleta é muito municipal, e a escala, quando tem o Estado, ela tem que ser olhada do ponto de vista ali da destinação, principalmente por conta da questão ambiental. E o custo logístico é muito importante. Hoje, para vocês terem ideia, em 199 municípios, o caminho para percorrer e destinar os resíduos é mais de 50 quilômetros. Então, é um custo logístico muito alto que se tem, e muitas vezes os municípios não têm nem condição de arcar com aquilo. A partir do momento que eu tenho escala, por exemplo, onde que eu estou falando, para quem conhece aqui São Paulo, região de Campinas, que a gente já está montando ali com 2 consórcios, que geram cerca de 3 mil toneladas dia, e acima de 500, 600, 700 toneladas dia, eu já tenho uma escala muito boa para, de fato, fazer economia circular. E é isso que a gente está modelando para a gente conseguir ter audiência, consulta pública, envolver a sociedade, colocar todo mundo na mesma página para conseguir até o meio do ano que vem fazer a auction, os leilões de resíduos sólidos, que a gente acredita muito que serão referência não só para o estado de São Paulo, não só para o Brasil. Como é que eu estou de tempo? Mais 2 minutos. E aí, olhando nessa perspectiva integrada que eu falei, a gente tem entendido a energia, a transição energética, a descarbonização nos nossos vários setores, nas nossas várias políticas públicas. Eu falei um pouquinho aqui de resíduos. O outro que a gente tem desenvolvido muito é a parte de transportes. O perfil de emissão do estado de São Paulo, diferentemente do Brasil, que é muito focado no agro, é transportes, se a gente for ver questão de emissão. E o Brasil, assim como o mundo já foi em várias partes em relação a algumas décadas, ele é muito focado em rodovia. Então, a gente precisa melhorar a nossa matriz logística. Como? Hidrovias, travessias, ferrovias. E aí a gente está desenvolvendo isso também com foco nessa lógica de transição energética, seja nos trilhos, seja, por exemplo, na parceria público-privada que a gente vai fazer agora, Estamos, inclusive, lá com o nosso governador em Nova York, procurando investidores e mais financiamentos para a gente conseguir colocar na praça no meio do ano para ter contrato até no fim do ano que vem, a PPP de travessias litorâneas, que envolve cerca de R$ 1 bilhão, 240 milhões aí de dólares, mais ou menos, de CAPEX, 20 anos de contrato, e contratos com previsibilidade, para a gente ter a troca de toda a nossa frota, são 48 vessels, 48 ferry boats, para elétrica, e para isso a gente precisa ter infraestrutura. E aí, em cada uma das travessias, a gente foi olhando aonde dava, onde não dava, para a gente colocar infraestrutura e fazer essa troca, que representa 18 mil toneladas de carbono a menos por ano. Mesma coisa na nossa hidrovia, que a gente está fazendo obra lá para perenizar, de forma com que a gente tenha 3,5 de profundidade e, em época de estiagem, como foi 14 e 15, eu não fique 20 meses sem a passagem de comboios, que representam 20 milhões de toneladas a menos de gás carbônico, uma vez que um comboio são 173 caminhões. Estou falando um pouco aqui de forma rápida, mas só para passar o panorama de que é importante ter essa integração de políticas públicas. A gente precisa olhar a transição energética e a descarbonização como uma política de Estado que perpassa governos, porque meio ambiente, infraestrutura são áreas que as pessoas também precisam enxergar como fazendo parte delas e compondo algo que é muito maior do que pessoas. É o Estado com suas instituições fortes, uma regulação bem qualificada, como a gente está fazendo com as nossas agências, que a gente melhorou, faz todo um arcabouço jurídico para melhorar essa parte de regulação. Lei Complementar 1413, o financiamento, a autonomia dessas instituições, de forma com que a gente consiga, de fato, ter a concretude da transição energética, de uma energia limpa, com sustentabilidade no longo prazo, uma regulação adequada e atração de investimentos. É um desafio? É possível? Não tenho dúvida. E isso eu acho que o Estado de São Paulo, e aí olhando de uma forma mais macro de energia limpa, o Brasil tem muito a contribuir para o mundo. Bom, já falei demais aqui. Muito obrigada. Um prazer estar com vocês.
Muito obrigado, secretária Natália. A explanação levou-me a perceber que, apesar de São Paulo ser um Estado, alguns países deviam replicar esse modelo. Não só os Estados no Brasil, mas alguns países deviam efetivamente replicar esse modelo. Eu gostaria de passar a palavra para o Dr. Eduardo e gostaria que fizesse aqui um highlight em relação aos desafios do setor de aviação, uma vez que é quase que impossível falar de descarbonização sem falar do setor de aviação. E gostaria também que focasse um pouco no combustível sustentável de aviação. Acho que é um aspecto importante para ser realçado. Muito obrigado.
Obrigado, Eduane. Antes de começar, queria fazer aqui um agradecimento e parabenizar a iniciativa da Georgetown Law, do IBDL, e aí, em nome dessa cumprimento, direciono ao professor Dom de Amitis. Queria também cumprimentar meus colegas painelistas, e aí aproveito a secretária para cumprimentá-la e, em nome dela, cumprimentar todos os demais. Bem, acho que antes de a gente falar um pouco da transição energética e um pouco do SAF na aviação, é importante tentar criar um contexto aqui, até para contextualizar aqui nos Estados Unidos o papel da aviação no Brasil, né? Eu acho que é importante falar que é um modal de transporte essencial, principalmente no Brasil, pelas dimensões continentais que tem, mas também pela infraestrutura terrestre limitada. Limitada por várias questões de geografia, questões de preservação ambiental, enfim. O fato é que é limitada, é essencial, porque é através dela que se garante o acesso a serviços essenciais como saúde e aviação para várias populações que estão, de alguma forma, isoladas ou distantes dos centros de saúde e de educação. Então, nesse sentido, a gente tem aqui alguns pontos que é preciso também contextualizar, que é o fato de que, apesar dessa essencialidade que a aviação tem, existe ainda um potencial de crescimento muito grande, né? Só para ter uma ideia comparativa, o Brasil hoje tem uma taxa de voo per capita por ano equivalente a 0,49 voos, enquanto a média da América Latina é 0,69. Então, a gente está abaixo da média da América Latina. E aí, para fazer uma comparação, aqui nos Estados Unidos, a gente tem uma taxa de 2,69. Então, existe aí uma oportunidade muito grande, um desafio muito grande, né? E aí é importante, dentro dessa contextualização, a gente começar também a entrar aqui no tema, que é a questão da descarbonização do setor de aviação. E aí, aproveitando aqui, a secretária comentou do peso, né, do modal de transporte. Aí eu queria só trazer aqui um dado que o setor aéreo, ele é responsável por 2,5% das emissões no modal transporte aéreo. E a perspectiva, os estudos têm mostrado que até 2030 vai ser igual a 3,6%. Vai ser responsável por 3,6%. Então, assim, a gente é essencial, a gente contribui pouco em relação aos demais modais de transporte, mas não por isso a gente, como setor, está deixando de assumir compromissos e compromissos importantes nesse sentido, né? E para que a gente possa fazer essa transição energética, essa descarbonização, o setor adotou aqui algumas estratégias, algumas rotas. As novas tecnologias, ou seja, a adoção de novas tecnologias, a eletrificação, o uso do hidrogênio como forma de combustível para aeronaves, mas isso é uma meta de longo prazo, ainda não existem tecnologias, mas as empresas estão buscando isso, estamos apoiando também como operadores aéreos. A outra rota, outra estratégia é a melhoria da eficiência operacional, isso já está sendo implementado, desde a implementação de softwares que trazem uma otimização da rota, que permite aí uma economia no consumo de combustível, a adoção, a renovação da frota. Hoje a Latam já tem 25% da frota renovada por novas aeronaves com consumo de 20% a 25% a menos. Então, isso já está em implementação. Essa é a estratégia que está mais avançada no sentido de dentro do setor. Mas existem pelo menos outras duas. A questão da compensação, já que, por mais que sejam adotadas todas essas questões de tecnologia, a gente ainda tem os desafios que elas não são suficientes para reduzir completamente as emissões. Então, aquilo que não for possível ser reduzido, a gente vai ter que compensar para poder atingir as metas internacionais e as metas colocadas pelo próprio governo do Brasil. E aí entra um pouco também no que você comentou, Eduardo, do combustível de futuro, né? O combustível do futuro, hoje, pelos estudos que tem mostrado, vai ser talvez um dos mais importantes, não o único, como eu comentei, mas o que vai ser responsável por 70% dessa descarbonização, né? Mas não vai conseguir passar disso, mesmo utilizando o SAF em escala necessária, e isso quando estiver disponível, né? Porque a gente já sabe, tem visto aí que as plantas, pelo menos no Brasil, com escala suficiente, de forma madura, só vai estar presente lá por 2028, por aí, tá? Bem, esse aqui são as rotas, né? A gente aqui ainda tem que falar um pouquinho sobre os desafios dessa descarbonização, e são alguns, eu vou falar de alguns, mas talvez não consiga falar de todos, até porque eu quero focar especificamente um. O primeiro é os custos elevados, custos da produção do SAF, do uso de compensação do crédito de carbono, da adoção, né, de novas tecnologias. Tudo isso vai trazer um desafio muito grande. Só para também trazer um pouco de concretude, hoje o preço do QAV, que é o querosene de aviação, que representa 40% dos custos de um voo, ele no Brasil está em torno de 0,70 dólares o litro. As previsões para um mercado maduro, inclusive feitas através de um estudo contratado pela Latam e pela Airbus e feito pela MIT, mostram que você, na produção do mercado maduro, vai ter um preço equivalente a 1,10 a 1,60 dólares o litro. Então, você fazendo a conta aí, você vê que isso vai trazer um desafio muito grande. Então, os custos, nesse sentido, cria um problema, um desafio mesmo. Então, a gente vai ter que tratar isso das mais diferentes formas. O que a secretária comentou, a escalabilidade na produção do SAF vai ser também um desafio. A gente tem aí um potencial muito grande. O Brasil esses estudos que a gente tem visto, o MIT mostra que o Brasil tem uma vantagem competitiva na produção de biocombustíveis, especificamente o SAF, muito grande, mas isso precisa ser realmente aproveitada, e aí são as políticas públicas e os diferentes mecanismos que vão permitir isso. As tecnologias de desenvolvimento, como a eletrificação, é um desafio que está sendo colocado, mas como eu comentei anteriormente, é uma questão de longo prazo. Mas aí eu queria focar aqui num desafio, e aí eu acho que trazer um pouco da concretude aqui para a questão das discussões aqui nesse simpósio, que é a da coordenação internacional, né? Quando a aviação é um setor global, a descarbonização, como a secretária comentou, exige aí uma colaboração e uma harmonização de políticas entre diversos setores e, no nosso caso, entre diversos países e regiões, né? Então, esse ponto da coordenação internacional, ele é fundamental. E aí ele se concretiza através do tema aqui que eu trago, né? Que é a questão da convergência regulatória e a interoperabilidade na transição de energia no setor de aviação. Isso porque, no contexto da aviação, a gente tem políticas entre diferentes jurisdições e setores que que o setor tem que cumprir, né? No painel anterior até foi falado muito dessa harmonização entre leis, entre questões, o setor de aviação vive isso cotidianamente, né? Então, é importante que a gente tenha esse olhar específico, né? E para que essa convergência regulatória ela é importante? Primeiro, como eu falei, para impulsionar essa descarbonização, né? Porque como a utilização de SAF e essas otimizações de eficiências operacionais, elas são feitas em diferentes países e são aplicadas diferentes normas e métricas, é importante que haja um alinhamento também dos objetivos de cada uma dessas jurisdições, né? Porque se não houver essa harmonização, vai ser difícil, inclusive, de implementar as metas colocadas no Acordo de Paris, as metas colocadas pela ICAO, que é a Organização de Aviação Civil Internacional. Então, isso tudo precisa ser feito de uma forma a garantir esta harmonização. Isso vai permitir, como eu falei antes, a questão do fomento do mercado do SAF, vai trazer previsibilidade no investimento e em uma segurança jurídica para os investidores na criação hoje do mercado brasileiro e internacional. Vai trazer um aumento de competitividade para o setor de aviação, principalmente no que quando a gente fala da aviação brasileira, né? Da aviação brasileira, porque é através do aproveitamento correto das vantagens competitivas que o Brasil possui na produção de biocombustível, que isso pode trazer para a gente esse aumento de competitividade dentro do setor. E aí, o que para a gente é importante é evidenciar os riscos de uma não implementação, de uma não convergência regulatória, que a gente pode ter várias distorções. Primeiro é a questão da fragmentação do mercado. Se você começa a ter diferentes regulamentações em várias jurisdições, você vai criar um mosaico de regras, e isso vai dificultar ou até inviabilizar, por exemplo, o voo de algumas rotas, né? Você vai ter que você vai criar uma dificuldade onde essa dificuldade vai inviabilizar por completo essas rotas. E isso pode ser também utilizado como uma forma de uma barreira comercial, né? Se você tem a força ou uma empresa que pode criar algum tipo de dificuldade, né? de uma competitividade, você pode começar a querer utilizar as métricas ambientais para criar uma barreira comercial para que a companhia aérea A, B ou C voe para o destino da América do Norte, da Europa, ou assim vai. Então, é importante que a gente atente a essas questões. A incerteza regulatória, ela pode também trazer um retardo até no desenvolvimento e no investimento do SAF. Pode trazer também um retardo na adoção de medidas que vão viabilizar a descarbonização do setor, e isso vai gerar o efeito negativo de a gente não avançar na descarbonização do setor. Os custos de conformidade também, porque se você começa a criar várias regras em diferentes localidades, a gente começa a ter, por exemplo, lá no Brasil agora, na discussão da Lei do Combustível do Futuro, foi ventilado a possibilidade de existir um SAF nacional para uso doméstico e um SAF internacional, né? Onde você tenha aí as conformidades diferentes para tentar acelerar, mas isso vai trazer um desafio, porque como que você vai fazer o controle desse cumprimento, né? Isso aí pode até gerar um potencial para multas e penalidades por não conformidade. A dificuldade da implementação do SAF, como comentei, as ineficiências na própria gestão de emissões, e isso pode levar às discrepâncias na contabilização de emissões até dos países, entre países, né? A aplicabilidade aí do artigo 6 do Acordo de Paris, isso não é interessante para a própria viabilização desse movimento de descarbonização mundial. Competição desleal, e aí eu já comentei um pouco da questão das barreiras comerciais, mas também eu acho que a gente precisa entender que nesse processo de descarbonização, muito é ligado à questão também da imagem, da reputação. Então, se você não tiver uma convergência regulatória, onde você possa ter todos esses elementos que eu comentei harmonizados, você começa a ter a possibilidade de ter greenwashing, de casos desses acabarem atrapalhando todo esse esforço de descarbonização do setor. Então, assim, eu queria só finalizar mostrando essa importância e aí deixar aqui uma reflexão, né, que é uma reflexão que a gente tem sempre colocado, né? Muito se diz lá no Brasil que a transição energética precisa ser justa e inclusiva. E a gente sempre pergunta para quem, né? Então, a gente sempre tem colocado que os passageiros que nunca voaram, eles não podem agora pagarem o preço daqueles que sempre voaram. Então, este é um ponto que a gente sempre gosta de finalizar para a gente trazer realmente essa reflexão e poder movimentar, já que a Latam especificamente está muito comprometida com esse desafio da descarbonização e da transição energética.
Thank you.
I just want to take a picture because it's very important to me. No, I want you to go first, please.
Okay, here I go. You want a picture of the panel? We need a picture of you on the panel. There. No, you're not the only person who has had to leave, so.
Thank you.
And thank you for your participation.
Sorry for answering.
Thank you so much, Eduardo. Muito obrigado, Eduardo. Esses highlights foram essenciais para que nós pudéssemos perceber como efetivamente o setor da aviação tem se movido, porque por mais que se fale de transição energética em todo lugar, é um pouco raro vermos o setor de aviação ser incluído nessa conversa e ter a oportunidade de explicar o que tem sido feito efetivamente. O Brasil, para muitos aspectos, está muito à frente do tempo e, em relação a esta transição energética, nós pensamos que é um desses aspectos. E eu gostaria de ouvir do professor José Ronaldo o que teve na base desse crescimento exponencial das energias solar e eólica no Brasil e qual tem sido o papel do parlamento ou quais têm sido as atividades parlamentares que influenciam ou têm influenciado nisso. Obrigado.
Obrigado, Sofia. Obrigado, professor Dom. Oferecer essa grande oportunidade aqui, desculpa, para a gente discutir em tão alto nível. As discussões estão sendo muito, muito produtivas. Pena que a Natália não pôde ficar aqui para discutir mais com a gente. A gente começou do micro e está indo para o macro agora. Tá? Eu vou dar um panorama mais geral da transição energética, particularmente no caso brasileiro, e vou começar falando que a gente muita gente fala, a gente já está avançado, tá, mas quanto? Quais são os números? Então, vou trazer alguns números aqui sobre a produção de energia no Brasil, particularmente energia elétrica, tá? Se você olhar a energia como um todo, levando em consideração petróleo utilizado em transporte, etc., a gente tem mais ou menos meio a meio de renovável e não renovável, tá? Embora nesse renovável entre até a lenha tradicional, tá? Porque ainda tem para cocção no Brasil o uso de lenha, tá? E não é tão pequeno quanto a gente imagina, diminuiu muito, mas ainda existe. Bom, mas olhando para energia elétrica, a gente tem hoje, tá, 87% da nossa capacidade de geração de energia elétrica em energia renovável. Era, em 2015, 80%, passou por 87% em 2024. Mas a geração de energia elétrica no ano passado, no ano retrasado, já, a maior parte, mais de 90%, foi de geração com energia renovável. Tá? Então, mais de 90%, o que até permitiria, usando o critério da União Europeia, que se produzisse hidrogênio verde pegando a energia do grid. Tá? O problema disso é que se algum ano a gente tem pouca chuva e precisa usar muita térmica, aí você vai baixar de 90%, aí você pode ter um problema. Então, não dá para contar com essa questão. A gente tem, no caso brasileiro, muito potencial para explorar a nossa transição já feita, né? Na verdade, a gente nem teve uma grande transição, porque a gente já começou com a hidrelétrica com grande participação, então, nosso caso é bastante diferente. E a gente tem outros potenciais, tá? Só para pegar a carona um pouco aqui no que vocês falaram, até a Natália e você, no próprio estado de São Paulo, a produção de cana-de-açúcar, a produção de álcool e de açúcar, você gera muito CO2, que você pode usar como rota tecnológica para a produção de hidrogênio e para a produção de SAF. Né? E isso é um enorme potencial, não é pouco. Tá? A gente pode até vir a ser exportador de SAF. E aí eu acho fundamental essa questão que você mencionou, da padronização. Não tem menor sentido não padronizar. Tá? E aí eu vou falar um pouco depois, mais no final, da nossa criatividade legislativa, que muitas vezes gera problemas. Tá? Mas voltando aqui para os números mais gerais, então, em termos de energia renovável como um todo, a gente passou de 80 para 87, mas o que foi isso? O que aconteceu? Hidrelétrica era, em 2015, é pouco tempo, né? 10 anos, 65% da capacidade produtiva de geração de energia elétrica no Brasil. Porém, a gente não tem mais como crescer fortemente a produção de energia hidrelétrica, mas, enfim, por conta de questões ambientais, etc. Dá para melhorar, repotencializar usinas, etc., mas o potencial não é tão grande assim. E aí o que acabou acontecendo foi que o aumento, né, na margem não foi por via de hidrelétrica, então a hidrelétrica ainda representa um percentual muito grande, qualquer comparação internacional, tá? Acho que só o Canadá talvez tenha uma coisa parecida, enfim, mas acho que o Brasil é o maior, o Brasil, em termos de países grandes, é o maior nessa área, então saiu de 65% a 45% no ano passado, tá? Mas em termos de geração foi mais do que isso, porque estava com bastante água nos reservatórios, então ainda é cerca de metade aí da capacidade produtiva, mas em queda. Tá? E o que aumentou? Bom, em 2015, energia eólica era 5%, energia eólica foi o primeiro dessas energias alternativas a crescer no Brasil. Hoje em dia já passou de 5,4 para 13,2, bastante. Mas a energia solar, que não era nada, era 0%, né? Era irrisório, era experimental em 2015, hoje são 22% da capacidade produtiva de energia elétrica no Brasil. Embora essa capacidade, você tenha um problema que ela só gera quando tem sol, né? Então, aí a gente tem uma série de problemas relacionados à tecnologia e o gerenciamento dessa energia, né? O gerenciamento dessa energia solar é extremamente complicado, porque você tem um negócio chamado curva do pato, que aí, durante o dia, você está gerando muita energia solar, pouca demanda. Quando a demanda por energia explode, essa energia para de ser gerada, e aí tem um crescimento de demanda muito grande. Muitas vezes tem que despachar as usinas térmicas antes para evitar um colapso do sistema. Tá? Então, não é nada trivial, é algo que as baterias ainda não são uma tecnologia factível para uso em larga escala, são só para lugares mais isolados, né? Então, a gente tem essa questão aí. Em termos de termoelétrica, no Brasil, hoje, é menos de 20% da capacidade produtiva, porém, tem uma função bastante importante, porque quando você tem algum problema, ou quando você tem falta de água, ou quando você tem qualquer problema na gestão do quanto está sendo gerado de energia, você liga a térmica muito rapidamente, e essa é uma flexibilidade que a térmica dá, que outras fontes não vão ter. Tá? Então, não dá para desprezar a importância também da térmica. O que se diz muito é que o gás natural pode ser um meio do caminho aí para essa transição. Tá? Bom, então, dito isso, esses números mais gerais, agora vamos para o que aconteceu. Por que, então, que esse tipo de energia, primeiramente energia eólica e depois energia solar, cresceu tanto no Brasil? Aí eu vou aqui fazer a gente vai chegar no que esse simpósio faz muito bem, né, que é essa conexão com o mundo do direito. Eu que sou economista, mas estou aqui falando sobre essa conexão do direito à economia. Bom, houve muito incentivo, leis foram criadas no Brasil para incentivar o crescimento desse tipo de energia. Particularmente, em 2002, começou um programa de incentivo chamado PROINFA, mas o crescimento efetivamente veio a partir de meados dos anos 2010. Aí que houve um crescimento mais expressivo. E a energia solar distribuída, o grande crescimento foi a partir de 2020. Eu vou entrar agora em temas polêmicos aí, em termos de legislação, de subsídio, tá? Mas eu acho importante a gente colocar, assim como você colocou a questão, né, do acesso à população, né, porque o preço aumentando, você diminui o acesso. A gente também tem que comentar sobre os efeitos da política e se a política de incentivo ela tem que continuar, se é o ideal ela continuar agora, se está bem dosada, né, porque a política pública, o grande desafio é muitas vezes dosar essa política. Às vezes você tem uma ideia de política pública, mas aí aquela política pública vai sendo postergada, e aí você vai tendo um problema. E eu vou trazer bem essa questão aqui. O que aconteceu que foi esse desenvolvimento tão grande? Foi a adoção do net metering, né, no Brasil, que você produz energia na sua casa, não está consumindo, você coloca no sistema. Isso gera alguns problemas, tá? Isso incentiva a pessoa a instalar, porque daí ela vai conseguir remunerar aquele ativo que ela investiu. Porém, você tem um problema aí que primeiro, muitas vezes essa companhia distribuidora de energia já comprou energia em leilões de longo prazo e não precisa daquela energia. Então, isso é uma despesa que ela vai ter que fazer, que vai onerar o consumidor dela. No fim, é isso que acaba acontecendo. Tá? E muitas vezes, aliás, muitas vezes não, a venda dessa energia, por legislação, ela é uma venda por um preço elevado, porque ela é como se fosse um preço final da energia, o que inclui ali tarifas que não deveriam estar no preço da energia, deveria ser o preço da energia, para ser correto, tecnicamente. Tá? E esse consumidor que instala, ele vai ter desconto das tarifas de transmissão e distribuição. Então, você tem aí um grande, digamos, incentivo que fazia muito sentido quando começou essa questão, porque era economicamente inviável investir em energia solar. Era muito caro. Tá? Aí, bom, o que aconteceu? Agora, só para falar alguns números de potência dessa energia, essa geração distribuída que chama. No Brasil, a gente chama de GD. Tá? No setor se fala GD. Saiu de 3 megawatts em 2013 para 36 mil megawatts em 2024, ou seja, 36 giga. O número de consumidores eram 183 em 2013, passou para 3 milhões em 2024. A geração efetiva de energia era 2 giga em 2013, passou para 30 mil giga em 2024. Então, assim, um crescimento realmente muito, muito expressivo, muito grande dessa geração de energia. E como você tem subsídio e é subsídio cruzado, a gente vai ter algumas patologias geradas por essa estrutura de incentivos que foi criada, e é o que a gente tem visto muito essa discussão. Bom, só para vocês terem uma ideia, no ano passado, das novas usinas que foram instaladas no Brasil, né, capacidade nova de geração de energia elétrica, 77% da capacidade nova de energia elétrica no ano passado foi de plantas solares. Tá? Desses 77, 48% de geração distribuída e 29% de geração centralizada. Tá? Então, assim, e o que aconteceu? Por que teve esse crescimento tão grande nos últimos anos? O governo mudou, a legislação impôs um phase-out dessa política, né, dessa política de incentivo, e aí quem fizesse esse investimento agora manteria os 100% desse incentivo, desse desconto de tarifas, e aí houve um grande impulso do investimento nos últimos anos. Junto com esse impulso no investimento, houve também um aumento do subsídio cruzado, né? Quem paga são os outros consumidores que não têm energia por essa fonte. Esse subsídio, esse é número da ANEEL, tá? Foi o número que eu estimei, era 60 milhões em 2018, passou para 11,6 bilhões em 2024, tá? Bom, o que isso significa? Isso significa muito mais subsídio do que, por exemplo, a tarifa social. E quem que, em geral, é o beneficiário desse tipo de política pública? As pessoas com renda, em média, pessoas com renda mais alta. Então, hoje a gente tem um subsídio muito maior para pessoas com renda mais alta do que o subsídio que é dado para as pessoas com renda baixa. Tá? Então, isso é uma questão que tem que ser falada, que tem que ser discutida. É um problema de política pública que onera a tarifa de energia brasileira, tá? Embora tenha os efeitos positivos. Não estou falando contra a energia solar, não é o meu ponto aqui, eu estou trazendo um contraponto ao lado bom de você ter aumentado, ok, só que a gente tem que fazer de forma sustentável. Esse é o meu ponto aqui. Tá? O payback em 2013, né, o tempo que levava para você rever um investimento desse era 20 anos, em 2013, e em 2023 era 3,2 anos. Ou seja, muito rapidamente você paga esse investimento. Para completar, vou falar sobre uma pesquisa que eu fiz com uma equipe da FGV Direito Rio. Tá? A gente tem lá um núcleo de estudos de transição energética e a gente estudou todas as proposições legislativas feitas no Brasil no período desde a Constituição de 1988, buscando o que era relacionado à transição energética. A gente olhou 35 mil proposições legislativas, o pessoal lá é bastante ativo, né? Como foi dito aqui ontem, especialmente. Dessas, depois de fazer busca por palavra-chave, usando, enfim, machine learning e outras coisas, a gente passou para 2.500 proposições, parcialmente relacionadas, aí a gente fez outros filtros, chegou a 540. 540 proposições legislativas nesse período a respeito de transição energética. É bastante coisa, né? Eu acredito que sim, se a gente fizer uma comparação internacional, acredito eu que deva ser bastante. Dessas proposições, tá, a maior parte das que eram identificadas com algum tipo de produção específica, a maior parte citou energia solar, tá? 153 proposições legislativas. Biocombustível, 120, por aí vai. Dos assuntos que foram tratados sobre energia solar, nessas proposições legislativas, a geração para consumo próprio, foram 79 dessas medidas eram a respeito de geração para consumo próprio, que é a geração distribuída. Tá? Outro número que eu acho bastante interessante é isso. Dessas medidas, tá? O que era para a energia solar, o que em geral era o que mais se colocava nessas medidas, nessas propostas de lei? A maioria é a criação de benefício fiscal. Benefício fiscal, programas, fomento, etc. Tá? Então, depois de dissecar isso tudo, o que é a minha conclusão? Minha conclusão é que cresceu muito a fonte de energia, o que é bom, mostra o nosso potencial, mas a gente tem uma situação agora que a gente precisa avaliar o tamanho desse subsídio, o impacto desse subsídio em termos de política pública e entender que isso trouxe junto uma atividade legislativa bastante intensa, voltada para manter ou ampliar esse tipo de benefício. E a gente tem que estar atento, porque esse tipo de benefício pode criar distorções no setor elétrico que podem nos prejudicar em termos de competitividade internacional, se a gente quer ser exportador, em alguma forma, seja como bem, de energia limpa para o mundo, tá? Particularmente para a Europa. Então, eu acho que essa é uma questão que a gente tem que estar muito atento, porque é óbvio que é fundamental a gente caminhar para uma energia mais limpa e ser um player internacional nessa área, mas tem que ser feita de forma sustentável que permita que a gente seja competitivo também. É isso. Obrigado aí.
Muito obrigado, professor José Ronaldo, por trazer essa abordagem tão rica e ajudar os juristas a mergulharem um pouco nos números, né? Que não é tão comum para os juristas. Muito obrigado. Agora vou passar a palavra para o Greg. Greg speaks Portuguese very well, maybe better than me. Maybe better than me, but he'll speak in English. And I would like to hear from you, Greg, your perspectives about financial agreement in the energy transition, especially focus on the capital markets. What roles the capital markets really plays when it comes to energy transitions. And also, we are doing business in Brazil, so what would be the best advice for investors, like what they seek or they avoid when it comes to investing in energy renewable?
Even though I do speak some Portuguese, there is no way I'm following a college professor and a head of public affairs after their Portuguese. I'll stay in English, thank you. I'm not going to match that. So thank you. My name is Greg Harrington. I'm a partner at the law firm of Arnold & Porter here in Washington. Our practice at Arnold & Porter, we've got about 1,000 lawyers around the US and in some offices in Asia and Europe. Here in DC, we do many things, but one of the things we do a lot of is sovereign finance. And we represent a number of the sovereigns, a number of the countries in Latin America in their financial transactions. We have represented the Banco Central do Brasil since 1985. Our firm was the firm that represented Brazil in all the renegotiations of the Dívida Pública do Brasil, Brady Plan, et cetera, nos anos 80 e 90. And we continue representing Tesouro Nacional in the issues of Brazil today. Recently, we closed a couple of issues for Brazil, ESG bonds, sustainable bonds of Brazil, which won numerous awards in terms of ESG and sustainable bonds. So I do a lot of capital markets work, but I think for these purposes, it's not just capital markets, which is really going to help in terms of energy transition. Capital markets can help, but there are other modalities that work even better for energy transition. I don't know who has the control of the slides. Is that me? Yeah. I'm probably going to turn it off, that I know. Okay. As you know, Brazil is a leader in renewable energies, as the other palestrantes have already demonstrated. But one of the aspects is the costs are very, very high. And when you're going to finance a project, there are certain limits that can be reached through the domestic markets. But when you get to larger and larger values, you really do need to begin accessing the international community, the international debt markets. I put up two examples for Unigel and Ceará, where they're spending 1.5 billion and 3.6 billion on green hydrogen. Those are prices, those are amounts which are very hard to finance 100% in the Brazilian domestic markets. Can it be done? Yes. Does Brazil have the domestic savings to do it? Yes. But at what price? And also, if it's going to be done at that price, what is the price for other transactions which won't have access to the capital? So if you're talking about a transaction in the billions or in excess of $500 or $1 billion, you really are looking at the international capital markets. But if you're doing that, what are the options available to you? Let's see if this works. Loans. obviously people think first of loans when they think of accessing and accessing capital. Well, loans are a terrific way to do it. There are tremendous people and tremendous institutions, BNDES, obviously, but the IFC, the World Bank, CAF, the IDB. There are numerous, in the United States, DFC increasingly, there are numerous players involved. And then there are the private banks as well, especially the international private banks and especially the European banks, which, when you talk about energy transition, are incentivized by their national laws to invest heavily in renewable energy. The problem with loans is they only go so far. The nice thing about a loan is you have somebody across the table you can negotiate with. If you need a waiver, you have somebody to talk to. If you need to skip a payment, skip 2 payments, you have somebody that you can negotiate with to make that happen. Will they always want to do it? Possibly no, but at least you have somebody across the table in a relatively simple financial instrument to talk to get it done. There are also modalities that are increasingly interesting modalities. I'm thinking sustainability-linked loans, where, for example, and this works very well for things like green hydrogen, where you might get a break, a discount in your interest rate if you hit certain key performance indicators. So let's say you hit a sustainable goal. Let's say you have been able to, for your state or your region or for your company, reduced your consumption of non-renewable energies. Well, maybe in that case, after a certain period, your interest rate goes down. Or if you have not hit that, your interest rate goes up. Now, that works very well for renewable energy. It also works for numerous other things in ESG, your board governance, your gender equality, your environmental pollution, numerous areas where sustainability-linked loans, but also sustainability-linked bonds have been used for ESG matters, including renewable energy. So loans are good, but they have their limits. They're very flexible, but they have limits in what you can do with a syndicated group of banks because banks have their own capital requirements and take a hit for the loans that they give. The more likely suspect, if you will, is a project finance. A project finance is a very complicated financial transaction. The number of contracts that you will see will be 4 or 5 times greater than a standard loan. But the very basics of a project finance is a sponsor, large corporation typically, comes in and wants to do a project. Like Unigel, they want to build a green hydrogen plant. They are the sponsor of it. The financiers come in, and what do the financiers get? They want to come in not based on a corporate guarantee of Unigel, which they would love to have, but for a project finance, they don't get a corporate guarantee. Their return is based on what the hydrogen, or who the hydrogen will be sold to, the off-taker. And so the company or the person or the entity which is going to buy the product ultimately is what finances this. So that off-taker comes in, collateral package on top of the shares of the company, on top of the assets, on top of the cash flows, et cetera. That is a project finance. That is the best way in the international markets to finance a large project. There are some issues though, however. If it is a commodity that is a dollarized commodity, it is much easier because you can match the cash flows of the loan with the cash flows of the production. If you're talking about something that sells, for example, into the grid in reais in Brazil, if you're going to build a large hydro, and I remember, it was interesting, I remember visiting Itaipu when it was under construction in 1982. And I thought at the time about just the turbinas that were going into Itaipu and the amount of cement in construction, the water, the reservoir along the river, the amount of money that was spent on Itaipu today, it wasn't at the time, would be a project finance because you're not going to do an Itaipu today on any other modalidade other than project finance. But that electricity, part of it sold into Paraguay, but most of that is sold into the grid in Brazil in reais. If you were going to finance Itaipu today for billions and billions of dollars, and your offtake was going to be sold into the Brazilian domestic market, you have a mismatch between the reais being sold and the dollar obligations. And who assumes that mismatch in interest rate risk? So project finance has its own difficulties when you're talking about cross-border. So that's project finance. Then you have the domestic and the international capital markets. That is a great source of fairly quick money. For many years, I remember doing the transactions for Eletrobras and for CESP in the state of São Paulo between 2000 and 2007. You can do a capital markets transaction very easily, but a capital markets transaction, you don't have anybody across the table to speak to if you need adjustments to what you're doing. So you can hit the capital markets. Brazil, for example, Tesouro Nacional issued out over $4 billion in bonds a few months ago. That transaction we were able to do in 6 days because it had disclosure, it was ready, it could hit the market. Brazil could do a sustainable bond issue today and it would close by the end of May because it's ready. So the capital markets, the money is available. But if you need to make an adjustment, if you need to have anything other than a regular interest payment, anything that goes along, it makes it much more difficult to adjust it because what do international investors want, which Edwin asked? Well, they want predictability. The debt capital markets, they want predictability. They don't want to give waivers. So those are the basic modalities. But what ultimately do investors want? They want projects that are bankable. They want projects where, and this is something more for the regulators in the room and for those that are working with governments and structuring the laws and the regulations that are necessary for transition. You might have the most beautiful plan in the world to create green hydrogen, to create a transport network, to create anything you want. But if you haven't thought to make that project bankable, financiável, where a bank is willing to come in and put money into that, where the bank knows that it's going to be able to get its money out at the end. I remember some 10, 15 years ago, Brazil was sending up large, remember the PAC, Programa de Aceleração de Crescimento, etc. Send people up here with beautiful programs that the government had created without giving a single consideration, in my view, as to whether they were actually bankable projects. So the government had its goals. It even had a return that it wanted the investors to have. Those projects were not bankable. They weren't realistic because an international bank, financiers, were not going to put their money down if somebody else had decided their return, and nobody, when they were drafting the rules and regulations, had thought as to whether an international bank, an international investor, would be able to put its money into those programs. So a transaction to be successful when it's being designed has to be bankable. What is bankable? Well, a stable cash flow, if possible. They want a predictable cash flow. They want to see what it is. Even if it's in reais, if it's in dollars, whatever it is, they want to know. It has to be predictable. It doesn't have to be guaranteed necessarily. Guaranteed is better, but it has to be predictable. They need to know what they're getting into. I sometimes think of, if you're getting into a boat next to a pier, are you going to get into the boat that is stable or the boat that is bouncing up and down? If you had to get into the balsa going to Ilhabela, are you going into the balsa that's bouncing up and down or the one that's nice and stable? You got to get into the one that's stable. They want stability. They want sponsors. I mentioned Unigel before. They want sponsors who are experienced and know what they're doing, sophisticated sponsors with good reputation. They want, and they're here, so the governments, they want to know that the regulations work and that the regulations aren't going to change in the middle of the transaction. They want economic and regulatory stability. They want risks that they can identify and mitigate. And those risks in a project finance, typically, whichever party is best able to manage the risks is the party that should assume the risks. So if the government controls environmental regulation, well, it becomes the government's problem if it changes its environmental laws, not the sponsors, because it's the government that controls the laws. If it's an off-take issue, who should assume the off-take risk? Well, somebody from the off-taker side should assume that risk. So that contract with the off-taker should be adjusted. So the risks are allocated to the party best able to assume them. We have other things here, but at the end of the day, these things have to be thought through so that the transaction is bankable and thought through, not just by a government official or a corporate official who wants to do a project, but thought that who is going to finance this at the end of the day. And there's some investors, what they do not want. And I think these are questions that most of the lawyers here will understand fully. They don't want instability and regulatory doubt. They want to know that the game that they're getting into when they put their money in is going to be the same game on the way out. Some of you may be here on student visas. You will know this incerteza on your student visa from the past couple of months. Well, if you were going to be an investor in a project abroad, that incerteza is not something that you're going to want when you're putting down $5 billion. It's one thing when you're coming up to the United States for a year and you risk your student visa. It is not something that you're going to want if you're putting down billions of dollars in an international project. They want as little bureaucratic complexity as possible. They want to know who is their point of contact, they want to know who it is, and they want to know what are the flexibilities and who they talk to if something goes wrong. One concern is always judicial slowness. How long does it take to get questions resolved? I was speaking right before the panel with, it was Andre, right? We're talking before the panel with the TCU and the arbitral panels and the mediation panels that the TCU has implemented. Brilliant, brilliant idea, because you have a predictability. I don't know how they work in practice. To me, the idea, the concept was brilliant. You have somebody that you can talk to, you have a mediator, and ultimately the government official can look to the TCU for certainty as if the regulator is going to reach an agreement, the regulator and the company are going to walk away knowing they have a secure agreement. They don't want tax instability, and they don't want political interference. Fortunately, you come from a country where the advantages far, far outweigh the risks. And so as you're going through the development of the renewable energy market in Brazil, while investors may look at all those risks and evaluate them, ultimately, when it comes to the case of Brazil, they're greatly outweighed by the advantages that companies and investors look at when they're going into Brazil. Here's a list of some of them, but I think they're obvious from other folks that have spoken on the panel before me. And that was it. Thank you.
Thank you very much, Greg. Thank you very much. We're behind the time. So I don't know if anyone has one question, at least. But thank you so much for joining us. And I hope our best day for the one who are staying for the next panel. Thank you.
Well done. And thank you. Thank you very much. You know, I'm sure. Maybe we've got some. Well, it's also difficult to run this desk, but that's over him, work this out. I'm getting like that. Thank you so much. And they would book this straight. Yeah, no, they were fourth, but they were all right. It's a tip of the spear in some ways, right? I mean, and it can get things, it's very, They can get his steel stuff. Yeah, it was like the first month.
Yeah. I'm not working on that. You've got your gift side. I know nothing about that. I know nothing about that. Oh, we have representation.
Congratulations.
Thank you. I'm glad we got that.
It's very interesting. Regulatory risks is changing, regulatory norms. Those are the maybe the biggest impact. Now, for example, if there are lawyers of ISA, ISA is a
Colombian.
exactly.
Electricity transmission.
And the discussion in ANEL, the electric agency, they want to change the rule that has been changed already 10 years ago. And this, when you do a 30 years investment, you must have a.
There have been changes, right? But they have to be, who pays for them?
Yes.
Are they preserved? And that's sort of the stability clause, right? You can change the laws all you want, but you pay for it.
Yes.
Right? As long as my return doesn't affect my return, you can do what you want.
Yes.
Right? There's a famous story of, I used to work with law firms, Sullivan and Cromwell, a large New York law firm. And Sullivan died early, but Cromwell was still there for many, many years. And he was long since retired and living in Paris. And at the end, people said a delegation of lawyers, John Vallis and others, they said a delegation of lawyers to speak with Mr. Cromwell in Paris. And they said, Mr. Cromwell, just want to say the partners have gotten together. We think we have to change a little bit the financial arrangements and the partner distributions since you're retired. We need to change things around. And Cromwell said, what you guys do with your half is not up to me. And that was similar, right? With the sustainability. Do what you want, but leave me home.
Yeah, that's
how are you? Right.
Nice to meet you. Nice to meet you.
Hi, I'm Leah.
Congratulations.
Thank you.
I don't mean to keep you. I just want to say I was really impressed with your presentation. I'm not personally Brazilian.
Where are you from?
I'm from Bulgaria, but I'm very interested in I'm doing energy and infrastructure. I worked in Paris for a number of years, and my husband is Brazilian, so I have a lot of.
Oh, is he? Okay, all right.
Yeah, I lived in Brazil for a while, and I was very interested in your presentation, specific examples. And I'm back in DC. I graduated from Georgetown about 5 years ago, and I'm trying to see how the energy infrastructure scene is in DC nowadays. And I was wondering whether it would be okay for me to reach out to you at a later time.
Of course. Please.
Yeah.
Please.
And to ask you some advice, maybe.
Of course. Let's we can have some coffee at the office.
Absolutely. Thank you so much. Wonderful. Then I'll get in touch with you.
Please, we can have coffee up there.
Wonderful. Thank you. Your office is really beautiful, so I know from experience.
How are you, sir?
I've had a wonderful time this experience. I graduated from Duke LLM in 2023, so I'm always like been around energy and infrastructure. Published a couple of articles on finance. I specifically came for this section because of
Oh my goodness! Oh no! Sorry about that. Sorry to disappoint. Sorry to disappoint.
Well, it was really great. I love your insights. It's wonderful to learn about all this financing.
Well, that's the mismatch, right? The mismatch between what the regulators put together and what actually is sellable in the market. And I think one of the things that the government sits among themselves and comes up with these plans and comes up with these stuff. And I remember when this tech program was presented, and I said, this is the world. Why are there returns? What are you doing at the foreign exchange risk? What who's the auction here? What have you thought about this? No, that's what we want. Right. Okay, I understand that's what you want. But you want somebody else to pay for it. And you talk about who's going to pay for it and whether they want to pay for it. And you can set up all the ministries you want. You can set up your entire cabinet. But if you haven't had somebody think about it, who's going to fund it? And what the stars make sense. No, but there's no point to even my comment.
But how's it like going for you in terms of like restructuring, especially given some of those risks? That's where you come in and you seem to advise either like the buyer, the financier, sponsors, or like how are you able to like balance your expertise from the legal perspective, the risk side of things, because it's financing.
That is a division, right? I mean, you've got the bankers who look at things from their point of view. They've got a very distinct point of view, right? And the lawyers look at it from another point of view. And the lawyers, we don't write the check. Right? We don't make the profit. We don't disperse funds, right? We just advise on the risks and what they're going through or whatever. Then they make the decision. Right. But also they make the decision that has to be executed. They're not just going to write a check and go on the merry way. Right. And they also have, are we no, I think like that. And then, mas me vem Rubem.
I'm Nigerian.
Oh, okay.
English.
Okay. All right.
Yeah. Well, nice to meet you. Champion? Yeah. So, well, I guess you're busy and you're probably.
Similar in size, population, but the way they in many ways dominate to some extent their own continent, right? Are biggest, most emotional power, you know, but so it's the Nigeria-Brazil connection. I mean, obviously Angola and Portuguese, but Nigeria is an interesting comparison in many ways. It's just that the opportunities and studies are.
Have you had any opportunities to
I've done some work also, but not it was just actually smaller countries in Congo, Brazil, looking at something in a lot of it's going on up here.
Yeah, let's connect. Maybe one of these days I could shoot you an email and I can talk to each other something. That'd be great. Appreciate it.
Nice to meet you.
Thank you.
All right. Eu estou bem. Brasil que escolher, né?
Amiga, essas águas pode ser misturada, né? Pode. Essa vai fazer. Vai ter presente?
Ah, tem?
Mas vamos chamar logo.
A última coisa que eu quero é falar.
Não, tudo bem, é porque me chamaram uma. Eu vou falar aqui rapidinho. Aí eu chamo.
Ela vai te apresentar.
Não, mas eu não quero que me apresente,
Não,
perder
então-
tempo
então
com isso.
já
Pode
começa.
deixar que eu vou começar. Eu começo e aí ela vem apresentar os speakers, tá bom? Não, eu sei, mas é só pra não perder tempo. Tá bom.
Se te chamar em 2 minutos também.
Você vai começar e é pra ler tudo, né? Eu vou começar e aí eu te chamo.
Tô aqui falando no microfone, mas é pra ler tudo.
Aí aqui, ministro, Neto, Rebeca e Juliana.
Não vou tirar mais ninguém, porque não vão. Cadê a fotógrafa?
Se você achar que vai ficando meio longo, se quiser tirar. Eu também não sei, né? Ah, pode ser. Peraí.
O Fernando, a Messias. A Rebeca, não, só vamos tirar foto do painel, porque se o ministro precisar sair, porque antes ele vai precisar sair, a gente já tira a foto do painel lá.
Tá bom.
A gente vai tirar a foto oficial. Murilo, você quer tirar a foto do painel? A gente vai tirar antes.
Olá, como vai?
Vamos tirar uma foto do painel? Vamos. O bom é que esse painel tem muitas mulheres, vai ficar intercalado. Não fica não fica um painel só de homem, né? Enquanto tem um painel que só fica um homem na foto, eu acho que hoje.
Some of they change things.
Fechou.
Só isso aqui e o final.
This is what we're making changes now. We take the photo before, when everyone is still here.
Tem que tirar depois, não ficou.
Peraí, don't. One second.
Karen wants to stay with us.
What they should do, we should just call it quits. It looks really good right now.
Okay, we have enough pictures.
Thank you. Good afternoon, and thank you all for being here today. We will discuss the use and challenges of alternative dispute resolution in the context of public administration in Brazil. So before we begin, I'd like to briefly introduce myself. My name is Karen Fácil Wilber. I did my law degrees in Sorbonne Law School in Paris. Then I came to Georgetown a few years ago for my LLM in International Legal Studies. Concentration in international arbitration and dispute resolution. While at Georgetown, I co-founded and served as president of the Georgetown Brazilian Law Association, BRASLA. So I'm very happy to be back here for this event. So Giovanna will present here the speakers. Here, you can just talk about the mediation too, if you don't mind. Okay. Mediation, conciliation. Isso, você pode falar sobre esse painel. E aí apresentei.
Hello, everyone. Thank you for being here. Our panel about mediation, conciliation, and arbitration have become important tool to promote efficiency, reduce costs, and help resolve disputes involving public entities. In this panel, we explore regulatory developments, practical experience, institutional challenge, and future perspectives for expanding the use of ADR in both administrative and judicial contexts. Our panelists, first, Minister Jorge Messias, so Minister of the State and Head of the Attorney General Office of Brazil, a distinguished legal expert and public administrator. Minister Messias brings over 2 decades of experience in the Brazilian public sector. He holds a law degree from the Federal University of Pernambuco and a master's and PhD in Development Society and International Cooperation from the University of Brasilia. He began his career at the Caixa Econômica Federal and later served as attorney for both the Central Bank of America and National Treasury. Appointed Attorney General of Brazil by President Luiz Inácio Lula da Silva in 2023, Minister Messias continues to shape the national legal and policy landscape. Our second panelist, it's Fernando Falcão. So Fernando is auditor at the Brazilian Federal Court of Accounts, TCU, where he serves as an advisor of the Department of External Control for Mutual Agreement and Conflict Prevention. He received his LLM in International Business and Economic Law with a concentration in Securities and Financial Law from Georgetown University Law Center. We also have Rebecca Albuquerque. She's a distinguished lawyer and political scientist with over 20 years of experience in regulatory public law and public policy. She's a graduate from University of Brasilia and a specialist in legislative procedure and corporate compliance. She's also a partner at the Paula Craft Advogados, a member of OAB Dev Council, and a licensed to practice law in Brazil, Portugal, and Italy. Her extensive background in both public administration and private advocacy makes her a leading voice in the intersection of law, policy, and dispute resolution. So last but not least, Juliana Loss. Juliana is the Executive Director of Mediation and Arbitration Chamber at Fundação Getúlio Vargas, one of the Latin America leading think tanks. Juliana holds a PhD from University Paris I, Panthéon-Sorbonne, and a Master in Dispute Resolution from University College III de Madrid. She's an experienced neutral in arbitration. Mediation plays an active role in shaping ADR practice in Brazil. So, Karen, the word's yours. Thank you.
Olá, olá. Obrigada. Senhor ministro, boa tarde. Todos me ouvindo? Sim. Se o senhor pudesse falar um pouco sobre a agenda de desjudicialização da AGU, por gentileza.
Bom, muito boa tarde a todas e todos. Eu queria cumprimentar a audiência tão prestigiada na pessoa do querido amigo que me fez o convite, Murilo. Murilo, é sempre um prazer estar contigo. A gente sempre aprende um pouco mais e é uma experiência sempre muito agradável. Cumprimento também a plateia na pessoa de um querido amigo, uma pessoa que eu tenho muita admiração pessoal, que é o CEO da Atlas Intel, o André Roman, está aqui conosco. E eu quero dizer que o acerto do tema é total. E digo que o Brasil hoje caminha a passos muito largos, não só na Advocacia Geral da União, na advocacia pública, como em outras instituições, em outros segmentos, principalmente do setor privado. Mas a gente precisa olhar ainda dentro de uma perspectiva do tamanho do desafio que nós temos. Quando nós olhamos o quadro do desafio da judicialização no Brasil, e os últimos números são muito preocupantes, a gente precisa encarar de frente isso, a gente tem aí a dimensão exata do que temos de fazer ainda, como eu digo, sociedade, porque esta é uma tarefa que não pode ser exclusiva do Estado nem dos poderes constituídos. Essa agenda ela precisa ser compartilhada por todos os setores, digamos assim, da sociedade, o setor econômico, a advocacia privada, a defensoria, o próprio Ministério Público. Vou falar um pouco mais sobre isso logo daqui a pouco. O Brasil é um país que tem 83 milhões de processos, segundo o último anuário da Justiça. De 2020 para 2024, nós tivemos um aumento da ordem de 43%. De 23 para 24, 10%. 38 milhões de processos entraram em 2024 no Poder Judiciário por diferentes portas da Justiça Federal, Estadual do Trabalho. Isso o país tendo feito a reforma trabalhista, tendo adotado uma série de mecanismos de solução alternativa de controvérsias, tendo construído uma agenda de redução de execuções fiscais via protestos. Enfim, todas essas iniciativas foram insuficientes para que nós pudéssemos ter aí uma queda no número de ajuizamento de novas ações no Brasil. E aí nós, quando olhamos o quadro da litigância, nós identificamos alguns setores chaves, né? Então, você olha o setor trabalhista, ainda é um setor muito relevante, o setor tributário demanda muita atenção, o setor de saúde, por óbvio, né? O Brasil
tem uma demanda de judicialização na saúde em razão do próprio modelo, tanto público quanto privado, né, de acesso, e uma série de agendas de questionamento, tanto do setor público quanto do setor privado. Na matéria administrativa, um nível muito elevado de processos ainda na matéria administrativa de pessoal, isso aí mais identificado no âmbito dos estados e municípios. Enfim, esse é o quadro que nós temos que lidar dentro da Agenda Nacional de Litigância. E me preocupa, em particular, quando nós identificamos o avanço que o Brasil teve em relação ao Conselho Nacional de Justiça. Está aqui o doutor Luiz Fernando Bandeira, que foi nosso conselheiro, fez, aliás, um trabalho extraordinário como conselheiro do CNJ. E nesse período de 20 anos que nós conseguimos construir uma ciência da jurimetria voltada à cobrança do judiciário na entrega da efetividade da prestação jurisdicional, com indicadores, com metas, com avaliação de desempenho, isso tudo associado a uma agenda de transparência ativa para que toda a sociedade possa fazer esse controle. E nós não conseguimos ainda colocar esta curva numa trajetória descendente. E nós não temos um crescimento populacional, por assim dizer, que justifique o número do crescimento de processos. E o que é que está acontecendo, então, no Brasil, para que o Brasil tenha um número tão expressivo de judicialização nos últimos anos? Essa eu acho que é a grande questão. Eu tenho apontado alguns temas que sugiro, assim, como reflexão, para que dentro dessa reflexão a gente possa, de fato, endereçar isso na construção do que eu chamo um grande pacto nacional pela segurança jurídica. E aí, dentro desse contexto, nós precisamos endereçar o primeiro eixo, que é o eixo da desjudicialização. No Brasil, é bem verdade que nós estamos lidando ainda com uma série de instrumentos que são instrumentos próprios da agenda de democratização que o país passou. Nossa Constituição tem 36, vai fazer 37 anos. Era um momento em que o Brasil tinha um fechamento muito significativo, as pessoas pouco acessavam o judiciário, e a Constituição de 88 entregou muitos sonhos para a sociedade. E esses sonhos passaram a ser, obviamente, demandados pela sociedade, e direito à saúde, direito à educação, saneamento, seguridade social, pela previdência social, pela assistência social em relação aí a LOAS, ao benefício de prestação continuada, essa porta larguíssima que o judiciário abriu em 88, em decorrência do Estado Constitucional, que se inaugurou em 88, essa porta nos trouxe essa realidade que nós temos hoje. A gente precisa encarar isso. O modelo tributário que também foi, digamos assim, selecionado pelo Constituinte dentro desse modelo de repartição de competências tributárias pelos três entes, né, a União, os Estados, o Distrito Federal e municípios, trouxe também uma série de dificuldades próprias aí da disputa pela compreensão do que seriam as bases tributárias. Isso gerou uma série de problemas no judiciário, que o judiciário ainda hoje luta para responder a processos bilionários, né, que inquietam tanto o Estado quanto o particular, tanto o setor econômico. Agora, dito isso, eu quero dizer para vocês que nós estamos endereçando essa questão, na minha opinião, de uma forma muito madura. Na área tributária, nós conseguimos, evidentemente, um avanço muito importante com a reforma tributária. E, nesse momento, pela condução e liderança do ministro Luiz Roberto Barroso, o presidente ele esteve aqui ontem, tomei notícia, conversei com ele ontem, ele saiu daqui muito animado com a agenda que teve, Murilo. Ele, por nossa sugestão, ele inaugurou um grupo de trabalho para discutir o tema da judicialização na nova reforma tributária, com o conceito de justiça 4.0, para que nós não tenhamos um quadro de litigância como nós temos hoje. Então, é importante que a gente tenha em mente que nós já estamos cuidando do futuro, para que os erros do passado não venham a serem repetidos. E aí, nós também temos acessado alguns mecanismos muito, digamos assim, saudáveis do ponto de vista da geração da confiança da sociedade no Estado. Semana retrasada, eu inaugurei na Sejam, que é a Câmara de Promoção da Segurança Jurídica para a Melhoria do Ambiente de Negócio, uma unidade que eu criei em 2023 na Advocacia Geral da União, e nós vamos institucionalmente abrir um edital para o quê? Exatamente para que nós possamos receber a consulta dos contribuintes e, de antemão, antes mesmo da entrada em vigor plena da reforma tributária, nós possamos endereçar as principais dúvidas e questões do ponto de vista da União no que nós compreendemos de questões relacionadas à aplicação da nova tributação. Então, são modelos que nós estamos adotando e, mais do que adotando, apostando como modelos que podem aí reduzir a litigância expressiva que nós temos hoje. Este quadro de litigância e a agenda correlata, que é a agenda de judicialização, que eu sempre digo, a litigância ela é a irmã gêmea da segurança jurídica. Quanto maior a litigância, menor a segurança jurídica. Veja, nós não podemos supor que a sociedade brasileira ou qualquer outra sociedade ela vai se tornar pacífica e menos conflituosa do dia para a noite. Não somos integrados por freiras e elfos e querubins. Nós temos que entender que o conflito ele vai existir, ele está dado dentro da relação humana. O que nós precisamos construir, na minha perspectiva, são alternativas para que a sociedade e o setor econômico possam, de fato, buscar novas vias para a solução de seus problemas. E aí é muito importante que a gente também olhe nessa agenda de solução dos problemas da sociedade o custo que significa ter um judiciário para um país com tanta desigualdade, com tantos desafios de seu desenvolvimento tardio, que expressa ainda desigualdades sociais e regionais muito profundas, mas que tem um dos judiciários mais caros do mundo. O sistema de justiça no Brasil é muito caro. Eu quero dizer que só do ponto de vista da União, nós gastamos mais de 2%, 2,5% do PIB para manter esse sistema de justiça e, junto com o sistema de justiça, um pagamento de dívidas decorrentes de decisões judiciais da ordem de 1% do PIB nacional, 100 bilhões de reais. Então, é preciso que a gente encare isso de frente e isso seja, de fato, precificado, porque isso também é custo do Brasil. Quando a sociedade exige de todos nós, corretamente, uma agenda de redução de custo e melhoria do gasto público, nós temos que falar também do que significa a judicialização no Brasil para o custo do Brasil. Ora, se eu entendo que 1% do PIB me tira 100 bi e isso pode ser revertido na redução da dívida pública, qual seria o impacto real disso se nós olharmos aí uma agenda de redução da dívida bruta do Brasil e, a partir daí, nos colocar numa condição de reduzir a nossa taxa Selic? Tudo isso precisa ser refletido pela sociedade. Eu, como advogado-geral da União, quando assumi em 2023, eu assumi a agenda da desjudicialização como um motivo de minha gestão. Algo que, de fato, me mobiliza muito, porque é absolutamente falido este modelo. O Estado, ele litigava e litiga ainda mal, litiga muito e é um custo muito caro. Portanto, não é uma litigância inteligente. Nós temos que ter uma litigância estratégica inteligente naquilo que for, de fato, absolutamente relevante. Eu falo com muito orgulho. Em 2023, nós celebramos 450 mil acordos de conciliação no primeiro grau. No ano passado, já foram 1.450.000 acordos de conciliação no primeiro grau. Nos últimos 4 anos, nós conseguimos uma redução só na interposição de recursos especiais no Superior Tribunal de Justiça da ordem de 3,8 milhões de processos. Isso tudo é contribuir para a redução da litigância no Brasil. Quem lidera e o Estado lidera precisa dar o exemplo. A minha mãe sempre fala que o exemplo arrasta, né? Então a gente precisa ouvir esses bons conselhos. Também eu quero dizer que de 23 para 24, nós recebemos, só no Superior Tribunal de Justiça, que é um tribunal importante no Brasil, todos sabem, os recursos, os agravos em recursos especiais eles representavam 50% total de processo. Hoje, no dia de hoje, caímos para 28%. E a nossa meta é chegar em 26% a 15%. É muito significativo que nós estamos, de fato, construindo. Na área tributária, nós avançamos muito para a agenda da transação tributária, reduzimos muito o número de apresentação de execuções fiscais, com um valor mais racional do ponto de vista da cobrança do crédito, tributário. Então, tudo isso, de fato, é uma contribuição que o Estado brasileiro, pela União, tem realizado. E é importante que a gente também veja que este exemplo da União tem influenciado de forma muito positiva os Estados. Eu vejo, a partir da cooperação que nós estabelecemos com diversos Estados da Federação, uma influência muito positiva do que nós estamos fazendo no plano federal para a redução da litigância nos estados e nos grandes municípios, nas capitais principalmente. E aí também é importante que a gente ressignifique o papel da União dentro de uma agenda de cooperação federativa. Quando eu cheguei na Advocacia Geral da União, existiam litígios históricos da União com os estados. Eu cito um exemplo que é o caso do Fundef. Nós celebramos 10 acordos do Fundef. Dinheiro que vai direto para a educação básica. Foram mais de 15 bilhões de reais nos últimos 2 anos para a educação básica, que nós conseguimos celebrar mediante acordos com vários estados da federação. Processos antiquíssimos, mais de 20 anos, um dinheiro que seria pago para o Estado, e eu quero dizer que eu tive ainda uma vantajosidade, foi bom para a União. Portanto, que eu tenho dito na Advocacia Geral da União que nós não podemos mais carregar este custo de forma injustificada. Hoje, para um advogado que trabalha comigo, um colega, manejar um recurso especial ou um recurso extraordinário, ele precisa justificar, porque a regra é não recorrer. Então, esta é uma virada de chave muito importante que nós conseguimos estabelecer na nossa casa. Mas o desafio não para por aí. Quando nós estabelecemos a agenda de judicialização, nós precisamos olhar para a floresta. É por isso que também na Sejam nós estamos convidando vários setores econômicos para contribuir conosco na construção do projeto de lei da desjudicialização. Fica aqui o convite, já tem um edital em andamento, vocês podem consultar no nosso website. E esse projeto, de fato, tende a enfrentar as bases da litigância no Brasil. E não é suficiente que a gente fale da agenda de judicialização sem enfrentar uma questão que é muito problemática no Brasil. Nós conseguimos, nos últimos 10 anos, uma série de instrumentos legais modernos, seguros, mas usamos muito pouco. Ora, se nós olharmos numa perspectiva histórica, em 2015 nós tivemos o Código de Processo Civil, a 13.104, com um comando claro para todos os integrantes do sistema de justiça para que aposte na agenda do consensualismo, antes mesmo da questão chegar ao judiciário. Também em 2015, com a 13.140, nós tivemos a Lei de Mediação e Composição Administrativa, que é um comando para a administração pública. Ali nós temos uma modernização dos instrumentos de arbitragem que nós estamos absolutamente engajados hoje. A União, as autarquias e fundações já tiveram ou já estão expostas a mais de 350 bilhões de reais em casos de arbitragem. É muito significativo o valor, e casos são poucos casos, mas casos, assim, de fato, muito relevantes. E nós estamos ali totalmente engajados, apostando com um núcleo de arbitragem extremamente profissional. Celebramos no ano passado um acordo muito importante com a Comissão Brasileira de Arbitragem, numa perspectiva de capacitação, de profissionalização do nosso pessoal, porque eu acredito que é o caminho. A nova lei de licitações reforça, e é uma aposta que nós estamos fazendo. Portanto, a gente precisa olhar esses novos instrumentos como, de fato, algo que pode nos levar a uma nova condição, a um novo patamar. Isso não pode ser que nem aquela perua Volvo muito bonita, mas que ninguém quer comprar, né? Tem que ser uma coisa assim que seja funcional. E eu acredito hoje que é algo funcional. E a gente precisa apostar. Nós não podemos ter medo de nos engajarmos institucionalmente nessa agenda. E, por fim, dentro dessa agenda de segurança jurídica, dentro de uma grande ação voltada para a redução dos litígios do ponto de vista estrutural no Brasil, eu tenho dito que nós temos que enfrentar de forma muito direta a agenda da litigância abusiva no Brasil. Isso tem sido um problema que tem atrasado e gerado uma desconfiança no nosso sistema de justiça. A litigância abusiva, a litigância predatória, que eu não vou detalhar, ela tem retirado bilhões de vários setores, não só o setor público, que é muito vítima da litigância predatória, mas também o setor econômico tem sido muito alvo da litigância predatória, e nós não podemos assistir a tudo isso inertes. Nós temos de fazer alguma coisa. O CNJ adotou já uma série de providências, que são importantes providências, mas eu digo que ainda é insuficiente. Nós, e eu acredito que nós vamos ter condição de propor em curto prazo, precisamos forçar mesmo a alteração legislativa e conversar com o Congresso Nacional. Eu já conversei um pouco com o Murilo para conseguirmos aí um avanço nessa agenda, para que a gente possa coibir de uma forma muito clara a litigância predatória no Brasil. No Brasil, é muito barato e é inconsequente litigar. As pessoas acessam o judiciário de uma forma absolutamente inconsequente e a gente precisa refletir sobre tudo isso, porque quando existe um custo estrutural dentro da litigância predatória, o dado não é meu, mas o Centro de Inteligência de Litigância Predatória do Tribunal de Justiça de Minas Gerais fez uma pesquisa a pedido do CNJ e disse que hoje, no setor privado, 30% das ações representam litigância predatória. É um número absurdo. Então, tem que, o Bandeira está aqui para não me deixar mentir quanto ao dado, só no estado de São Paulo, em 2024, foram 16 bilhões de reais de litigância predatória só no setor privado, não tem dado do setor público. Então, essa questão, ela precisa ser encarada, porque um país, e eu finalizo, que está numa agenda franca de desenvolvimento econômico, como o Brasil, crescendo a uma base de 3% ao ano, que teve nos últimos 2 anos o melhor indicador da sua balança comercial, que está numa situação de melhor desemprego da história, 6,9%, melhor dado dos últimos 12 anos. Nós conseguimos coordenar, pelo papel, a ação do Estado, um conjunto de investimentos na nova indústria Brasil da ordem de 3,4 trilhões de reais, o novo PAC com 1,4 trilhões de reais, setor público, setor privado, e estamos em franco crescimento. Se nós não encararmos a segurança jurídica como um marco civilizatório e nós criarmos condições para transformarmos, do ponto de vista material, essa segurança jurídica como um valor a ser percebido e perseguido por toda a sociedade, nós podemos perder uma nova agenda de desenvolvimento. Porque a agenda de desenvolvimento no Brasil tem sido interditada muitas vezes exatamente por conta da agenda que a insegurança jurídica nos coloca como, digamos assim, correntes que não nos deixam ter a capacidade máxima de utilização do nosso potencial. Então, eu queria finalizar convidando a todos vocês que são atores importantes na área jurídica nacional para que nós possamos, de fato, nos engajar nesse grande pacto nacional pela segurança jurídica que eu tenho estabelecido como esses 3 eixos: de judicialização, consensualismo e o combate à litigância predatória. Muito obrigado. Eu queria, mais uma vez, parabenizar a organização do evento, pelo acerto dos temas, também pela seleção dos palestrantes. Eu estou aqui atento para ouvir aqui os meus colegas de painel e dizer que será, de fato, um momento muito rico para a gente refletir num tema da maior relevância para o nosso país. Muito obrigado.
Muito obrigada, ministro. Inclusive, senhor ministro, tem outro evento aqui em DC daqui a pouco, então fique à vontade, caso o senhor possa partir. Mas obrigada por ter dado esse pontapé inicial aqui nas discussões. Eu acho que, na sequência, eu convidaria a Rebeca a falar um pouco sobre os avanços e desafios das soluções consensuais de conflitos na administração pública, de repente oferecer um panorama.
Obrigada, Kathleen. Obrigada a todos. Prazer estar aqui com vocês, sobretudo falando de um assunto que, apesar da grande responsabilidade, seguia o assunto logo depois da fala do ministro, mas eu me sinto pessoalmente bastante envolvida com esse assunto por ter atuado profissionalmente, tendo passado pelo governo há exatamente 10 anos, 15 anos, de 15 a 10 anos atrás, quando essa discussão dos métodos alternativos de solução de conflito com a administração pública estavam sendo construídos na forma de lei ordinária. Então, é sempre uma luta, né? Agora o ministro já traz novas ideias de novos projetos de lei que têm que ser colocados, né, para discussão, para se transformar em lei, para ajudar sempre nesse sentido da desjudicialização, no sentido de uma solução mais eficaz de solução de conflitos, sobretudo com a administração pública. Então, já agradecendo a oportunidade e cumprimentando a mesa em nome do ministro Messias, eu gostaria de apresentar, na verdade, falar muito rapidamente dessa contextualização em seguida do que o ministro Messias já colocou, de um congestionamento do judiciário, né? Então, a gente tem dados do CNJ de que o judiciário está congestionado em 70%, 91% quando se fala em execuções fiscais. E também a gente vê, como o ministro falou, 83 milhões de processos pendentes no judiciário e 12 bilhões de processos que estão pendentes nos judiciários e conclusos hoje, dados do CNJ de 31 de março desse ano. Né? Mas, ao mesmo tempo, temos bons resultados obtidos com métodos alternativos de solução de conflitos, dados da própria AGU, resultado de arbitragem de 222 bilhões desde 2006, decorrentes de ganhos e de perdas evitadas, né? Então, é um conjunto, né? Não há solução mágica, não é uma solução de uma hora para outra, é um conjunto de esforços que envolvem, sobretudo, os três poderes, né? Então, a gente está falando aqui desde quando começaram os primeiros painéis de um esforço, né, de várias frentes para solucionar conflitos e cada vez mais tornar o Brasil atrativo para investimentos. Então, achei importante a gente trazer aqui a questão legal, né? Assim, o ministro falou do CPC de 2015, então o nosso Código de Processo Civil em 2015 trouxe de forma muito explícita a questão da conciliação, mediação, métodos alternativos de solução de conflito deverão ser estimulados por juízes, por advogados, por defensores públicos, pelos membros do Ministério Público. Né? E o próprio Código de Ética da OAB, então eu como advogada, conselheira da OAB em Brasília, a gente tem muito assim, em 2015 também, então aniversariando também 10 anos no ano de 2025, a gente tem a resolução número 2 de 2015 da OAB, em que coloca que é dever do advogado estimular a conciliação, né, entre os litigantes, prevenindo sempre que possível a instauração de litígios. E aí, em 2015, aniversariando 10 anos esse ano, a lei de mediação, né, que versa sobre a transação de direitos disponíveis, né, em que a União, estados e municípios poderão criar câmaras que versem, que previnam e que façam a solução administrativa de conflitos, e tem muitos exemplos e bons exemplos de tudo que a AGU, desde então, tem instaurado dentro da administração Pública Federal e também o TCU, tudo que a TCU tem trazido, e eu não vou vou deixar para o Fernando a parte do TCU, mas salientando que é preciso engajamento dos três poderes da República e deixando de lado o excesso, na verdade, é uma mudança de cultura da forma como se pensa a solução de conflitos, porque, na verdade, é uma mudança de cultura em relação ao próprio formalismo do direito, né? Então, para que essas medidas alternativas de solução de conflitos, para realmente fazer a diferença, há necessidade de deixar de lado o excesso ao apego aos formalismos e aos tecnicismos próprios do processo, e para, assim, conseguir, com segurança jurídica, mas conseguir avançar nos métodos alternativos de solução de conflitos. Então, no histórico, a gente vê que em 1998, a cúpula ibero-americana de presidentes dos tribunais de justiça e superiores tribunais federais estabeleceu como meta a promoção de mecanismos alternativos de solução de conflitos, e eu gostaria de destacar em 2009, então a gente tem 16 anos, na verdade, do segundo pacto republicano, por um sistema de justiça mais acessível, mais ágil, mais efetivo, que o Brasil, quando então o presidente Gilmar Mendes, do STF, colocou a questão expressa nesse pacto assinado da necessidade de melhoramento da prestação jurisdicional, sobretudo, né, por meio de prevenção de conflitos e o dever de estimular a autocomposição. Né? E aí, a partir de 2009, vieram as leis todas que a gente já ouviu aqui do ministro, e mais do que a lei de mediação, 2015, lei de arbitragem, eu ressaltaria também outras leis que eventualmente não são diretamente ligadas à autocomposição de conflitos, mas que vão sempre marchando nessa ideia, né, de tornar um judiciário mais ágil, que também teve a lei de leniência prevista dentro da lei de anticorrupção no Brasil em 2013, um pouquinho antes da lei de mediação e de arbitragem, a lei da transação tributária, mencionada pelo ministro Messias, que tem feito, são 5 anos, na verdade, dela, porque foi em 2020, mas a gente vê dados da própria PGFN, da Procuradoria-Geral da Fazenda Nacional, né, que a gente tem uma lei nova há 5 anos, tem tido mais de 3 milhões de acordos sendo feitos em relação à recuperação, né, da dívida ativa da União. Na verdade, 3 milhões de acordos e 84 bilhões de reais recuperados da dívida. Então, na verdade, são resultados que tornam assim a recuperação fiscal transacional supera a execução direta, ministro. Né? Surpreendentemente, porque não é fácil, inclusive assim, eu fui testemunha do quanto foi difícil positivar em lei lá em 2010 até 2015 que isso tudo era possível, e agora começamos de fato a olhar o quanto de resultado que isso traz, e a transação tributária de fato tem superado a execução direta. São valores que retornam à sociedade em forma de serviços prestados à população. Então não é apenas, assim como a lei de improbidade também, ministro Messias. Então, a gente vê a lei de a permissão para acordos de não persecução civil, né? Tem sido também uma quebra de paradigma. Então, o Brasil tem atuado nesse sentido com modelos de composição que extrapolam a esfera patrimonial. Então, não é só recompor aos cofres públicos uma dívida, um crédito. Na verdade, eu acho que a composição de conflitos, eles entregam à sociedade soluções efetivas, se traduzindo em percepção da sociedade em relação àquela solução, e não só recuperação de créditos para os cofres públicos. Então, de fato, a gente está falando aqui de uma mudança cultural que extrapola, de fato, apenas uma questão patrimonial. Então, é isso. A gente está falando de cultura de composição, Karen, princípios norteadores de paz social, autonomia da vontade, para os quais, assim, todos nós da comunidade jurídica devemos, né, nos deixar nortear nas nossas alterações, e apenas reforçando a importância dessa cultura da paz e da eficiência na gestão pública, eu deixaria um convite, né, como cada profissional do direito pode contribuir para essa transformação. Então, quando o ministro fala da litigância predatória, né, na verdade perpassa também a forma como nós, profissionais do direito, também entendemos o acesso à justiça, né, e não nos esquecer da nossa função nesse ecossistema, pela desjudicialização. Muito obrigada.
Eu vou pedir licença para me retirar, porque eu tenho um evento agora na embaixada, na missão do Brasil junto ao EA, mas eu também queria, antes de me despedir, agradecer a Sofia Monteiro pela gentileza de nos receber aqui. Eu não sei onde é que ela está, mas fica meu abraço e sucesso pleno ao evento. Muito obrigado. Com licença.
Boa reunião.
Bom, vamos dar continuidade aqui. Eu acho que considerando, né, esse desafio de implementar soluções dialógicas em um país marcado por uma forte cultura do litígio, acho que seria interessante ouvir agora do Fernando um pouco sobre como tem sido, como você avalia assim, essa evolução da demanda por mediação no TCU, desde a criação da SESEX Consenso, etc.
Obrigado. Eu cumprimento aqui os colegas do painel e agradeço a oportunidade ao professor Yamis, agradeço a Sofia também e ao BDL pela oportunidade de participar aqui do evento, né? Então, o objetivo aqui da minha fala seria no sentido de mostrar, falar um pouco sobre a experiência do Tribunal de Contas da União. Foi criada nesse objetivo de estimular a solução consensual, foi criada a Secretaria em dezembro de 2022, a Secretaria de Solução Consensual e Prevenção de Conflitos, e o objetivo da Secretaria é tentar atrair, receber demandas do Poder Executivo, principalmente, e tentar solucionar esses conflitos, notadamente na área de infraestrutura, nos contratos de concessão, né? Então, ela foi, a partir da criação, nós já recebemos em torno de 37 processos. Aí falando um pouco sobre essa questão os requerentes são os ministérios de ferrovia, o Ministério de Portos, aeroportos, aí tem casos de ferrovia, de telefonia, casos de estradas e também tem de energia. O processo que foi criado a partir de dezembro de 2022, ele é a partir de uma demanda do ministro ou do diretor-geral da agência reguladora, é formada uma comissão para tratar especificamente do caso que é requerido, e a comissão ela é formada por membros do Tribunal de Contas da União, a unidade especializada que vai tratar da área técnica. Além disso, tem a participação da Advocacia Geral da União, a participação da Procuradoria Federal e de representantes também da área técnica da agência reguladora e do Ministério. A comissão tem um prazo de 120 dias para alcançar, até 120 dias para alcançar uma solução consensual. Desses 37 casos que eu mencionei, mais ou menos 7 casos não foram conhecidos porque não se encaixavam nos requisitos, né? Não tinham sido preenchidos os requisitos apontados que são exigidos pela instituição normativa, mas desses outros 37, então 30 que foram analisados, até o momento já em torno de 20 tem uma solução consensual alcançada, né? E aí são setores, como eu mencionei, o setor de energia, de rodovias, de ferrovias e de aeroportos. A partir do momento em que entra em acordo, esse processo ele segue para o Ministério Público que atua junto ao TCU para a manifestação deles. Tem também uma autorização aqui da Advocacia Geral da União, principalmente do ministro Messias, aqui que tem autorização, e tem também a autorização para o plenário do Tribunal de Contas da União para fazer a análise da matéria e autorizar o presidente do Tribunal de Contas para assinar o acordo, né? E aí eu acho que poderia, talvez, falando um pouco dos resultados, né? Nós já temos, com a atuação da Secretaria, em torno de 50 bilhões de reais, algo em torno de 10 bilhões de dólares, foram tratados nessas comissões. Foi acordado a prorrogação de contratos de concessão, antecipação de investimentos, redução de litígios judiciais, administrativos e arbitrais, e a gente tem visto que esse prazo de 120 dias que a comissão tem para chegar a um consenso acaba sendo uma alternativa que dá uma rapidez para alcançar uma solução. Então, acho que aumenta a efetividade. Tem uma questão da segurança jurídica que foi bastante comentada aqui, que nesse caso o Tribunal de Contas da União ele acaba fazendo o controle concomitante e um controle preventivo da solução que está sendo alcançada. Então, acho que isso evita o litígio na esfera judicial e, além disso, tem reduzido os processos arbitrais, porque as concessionárias não querem dar sequência a partir do acordo que está sendo alcançado, né? E a gente está, a partir da solução, a gente faz o monitoramento do acordo, da implementação do acordo, do pagamento de eventuais multas, do recolhimento de valores que são devidos à União, e os processos vão sendo encerrados pelas partes, né, porque tem a intenção de reduzir o litígio, né? Bom, acho que era isso que eu tinha para falar sobre o tribunal. A experiência assim, tem demonstrado que a implementação de soluções alternativas na administração pública, ela tem um caminho longo a percorrer, mas acho que já tem um bom avanço nisso e a gente tem visto que acaba que é uma solução uma alternativa que assim, sem retorno, né? Então, à medida que estão sendo negociados acordos, a gente tem visto que cada vez mais os ministérios têm procurado para fazer novos requerimentos, né? É isso, obrigado.
Muito obrigada, Fernando. I'm sorry, in the interest of time, so now we're switching to English, and we will talk about dispute boards, another option, but from the FGV perspective.
It's too late to speak. Good evening. I'll try to be quick so you don't sleep at that point. I think it's very hard to be here. So I thank you all for being here, for paying attention. This is a specific subject that I love, so I will speak with passion. I work mostly with arbitration and mediation, but this is my passion, dispute board. I don't work with dispute board as a neutral, but I work with dispute board as an institution. First, I would like to thank Georgetown University, Professor Don De Amicis, and specifically, I would like to thank two young women, very special women with babies and very competent and hard worker, Gary and Sophia. I think you are the best that we have in Brazil. Hard work women with a lot of potential. So thank you very much. It's a pleasure to be here. Well, I will speak, as I told you before, about dispute board. I don't know if you have heard about that before, but probably Professor Don De Amicis, yes. And I'll try, Professor, to explain the difference between the American experience and the Brazilian experience. Well, dispute board, if you don't know what it is, it's a board with engineers or technical professionals. They decided to create that in the 70s, in the beginning of the 70s, to avoid lawyers. They thought that in infrastructure and construction projects, they were having a lot of arbitration and a lot of litigation. So they thought that they could avoid the lawyers. So they created a board with engineers that could understand and decide and recommend solutions during the construction project. So that's the difference if we compare dispute boards with arbitration and mediation. You'll see in the real time what's happening, and you can decide or recommend. And that's a very interesting point because, for example, Professor, here in the US, you have a lot of dispute boards, much more than we have, and much more than I think the whole world. But the difference is that here, usually the dispute board make recommendations, and you do what the board recommend. So we try to do that in Brazil. Our first case was in 2005 with the yellow metro line. And the first time that we tried, the dispute board was recommending solutions. It didn't work because in Brazil, as Murilo told earlier today, the state and is bigger than the society. So we usually don't do what we have to do just because we have a recommendation. So we change it. Now, the most part of the dispute boards that we have, not just in Brazil, but also in the Peruvian experience, is decision boards. So they take decisions. They also intervene as a consensual board. So they use a lot of mediation techniques, even though they don't mediate, but they use mediation techniques also to try to avoid the procedure of the decision. Usually, at least in Brazil, 70% of the solutions come from the consensual action of the board, but at the end, we adopt a model with decision. So that's a big difference. We don't do recommendation boards in Brazil. We do decision boards. And it's interesting because it's not just in Brazil, as I told, also in Europe. This is for example, the FIDIC model contracts. In the beginning, they promoted the clause with the recommendation board. And from 2017, they changed, and now they promote the decision board because outside the US, this is the most used form of dispute board. And why we chose to talk about a dispute board? Because in Brazil, I remember, well, in 2016, in the World Bank ranking, we were a bit better than in the previous year because we had the arbitration law and the mediation law. And we think that dispute board could be also an interesting tool. Different from the US, for example. You use dispute board because you like it. You think it's interesting to avoid litigation. It's not seen that way in Brazil and in Peru, for example. We have a lot of dispute boards in Peru as well right now. We see it not as a good tool in the beginning because it's imposed by the World Bank or the Inter-American Bank or the Japanese Bank. For example, most part of the dispute boards that we have in Brazil right now, we do have it because of the requirement of the banks that are investing in Brazil. So that's the reason it's not that amicable, the use of dispute. But it's there is another interesting point also is that the judiciary we don't have a lot of cases of dispute board in courts right now, but all of them, the judiciary decided that the board was correct. We did a research last year, and we don't have many cases yet. I think we had 11 or 12 cases, but in all of them, they thought that the the technical view of the board was correct. So it doesn't mean that it has to be that way to understand dispute board as a good tool, but it's an interesting point because, for example, Brazil is well seen in the arbitration scenario in the world because we have, Gustavo wrote an article about this. We have a strong judiciary concerning arbitration. They are very arbitration friendly, and they seem to be dispute board friendly as well. I think this is one of the most interesting tools for one of our biggest problems in Brazil. I think we have a PowerPoint presentation. I don't know if we have just to. That's okay. Because if we see the numbers of the accounting court in Brazil, the most part of our construction project doesn't go well. They stop, they stall. So dispute board could be a good tool to avoid this scenario. So I'm sorry about my voice, and I thank you very much for being here right now and here with attention about this new tool for us and not that new for you, Professor. Thank you very much.
And just one fact that Juliana hasn't shared is that for the first time ever, FGV is hosting a dispute boards competition this summer. So who knows, hopefully next year, maybe we can see like a Georgetown FGV team take the challenge together. That would be fun. I'd like to see that. Thank you very much. Thank you to our panelists for your valuable contributions. What we heard is that ADR is not just a legal tool, it's really a powerful strategy for making public administration more efficient, more transparent, and trustworthy. Thank you all for being here. And unfortunately, we won't have time for questions. Yes, we have another panel, the last panel of the day. I hope you guys will stay. Thank you. A gente está 20 minutos só. Sim, eu também.
Thank you.
Thank you, Professor. Sorry. My voice is
fine. Your voice is fine. You did great. And
Roberta. Can you? Tu pode botar. Paula, could you come over? So we're gonna head to the last panel of the night, and I beg your patience. We are running behind schedule, but the good news is that MPB band is already preparing to, entertain our cocktail. So this panel is besides you and the cocktail, but it's an amazing panel. And I'm gonna pass over to Paula, who's gonna introduce our speakers. Thank you.
Okay, so good afternoon, everyone. Thank you one more time for your attention. Thank you, Professor Damicis and Sophia, for bringing this event together. As part of the CTBL, I'm very, very proud of the result. And I'm going to introduce the speakers since we are a little bit behind the schedule. So let's start with Professor Weitzel. She is professor of Georgetown Law and the faculty director of International Arbitration and Dispute Resolution at Georgetown Law. Also, I'm going to invite Celso Xavier. He is the partner at Xavier, Galhard, Inglês, Schaffer Advogados. He holds an LLM degree from Stanford Law School and focuses his practice on complex arbitration and litigation disputes. Also, I'm going to introduce Professor Bruno Salama. He is an independent arbitrator. He is a law professor at UC Berkeley Law School, where he focused on international arbitration, economics, technology, and regulation. He also teaches at FGV Law School in São Paulo, and he is a partner at Salama Silva Filho Advogados in São Paulo as well. Also, I'm going to introduce Fernando Merino, who is a partner at Steptoe. He's based here in Washington, D.C., and he focuses his practice in a wide varied range of areas, such as compliance investigations, dispute resolution, corporate and securities law. He served as chief legal officer for major industrial and retail companies. Last but not least, I'm going to, just one moment. Introduce the Judge Abner Youssef. He is an assistant judge in the Brazilian Supreme Court. He is a state judge in São Paulo. He is a PhD candidate at State University of São Paulo. He has an LLM in constitutional law at the University of Brasilia. He is also a professor of constitutional law at Mackenzie Presbyterian University at IDP. And finally, I'm going to introduce our moderator, Gustavo Faveroval. He is a partner at César Asfor Rocha Advogados. He has an LLM degree from Columbia Law School and a master's degree in civil procedure law from the University of São Paulo. He is also a law professor at the Brazilian Institute of Public Law. So this panel is about the constitutionality of arbitration, and please stick with our speakers. Thank you.
Hello. Thank you, Paula, for the kind introduction. It's a pleasure to be here with you all today. This is a very beautiful university, very, very nice law center. Professor Donamici, thank you for being here, for organizing this event. Murilo, thank you for the kind invitation. Sophia, thank you also for the kind invitation, for organizing everything, putting together this great event. So our panel today is about the constitutionality of arbitration. We're not going to focus only on the constitutionality of arbitration itself, but also on the intersection of arbitration and constitutional law, which I think it's maybe the most important issue related to arbitration nowadays. And I have to say that Georgetown Law Center put together top-notch practitioners to talk about this topic, which I'm glad to be here moderating this panel. And so, Judge Abner, I'll start with you. Let me ask you something. Can arbitrators engage in constitutional review, which we would say in Portuguese, controle difuso de constitucionalidade, during arbitral proceedings under Brazilian law? And if so, if you agree to that, how would this function within each legal framework?
Well, good evening, everyone. It's a huge honor and great pleasure to be here. I'd like first to thank Professor Dom, who I had the pleasure to meet yesterday. Also, I'd like to thank Sophia and Murilo for organizing this event and for this invitation. So, as Gustavo said, I'll try to answer this question. Can arbitrators engage in constitutional review under Brazilian law? And as we are talking about Brazilian law, there are some premises I'd like to establish first with you. My background, my academic background is all constructed in constitutional law, so that's the approach I'll give here today. Brazil has a wide and strong model of constitutional review. We have like two ways of doing that. One we call is abstract and concentrated constitutional review, which is made by the Brazilian Supreme Court and is very much alike the German model. And the other is what we call diffuse and concrete constitutional review, which is a little bit like the American model. This was the inspiration, the old and classic Marbury versus Madison, in which every judge in Brazil can and must do the constitutional review. So to answer the question, there is one preliminary issue we have to discuss, which is arbitration a way to exercise jurisdiction? Because if the answer to this question is yes, I think it's a logical conclusion that yes, arbitrators can and must exercise the constitutional review within their cases. And the Brazilian Arbitration Act dates from 1996. At that time, this theme was surrounded by some controversies, but we can say that nowadays arbitration is a safe model, is a legal certainty, has it legal certainty to solve disputes, to settle case in Brazil. But there are still some topics that are not completely settled, are not completely decided. And the well-known point of a well-known point of controversy, including these days, is if arbitration is or is not a way of exercise of jurisdiction. And when we think about jurisdiction, we can say that jurisdiction is the authority to settle disputes with impartial decisions by third parties that are not in the case, hearing and deciding case through a formal procedure leading to a final judgment. And when we think of these characteristics, we sure has it all in the arbitration. We have it all in arbitration. So the first answer I present here is, in my opinion, yes, arbitration is a way of exercising jurisdiction. And with it, it comes a lot of issues, just like the nature of jurisdiction and the duties that comes along with it. Of course, when we say arbitration is a way of jurisdiction, I'm not saying that it's completely equal to judiciary jurisdiction. Of course, there are some differences, such as the bond of legitimacy of the judges, the way judges are appointed, the coerciveness of the decision. But at the same time, if we say that both are jurisdiction, there must be some features, some common features among them. And one of these features is that both jurisdiction, state jurisdiction and arbitration jurisdiction, are based upon the Constitution. So the supremacy clause, the constitutional clause, and the normative force of the Constitution can and must be invoked both by judges and also by arbitrators. And we think of that, the constitutional authority to review constitution, the authority to engage constitutional review derives from this very nature of arbitral proceeding as a way of exercising jurisdiction. And of course, as we talk about Brazilian law, we assume that this arbitration chose to apply the Brazilian law system. And when this choice is made, all the legal framework of Brazilian system is and must be applied. Not only the rules, not only the state laws, but also and mainly the Constitution. And also, when you think about that, we can say that the arbitrators, as a judge of law and a judge of fact of the case, as the Brazilian law clearly states, has also the duty to do so. Not only arbitrators can engage in constitutional review, but they must do it. So choosing the application of Brazilian law, the possibility of engaging in constitutional review is an inherent power to the arbitrator as an instrument of its jurisdiction. It seems logical to me. And also the freedom that parties have to choose the rules of law adopted in some arbitration does not reach the possibility of excluding the application of constitutional norms, considering their supremacy clause, considering their normative force. And I think also that even when parties agree that arbitration shall be based on equity, it's not possible as well to utilize the arbitration as a way out of Constitution, because equity does not mean a judgment contra legem against the law, or contra constitution, against the Constitution. So when Brazilian law is adopted, as I said, the entire normative framework of Brazilian legal system is invoked and must be adopted, and the Constitution is on the top of it. It worth noting an alteration that was made in Brazilian Arbitration Act in 2015, when legislators deliberately revoked a restrictive provision that stated something like this. The law said, and says no more, if during the course of arbitration, a controversy arises concerning non-disposable rights, and it's verified that the judgment depends on their existence, the arbitrator or the arbitral panel shall refer the parties to the competent authority of the judiciary. The law said that, the Brazilian Act said that, and says no more, because this article was revoked in 2015. And for me, it is a very good signal that arbitrators can also decide about non-disposable rights, non-disposable norms, such as the Constitution. So, arbitrators, yes, can do that. And of course, their decision has some limits that are binding just to the parties that participated of the arbitration. Just like we say in Brazil and in part in America too, when we have the diffuse and concrete constitutional review, the decision of the case is binding only to the parties that made part of that decision. So there are not erga omnes effects in this decision, and this is also a feature that I think comes with this possibility. The same effects of judicial constitutional review promoted on a diffuse and concrete basis. Of course, this conclusion that I now present doesn't settle all the controversies surrounding this theme, surrounding the constitutionality of the arbitration, but there are some limits that bound this power, and I think some of these limits, some of these questions will be addressed by the following speakers, my colleagues, so I'll not engage in them now. But from this perspective, as a conclusion, I sought here to highlight the possibility that arbitrators engage in constitutional review during their procedures, complying with the Constitution. And I think that these features qualify even more arbitration as a secure and binding mechanism to settle disputes, to settle resolution in Brazil, fulfilling the responsibilities of the task it assumes in resolving disputes, interpreting applicable norms, especially and mainly when these norms assume a constitutional level. Thank you very much.
Thanks, Judge Abner. Great presentation. This is a very interesting topic. It's very dear to me, as you know. And on a different perspective now, we all know that not only in Brazil, but also in the US, arbitration practitioners, dispute resolution practitioners, have been addressing and studying the relationship between the judiciary and arbitral tribunals, arbitration itself. So based on that, Celso, I would like to hear your thoughts and to know actually, and to share with our audience here, what has been under consideration by the Brazilian Supreme Court when it comes to arbitration?
It's always the green light, I'm sorry. Well, first, I'd like to thank you, Murilo and Sofia, for this kind invitation, Professor Demisis as well. I'm very flattered to be here, and thank you for hosting that. It's such a great event, and thank you, Professor Ann, and my Brazilian colleagues that will only enhance the quality of this panel. Well, we don't have too much time to address all the issues, all the questions on Brazilian arbitration, especially those concerning the constitutionality of some issues. But sometimes the most complex questions, they are resolved by simple answers. And we need really to get back to the basics. And so just a little bit of history will help us out on this. The Brazilian Arbitration Act is dated 1996. But only after 2001, actually, that Brazilian arbitration has been performed and implemented in Brazil, when the Supreme Court at that point in time, and the reporting justice at that point was Justice Ellen Gracie, who has already retired, has led a very important leading case on the constitutionality of the Brazilian Arbitration Act. It was at that point an international award that the party, the applicant, was trying to enforce in the country, and it has been raised at the Supreme Court level to what extent arbitration will be constitutional in Brazil, because there's a there's a clause in the Brazilian Constitution that deals with the access to the justice that would be a non-disposable right. So every single Brazilian or everyone in Brazil would have the right to access the justice. And so this would not be waivable. And so that was the battle between the Brazilian Arbitration Act and the Constitution. And so there was a decision, obviously accurate and following the trend in the whole world, that, well, provided that there's a free consent, so the parties, they really intended to arbitrate that issue, that issue is about non-disposable rights, so rights that the parties, they have the ability to settle, and provided there's trust, which is that the parties, they need to trust on that arbitration tribunal, constitutionality was acknowledged, and as of that moment, all the arbitration clauses, they have been implemented, they have been performed, and from that moment in time, Brazilian arbitration has increased on a very, very high pace. And nowadays probably is one of the most important countries in terms of arbitrations, not only about the quantity of the cases, but about the importance of the disputes. And we have very good chambers in Brazil that are leading arbitration worldwide. We have ICC and other international chambers with offices in Brazil. So I'm really a big fan of arbitration. But being a big fan of arbitration is like a kid. It doesn't mean that you cannot criticize your kid. Actually, to raise good kids as a good adults, you need to see internally and you need to criticize to see how we can grow up in a better fashion. And I think we are exactly in Brazil in such a discussion. And when there is such a discussion, you always see a battle. People going to the left and people going to the right, defending different interests. And probably the right answer is in the middle, usually. And I think we are in such a moment, both from a theoretical and a practical standpoint. But to resolve the disputes, and a few of these disputes, they are reaching the Supreme Court at this point in time, you need to get back to the basics. You need to see exactly what the Supreme Court decided in 2001. So the questions about, was there a free consent for the parties to arbitrate? What are the pillars of the arbitration to be a good arbitration? And is there trust in such a case in the way that arbitration could be a good alternative or a good way to solve disputes in the country? If you go back to the basic, it's probably all the three topics that I decided to bring you here for the audience, you're going to decide on the right direction. So the first issue is about the duty of disclosure. This is a very debatable issue in the country. We have in our Arbitration Act, which is Section 14, inspired by all the arbitration acts worldwide, the duty of the arbitrator to disclose anything that would bring a reasonable doubt, or in Portuguese, it's called justifiable doubt, about the independence and impartiality of that specific arbitrator. And it has been debated because people see this on a different way, in a different topics. So arbitrators, they would have a tendency not to disclose everything, and I think it's comprehensible. If you're a full-time arbitrator, the more arbitrations you have, the better. Well, it's a service the arbitrator is going to render. So the more you disclose, probably you are enhancing the likelihood that you'll be challenged. And if you're challenged, you're not occupied that specific position. Is it a selfish behavior? It is, but we need to deal with that. This is a human being, and we need to protect the system against that. So the discussion is, to what extent this duty of disclosure should go? Should it go to a certain point that you're going to give to the parties the ability to challenge any single arbitrator just because the party didn't like that? Of course not. But we also need to pay attention that arbitration, unlike the court system, you have a lot of tools to do a lot of bad things. such as, well, in the court system, you don't choose the judge you want. This is randomly assigned to a specific judge. So this is a protection of the system. In the arbitration, no, you choose exactly the very single person that you would like to decide your case. I don't know how lawyers or how parties will think on that, but they have this too, and this is a very important too. So if the other side doesn't know every single detail about the relationship of that specific arbitrator with the parties, with the lawyers, well, that's a very important thing, because that will bring to the other side a reasonable doubt on the independence and impartiality of that specific person. So I think that's an important pillar for the arbitration really to stand, because otherwise you're going to fall because of the lack of trust of the clients in the end of the day on that specific system. We should also pay attention that in arbitration there isn't an appeal. So it's just the panel. If the panel decided on the merits, the decision is made, it's done. So you do not have other panels to redecide that issue. In arbitration, it's confidential. So nobody knows what's going on there in most of the cases. So there is no press checking out what is going on. And this, obviously, in most of the cases, it happens when there is a lawsuit, for example. In arbitration, you don't have the CNJ. We had here the former commissioner of the CNJ, Luis Fernando Bandeira, who is very used to that. I mean, the CNJ doesn't control arbitration, doesn't control the arbitrators. So there is no disciplinary body to see what arbitrators have been doing. There will be the chambers, there will be ICC, there will be the others checking out, but no authority perhaps to punish the arbitrators the way the CNJ could punish a judge, for example. So the arbitration itself doesn't have all the protection mechanisms that the court system would have. And there's only one single pillar that could cause the arbitration to stand, which is the respect to the duty of disclosure. Because that's the way you give the parties the ability to really put that person on an X-ray, like customs, like security in the airport that will be in an hour from now, to see who that person is. What are the relationships the person has with the parties? What are the precedents, the case that person has decided, or what is the doctrine that such a person has decided? And then every single lawsuit, a set-aside action that would have challenging an arbitration award in Brazil based on legally fail on the duty of disclosure, Brazilian courts, they have decided on very different ways, very different ways. There are decisions saying that, well, the parties, they have the duty to investigate arbitrator's life, which is something that simply doesn't exist in the Brazilian Arbitration Act. So it's exactly the shift of the burden. Instead of the arbitrator to review issues that may compromise or harm the independence and impartiality, it's the opposite. You as the party, you have the duty to investigate arbitrator's life. There are decisions on this way. There are decisions applying soft law. What is soft law? I know what people say as being soft law, but in my understanding, either there is a law, there is no law. When the parties, they choose Brazilian law, they did not choose soft law. They could. If they could, there's no problem. It's the ability of the parties to do so, but if they did not choose, it's Brazilian law. So then some court decisions say, well, let's see what the IBA guidelines on conflict of interest will say on that. But the parties didn't choose that. So could the Brazilian courts do that? So there are quite a few topics that are under discussion that will give rise to some set-aside actions to be granted and a few of them not to be granted. That's the reason why recently, I think a year and a half ago or so, an ADPF, which is one of the tools that Judge Abner correctly mentioned to check out the constitutionality of some decisions or administrative acts that would violate important clause of the Brazilian Constitution. So this tool has been used by a political party called União Brasil, exactly raising the hand and say, well, there are issues about duty of disclosure that Brazilian courts, they are deciding on very opposite ways. And it goes not against arbitration, it goes against the certainty that, well, the legal system should have to attract investments, to bring people to use arbitration in the end of the day. So it's a good tool and has required the Brazilian Supreme Court to decide on that, to try exactly to bring that vague concept, which is in the Brazilian Arbitration Act, about what the just filed out would be, to more down to the earth, to say, well, in an actual perspective, what does that mean? Because if the Supreme Court doesn't do that, there'll still be decisions going to the left and going to the right on that specific issue. So this is, I think, the first thing that probably the reporting Justice Alexandre de Moraes, that has already reached the Supreme Court, and at a certain point in time, the Supreme Court will need to decide on that specific and very important issue. The second issue that I think it's also important to tell you is about mandatory arbitration. This word itself brings a contradiction, because if arbitration depends on the free consent, there should not be a mandatory arbitration. It's against the concept of free consent. It's against the concept of what the Supreme Court decided back in 2001. That's what I'm repeating, that we need to go back to the basics. There are at least 2 specific industries in Brazil, or segments, that we do see mandatory arbitration. So there is what we call CCEE, which is the Chamber of Commercialization of Electric Energy in Brazil, that imposes on all the companies dealing in that market to choose arbitration, for instance. And it says that, well, if you have a contract that you are trading electric energy, you need to choose arbitration. So it's mandatory. There's also B3. B3 is the Brazilian stock exchange that has decided years ago that if you're a listed company, if you go public, and if you want to go public in a specific segment, which is called the new market, Novo Mercado, which is the most important market that will comprehend the most significant companies in the country, you need to put in your bylaws a mandatory arbitration. So any dispute that will involve the company, the managers, and the shareholders, it has to be resolved by arbitration. And not only it has to be resolved by arbitration, but the arbitration should take place at the very same chamber of B3, which is the Câmara do Mercado. So there's no option. If you don't agree to that, you're not listed in Novo Mercado. And if you're not listed in Novo Mercado, you're going to lose billions of reais, for instance. And so there's a discussion on, is it legal? Is it constitutional? Is it in accordance with the precedent 2001? Now B3 is revising its own rules to say, at very least, that it doesn't need to be at the B3 chamber, but arbitration will still be mandatory because, well, from a corporate governance perspective, arbitration is better than the court system. I don't know. It may be not. But again, from a constitutional point of view, it doesn't look very constitutional, in my opinion. And the third topic, which is, and then I'm going to wrap up, which is aligned with what Judge Abner has just said, is that are arbitrators allowed to interpret the Constitution and apply the federal Constitution? The answer is yes, of course. They need to apply Brazilian law, and in the context of Brazilian law, the Brazilian Constitution is within that. The issue is when the arbitrators, they apply in the wrong way the Brazilian Constitution. And people say, well, but the judges could do that the same way. That's true. But if they do that the same way, at a certain point in time, there's at least the chance that this case will reach the Supreme Court. And the Supreme Court, that is the goalkeeper of the Constitution, will say, this is unconstitutional. Or no, I'm going to uphold that. That's constitutional. What in arbitration? There's no review. So could the arbitrators decide against the Constitution? And could that award not be revised, reviewed by the Brazilian Supreme Court? So you're going to create a lot of awards that will violate the Brazilian Constitution? Is that a system that we want? The answer is not yes or no. I mean, it's a very complex issue to be dealt with. But it gains importance when that decision is not only unconstitutional, but when this inconstitutionality deals with what we call matéria de ordem pública, or the public policy, for example, with sovereignty, with antitrust laws. So let's assume, for instance, there's an SPA. So an M&A deal, and there's a dispute between seller and purchaser. And the award says, well, you need to transfer the shares to Judge Abner. So he won the arbitration. But then there will be an issue of public policy, for example, that, well, that deal, because of the amount involved, would require the approval of the antitrust authority, for example. So what are we going to do? Are we going to enforce the arbitration award? Are we going to enforce what the antitrust authority has decided? What should we do? So this is another issue that very soon will reach the Supreme Court. It could be for sovereignty issues, it could be for antitrust issues or other issues, but some kind of control may exist or should exist. We will not have the control of each case on a case-by-case basis, but probably political parties and other parties that have standing to go to the Supreme Court will try to establish some standards regarding this, so we can obviously enhance arbitration in the country now that arbitration has been performed for 24 to 25 years. So guys, we could stay here talking for an hour, and I think I've already overcome the time and ahead, but it was really such a pleasure to be here with you. Thank you.
Thank you, Celso. It's indeed always good to go back to basics. And I have to say that I think it's the first time I heard someone talking about arbitration while teaching how to raise a kid and how to face airport x-rays. So congratulations, Celso. Amazing.
Trying to compete with the MPV, which is outside.
Yes.
It's almost unconstitutional.
Exactly. But now let's turn a little bit to the US. So Professor Whitesell, thanks again for being here. You're from the House, right? And let me ask you something. What are the constitutional grounds that legitimize arbitration as an effective dispute resolution mechanism in the US?
Thank you. I would like to start by also thanking the organizers of this conference for having invited me to participate. I'm always delighted to be involved in Brazilian arbitration events, since Brazil is a country where I've personally witnessed the amazing development of international arbitration. And I'm also extremely proud of the many Georgetown Brazilian students who are contributing to this development, including Sophia, who has worked so hard on organizing this event today. Now, as you have heard, my topic today is a discussion of the constitutional grounds that legitimize arbitration as an effective dispute resolution mechanism here in the United States. And I could end my presentation very quickly by telling you that there is no mention of arbitration in the US Constitution, and then you could all go listen to the music. But indeed, the US Constitution does not directly regulate arbitration, so we must look beyond the text of the Constitution to see how its principles affect arbitration. Now, as you may know, the arbitration in the United States is governed by the Federal Arbitration Act, the FAA. It's a federal statute which was adopted by Congress in 1925. And it's through the application of the FAA and its interpretation by the courts, and in particular the US Supreme Court, that we can see the impact of constitutional grounds on arbitration's legitimacy and effectiveness. Indeed, as the US Supreme Court stated in a case called the Southland case, the FAA declared a national policy favoring arbitration. And furthermore, as held by the Supreme Court again in the Shirk case, the FAA reversed centuries of judicial hostility to arbitration agreements and was designed to allow parties to avoid the costliness and delays of litigation and place arbitration agreements upon the same footing as other contracts. So absolute pro-arbitration stance taken by our US Supreme Court. Now, due to time constraints, I'm just going to mention a few of the constitutional principles that affect arbitration. The first would be the supremacy clause. Like in Brazil, we also have a supremacy clause that's found in Article 6 of the US Constitution. And under this clause, the Constitution and the laws of the United States and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. So this means that the Constitution, federal laws, and international treaties will preempt any state arbitration laws. Again, being in a federal system, we have the federal and the state systems. So therefore, the arbitration laws in the 50 different states and their interpretation must be in compliance with the Constitution, with the Federal Arbitration Act, with the international treaties, which includes the New York Convention and the Panama Convention. Coming back to the Federal Arbitration Act, it is, again, a very pro-arbitration statute, and it has consistently been interpreted by U.S. federal courts to promote the enforceability of arbitration agreements. And so under the U.S. Constitution's supremacy clause, the FAA would preempt any conflicting state arbitration law. So that positive attitude of federal law towards arbitration affects the provisions of our state laws as well. Now, this has caused some debate in areas such as employment law, labor law, consumer cases, where it's often argued that these issues shouldn't be governed by federal law, these should be governed by state laws, and then should not be subject to arbitration, especially not mandatory arbitration, which is something we also already heard referred to. Now, issues have also arisen concerning the possibility under the Federal Arbitration Act for parties to include a choice of law clause in their agreement, pursuant to which they would choose state law instead of applying federal law. In other words, the parties would contractually agree to subject their arbitration clause to state law. So even though the Supreme Court has ruled that the FAA preempts contradictory state law concerning the enforceability of arbitration agreements, there is this gray area as to where federal and state issues may sometimes come into question as to what will be enforced based on an agreement by the parties. Now, the FAA itself must be interpreted in accordance with the Constitution, which leads me to my next constitutional principle, which is the power of judicial review, which we've also been hearing about. So under Article 3 of the US Constitution, it is stated inter alia that the judicial power shall extend to all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made or which shall be made under their authority. That's Article 3. Arbitration, as you know, is a private form of dispute resolution. So the question can be raised, as was already raised, is it legitimate for arbitrators to be deciding cases and for parties to be giving up their right to a day in court, or in most cases here, to a jury trial? And this is sometimes referred to as waiver, considering that the parties have accepted arbitration as a waiver of the public system. This comes especially under attack when, again, we look at certain types of mandatory arbitration and where questions can be asked as to, did the parties actually freely consent to giving up their rights? Now, there's also a theory that has developed in the US called the appellate review theory, pursuant to which a non-Article 3 decision-making mechanism, such as arbitration, is considered constitutional as long as an Article 3 court has a sufficient opportunity to review the decision. And you were, again, already referring to that. So the fact that an arbitrator's decision may eventually come under judicial scrutiny renders it constitutional. Now, this theory has, however, been debated and contested, especially as concerns what constitutes a sufficient opportunity to satisfy the Article 3 constitutional requirement of judicial review. Finally, I would like to mention the principles of due process under the US Constitution. Now, in the US, due process of law is a constitutional guarantee. It's protected by the Due Process Clause in the 5th and 14th Amendments. The Fifth Amendment states no person shall be deprived of life, liberty, or property without due process of law. And the 14th Amendment provides no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So very, very solid principles of the US Constitution. The FAA, the Federal Arbitration Act, does not explicitly refer to due process or equal protection of the laws, but the US courts have interpreted the FAA to require that arbitration procedures must provide equality of treatment, due process, or natural justice. In other words, the procedure must satisfy what has been referred to as minimal requirements of fairness, which would cover issues such as adequate notice of the demand and the hearing, the opportunity to be heard, a fair and impartial decision. So these concepts would be constitutional principles that would need to be respected during the arbitration proceedings themselves. But again, we're going to find them applied at the judicial review stage when an award may come for either enforcement or set aside in front of the US court. Now, both the Federal Arbitration Act and the New York Convention, which becomes part of the Federal Arbitration Act as its Chapter 2, include respectively grounds for set aside or non-enforcement based on due process type grounds, without again explicitly referring to due process. And US courts have held that the FAA requires an award to be set aside if there is a fundamental unfairness which violates a party's due process rights. Such unfairness might include a party being denied an adequate opportunity to present its evidence and its arguments. And under the New York Convention, again, Chapter 2 of the FAA, US courts have refused enforcement where a party was not given proper notice or was otherwise unable to present its case. So in essence, what we are seeing is that these US court decisions are applying US constitutional principles as to what due process means. Now, there are many more interesting questions that we could consider about how the US Constitution impacts the practice of arbitration, such as the role of state parties, and state with a capital S, in arbitration, for example. But for today, I'm going to have to stop here. So to summarize, what we see in the US is that constitutional principles and the role played by the courts in applying those principles have a substantial effect in making arbitration effective. And it is those constitutional principles and their application by the courts which contribute to the US being seen in the world as a pro-arbitration jurisdiction. I look forward to hearing from my colleagues and from the rest of you if you have any questions. Thank you again for inviting me to be with you here today.
Thank you, Professor Weitzel, for your great remarks. Your remarks reminded me of Professor Peter Rutledge's book, Arbitration and Constitution. It's a great book. I would recommend everyone to read, who, of course, may be interested in this topic. Now, Professor Bruno, I want to hear your thoughts on the same issue, right? Maybe from both the Brazilian perspective and the US perspective, if time permits, considering your professional status since, I don't know, 6 years ago, right?
Good afternoon, everybody. I think my main task here is to speak very little. If I speak very little, everybody will love my presentation. And so that's my plan. On the face of it, it would seem that the constitutional grounds for arbitration in the US and in Brazil are very similar, because we've heard arbitration is not mentioned in the US Constitution, neither is it mentioned in the Brazilian Constitution. And so the constitutional grounds have been based on interpretation by the Brazilian Supreme Court, just like they have been based on interpretation by the American Supreme Court. And yet, I do believe that the constitutional grounds for the legitimacy of arbitration in Brazil and the US are very different. I think they are radically different. And so let me tell you that threefold. First of all, what is the grounds for disputing the legitimacy of arbitration in the United States? Many things, but first and foremost, the right to a jury trial. There's a case of the 70s, although there are many similar cases. It's the Madden case. And so Madden is just this individual who checks in a hospital and is sick. And so signs an adhesion contract, contrato de adesão, whereby it's waiving its right to a trial and therefore agreeing to arbitration. And then later on, this person goes, and then the person tries to go to court. The adversary, which is a hospital named Kaiser, says, no, you signed an arbitration clause here. And what is the grounds, the main ground on which Madden is contesting the arbitration clause? Madden says, I never waived my right to a jury trial. So that's the 7th Amendment to the US Constitution. Everybody in this country has a right to a jury trial. And of course, there's no jury trial when you have an arbitration. Well, the grounds based on which the legitimacy of arbitration in Brazil is disputed is not a jury trial for sure. The Constitution says that nenhuma lei excluirá da apreciação do judiciário lesão ou ameaça a direito, right? No law shall exclude from the appreciation of the Brazilian judicial system a threat or a violation of a right. And so in the United States, the question is procedure. Do I have the right to a jury trial? Whereas in Brazil, the question has to do with sovereignty. The grounds, therefore, are very different from that standpoint. Second, they're very different because the history of the federal legislation on arbitration, the FAA in the United States, which is now 100 years old, versus the Brazilian arbitration law, they were enacted in a very different political and historical setting. The FAA was enacted here in the United States in 1995, responding to, what did I say? What did I say? Oh, no, of course not. I'm sorry, thank you. In 1925, absolutely in the 20s, it's enacted in 1925, responding to pressures of the commercial community, the trade community, the Chamber of Commerce, and so on. It's basically merchants and people in business in the United States, and they enter into contracts and they want to have the Chamber of Commerce deciding their disputes, but they are really unsure that the Chamber of Commerce will enact an award, but then it will not be respected in court because this is the tradition inherited from the English common law. And so in the United States, at some point, whether it's Southland that recognizes there's a public policy favoring arbitration or many other court cases, in the United States, after the enactment of the FAA, the Supreme Court's gonna okay arbitration. All right, how is the Brazilian arbitration law enacted in the 25 years ago or so? It's a completely different scenario. Brazilian arbitration law is responding to the pressures of globalization. And so the key question is, how are we going to adjudicate disputes that are international in character as opposed to domestic disputes? That's the main driver, because Brazil, like many other countries in Latin America at that point, is undergoing this process of privatization. And so foreign companies and foreign investors are buying interests in Brazil And they're like, oh, we don't want to litigate in Brazilian courts because we fear that Brazilian courts will favor. We fear that Brazilian courts will favor national interests or the Brazilian government. And so that is so the setting is different. And so what's the lesson here? Well, the lesson is that, at least the way I see it, the arbitration, both in Brazil and in the US, represent a big cultural change. But in the United States, it's very organic. It's just the business scenario is changing. And that leads to the enactment of an arbitration act. Whereas in Brazil, it's just, well, it's a little bit exogenous. It's this international circumstance and situation whereby the World Bank and many other players worldwide are putting pressure on Brazil alongside many, many, many other countries to enact an arbitration law. And finally, this is my main finding. It's so surprising, not to say shocking, since I started teaching arbitration here in the United States, which is when I learned that most of the cases that are subject to arbitration in this country they have to do with labor and consumer disputes. I want to repeat that because we would think that arbitration in the US and here is the same because, I don't know, both countries ratified the New York Convention or whatever. It's just very different. Arbitration here in the United States is for labor contracts and consumer contracts for the most part, right? Obviously, it's many other things. Whereas in Brazil, well, those disputes don't go to arbitration almost never, right? It's possible now in labor disputes, it's possible when you have, like high profile employees. And in consumer law, it's always been possible, provided the consumer starts an arbitration case, which never happens, right? Or provided that the consumer and the supplier agree to arbitration after the dispute has started, which also never happened. And so how do we make sense of this difference in the subject matter of arbitration here in the US and in Brazil? I have an interpretation. I think that the American courts, they want to filter out, they want to get rid of routine cases. And they want to preserve the judicial system for the important cases. Whereas in Brazil, for understandable reasons, the judicial system wants to exercise jurisdiction over routine cases, which is why, if I miss my plane here going to Brazil and let's say LATAM screws up, I'm going to start a lawsuit against LATAM in Brazil, whereas in the United States, those things would go to arbitration. And so the US courts, they want to get rid of the, silly, routine, stupid cases, honestly, right? And what's the result of that? Well, the result of that is that you have a good judicial system because the judges have time to spend on the high-profile cases. Whereas in Brazil, the policy of, taking all the routine silly cases implicitly takes the high-profile cases to arbitration. And so let me conclude by saying this. I think that arbitration, let's see, the differences in the identity of arbitration, let's put it like that, in countries like Brazil and the United States, they demonstrate this, that arbitration is flexible enough to operate in very different systems, but it does operate very differently, and the constitutional grounds on which it takes place is very different as well. Thank you.
Thank you, Professor Bruno. Very enlightening insights, especially for us Brazilians who have practiced or studied abroad in the US, many Georgetown alumni and students here. So thank you so much for that. Now, Fernando, as many people said today, last but not least, you're gonna address, if I may, a very controversial topic and very complex topic, to be honest, which is, are arbitrators bound by judicial precedent? And if so, what happens if an arbitrator simply does not follow on a precedent rendered by the judiciary?
Thank you. Thank you for that. First of all, good evening for everybody, as opposed to good afternoon. I want to thank the professor and obviously Sophia and the organizers for this invitation. It's a pleasure to be here again. I had the privilege also to be participating last year. So for me, it's even though this is not my alma mater, it's starting to feel like it since I'm often coming here. And Gustavo, with due respect to you as a moderator, as an organizer, I think we have had a long day. I have the non-envious position of being the last person to speak. But even more importantly, I am in close proximity to a panel colleague that has to get a plane and leave, which means I can be, at any moment I can have my legs kicked or something like that because people need to leave. So I'll be very, very economical, and instead of sort of focusing on the points that as we agreed, I wanted to make perhaps three or four remarks that are aligned with my practice and my prior experience, both as a senior in-house lawyer, as a general counsel for large Brazilian companies, for banks, and what kindly piggyback a little bit on what Bruno was saying about the differences between the practice of arbitration in Brazil and in the US. And first, I want to speak to those very, very resilient speakers and the very, very resilient students that are still here and after such a long day. Practicing being an arbitrator or practicing arbitration in Brazil provides a tremendous opportunity. We just heard that we are a country with 80 million cases. I dare to say that I don't think there's any other country out there that has 80 million cases. Second, that means we have a judiciary that is by definition full cases clogged, has a number of issues about delivery of decisions or being deficient, which provides alternative dispute resolution with a real potential to grow. And that's why we have seen, Celso was mentioning about, 25 years of the law has been in place. That is true, but the law has really been tested and the cases have really been developing over only 10 or 15 years. And over that period, we saw an immense growth or private commercial arbitration in Brazil to an extent where a number of the international chambers are now placed in Brazil. So that is a merit to the system and how well the system works. Surely there are a lot of issues with the system. I'll come back to Novo Mercado and New Market in a second. But if being purely practical and looking at the efficiency of the system has worked fairly well for the purposes of what he has intended to develop. So as a student, having the opportunity to be here and learn about another system and bringing that back to Brazil, and as a professional opportunity, arbitration is a great market for you to be in. I think it's a tremendous opportunity for you to be here, learning and going back to practice. Second reason why I think Brazil provides such an amazing opportunity for arbitration practitioners, it's the flip side of what Celso was saying, and along the same, in a way, the flip side of what Bruno was saying. Right or wrong, good or bad, we have companies that have contractually agreed to, in order to be listed in the premium segment of the stock exchange in Brazil, to have compulsory arbitration provisions. That means that the key capital market issues, corporate law issues, security law issues for those listed companies are going to be decided by arbitration. Now, we can debate whether that's good or bad. We can debate the origins about that. I would tend to agree there's a lot of problems with that, but that's the reality we have. But that also means for those that are practicing arbitration, that is a tremendous field and a tremendous opportunity. There's not a lot of countries out there where you're going to have your largest M&A transactions decided by arbitration. and appointed an appointed arbitrator between two private counterparties without an opportunity for review. Last but not least, there are a number of different countries, including in the US, where you can have government against or government and a private counterparty go to arbitration. But I don't know a lot of countries where the space or the size of the government is as big as it is in Brazil vis-a-vis private counterparties. So the ability that a private counterparty has to go to a regulatory agency or to TCU and resolve a matter via arbitration has a tremendous practical impact for companies and individuals in general. With that being said, I want to close my comments on the benefit of not getting beaten by my colleague here and making sure he makes it to the airport. Thank you very much. Thank you all.
Fernando, although you betrayed my trust, that's fine. And as I promised Sophia that we would finish until 7:30, I think we're on time. So thank you so much, everyone. We're done here, Professor.
Well, I guess I'm really the last speaker before we go. So I want to thank this panel. You were terrific. Gustavo, fabulous job. Anne-Marie Whitesell, my colleague, I am now going to tell everyone she's a constitutional lawyer. This is amazing. It was a really interesting day. We've heard, I think, 7 panels today. It's really quite remarkable, maybe 6, quite remarkable. We've had wonderful variety, very incisive sort of analysis that has been made. This was very engaging as a panel. You were also on time, and I thank you for that. With that, we are going, is it next door, Sophia? Next door, right. And we're going to hear music, and we're going to have drinks, and we're going to convene here tomorrow for the last 2 panels at what time? 9, okay, it must be 9. So we hope to see you all here at 9 o'clock. Thank you very much.
I'm not
You are
I had to help please.
Just a second. Murilo, would you like to come? Okay.
Come on to the panel.
I always try, right?
Bruno, prazerzão. It's good to see you again. So I hope we can catch up one of these times here.
Have a good chat.
Thank you very much. Things are a little bit nervous. You held up really well. Thank you very much.
E vem tamo junto, hein? Deixa de sinal, hein?
And I can tell by his remarks that he's a rich person. Yes. All the remaining For those of us who have bad backs now, yes, I appreciate You have my name. Thank you very much again.
Deu tempo, tá vendo? Eu te mando, eu mandei foto.
So we need to plan to fix the time next year. Right, I saw that, right. That helps. You get them to release one day before they go.
Pois eu não sabia que agora você já ficou.
There's a lot of very good things on the bill, and we should be talking more about that. Things.
I never, I published 3 years ago.
That's great.
Eu acho que sim. Provavelmente da experiência deles.
So maybe you should share that with me if you can, because then I'll know all the good things.
I will update. I was today.
Você falou que vai ficar boa.
I will update this book
I love your sentence. Like, we don't give trouble to anyone. You should take
No,
Brazil.
is a very generous country because we don't cause problems to anyone. We are not like Venezuela.
Never had internal civil wars, religious
You
wars.
could have taken
I
Argentina.
don't even think you've had a cyber war. Although that could generate a war, but that's a different topic. It has a potential
You
to.
just destroyed Caracas.
Brazil is something 90% of our time to create problems for us. That's our.
He's convinced that Brazil I've been doing this for 2 years. He's convinced, you know?
I am convinced.
He needs the
Let's
statistics
do a team building in Brazil. In Brazil.
The problem is hard to send all this money down there. Your part would make this so rich, right? I mean.
I am going to present Lucas to
Foi bom? Legal, não? Foi legal, né? Vamos ver se o que você tá agora. O pessoal falou exatamente, né? Eu obrigado Registrado. Registrar a foto aí.
Se puder ir só um pouquinho mais para trás, perfeito. Obrigada. Tá ótimo. Obrigada. Eu vou mandar todas aí. Todas as fotografias, não sei como eles vão disponibilizar as fotos da vez. Então, a Karen lógico.
Legal.
É melhor fechar, né? Isso. Bom. Ótimo.
Não sei se seria melhor ficar sem o... Você pode usar...
Pode usar para outras coisas,
né? Pode...
Claro.
Abusar.
Óbvio, gente. Estou aqui para isso.
Não.
Maravilhoso. Imagina. Mariana.
Obrigada, Mariana.
Tá. Ótimo.
Ficaram ruins, não, né?
This is good. They're trying to pay me off now.
A lot of caipirinhas. Yes. Also, they gave a good idea if you want to take off to use like LinkedIn or anything.
Yeah. Yes.
They gave this idea, and I was like, okay, that's a good one. Perfect.
Thank you so much.
Fala português, eu falo inglês com você.
Olhando. Mas só pega essa cadeira. Senta aqui do meu lado. Fica olhando pra mim, tá? A gente vai segurar um salão aí, Fernando Medina. Vou tentar botar aqui na coisa. Tá resolvido. Entendeu? Vai dar falta você. Esse debate de vocês. O debate do FICO, cadê vocês? Participação importante na George Brown.
Ué, eu não tô esquecendo.
Acho que é casal que investe, sei lá, que malha junto, emagrece junto, tem tudo.
Gasta junto. Em pé, não?